The House will come to order. Today, the Pledge of Allegiance will be led by Representative Lukens and Representative Weinberg.
Please join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Schiebel, please call the roll.
Representatives Amabile, Armagast, Bacon, Byrd, Bockenfeld, Basenecker, Bottoms, Bradfield, Bradley, Brown, Representative Brown,
Excused.
Catlin, Doherty, DeGraff, Degree Kennedy, Dixon, Duran, English, Representative Epps is excused. Evans, Frizzell, oh, Epps is here, okay. Froelich, Garcia, Gonzalez Gutierrez, Hamrick, Hartsook, Herod,
Here.
Holtorf, Judah, Joseph, Kip, Leader, Lindsay, Linstead, Luck, Lukens, Lynch, Mabry, Marshall, Martinez, Morrow, Representative Morrow,
Excused.
McCormick, McLaughlin, Rep. McLaughlin,
Excused.
Michelson Janae, Ortiz,
Here.
Parenti, Puglisi, Ricks, Sharbini, Sirota, Snyder, Soper, Story, Taggart, Titone, Valdez is excused. Velasco, Vigil, Weinberg, Weissman, Rep. Wilford is excused. Wilson, Winter, Woodrow is excused. Young, Rep. Young,
Excused. Oh,
and Madam Speaker.
with 60 present, 5 excused, we do have a quorum. Representative Parenti.
Thank you, Madam Speaker. Colleagues, we have a lot of important work ahead of us today, so I'm going to just move right through the reading of the journal this morning, but I do encourage you all to be present for the reading of the journal throughout the rest of the week. It will be to your benefit, I promise. Madam Speaker, I move that the journal of Saturday, March 25th, 2023 be approved as corrected by the Chief Clerk.
Members, you've heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. Aye. All those opposed, no. The motion is adopted. Announcements and introductions. Representative Bottoms.
Thank you, Madam Speaker. I'd like to request a moment of personal privilege.
Granted.
I am taking this moment to discuss this evoking of Rule 14. This is an aggressive, immoral attack on the rights and freedoms of all citizens of Colorado, Democrat and Republicans. This is extremely disappointing, but this is what liberalism is. This is how liberalism deals with opposition. This is how liberal leadership handles conflict. This is fascism in every sense of the word. Webster's dictionary of the word fascism: political philosophy, movement, or regime that exalts nation and often race, which we see done often here, above the individual, and that stands for a centralized autocratic government headed by a dictatorial leader. Severe economic and social regimentation, that's what we see every day in this chamber. And forcible suppression of opposition. That's what Rule 14 is accomplishing. Let me read this again. Forcible suppression of opposition. You don't like what you hear, so you shut down the debate and the discussion. Every single part of this definition is being realized right now, today, on this floor, by this craziness of using Rule 14 completely out of context and out of the reason that it was designed and developed. All the majority party had to do was sit and listen. Didn't have to say anything, didn't have to agree, didn't have to do anything. All the majority party had to do was sit and listen until the minority party, a very small minority, ran out of steam. That's all the majority party has to do. You're still going to get your bills. You're still going to get every single thing done that you want done because you're the supermajority. All you had to do was listen. You had to listen to our Republican issues. Things like God being in control of life, murdering babies, Second Amendment freedoms, liberty, economic equality, pursuit of happiness, not killing drug addicts, not attacking people because their skin color isn't the same as yours, not attacking people because they have a moral compass and direction. All you had to do was sit and listen. But you can't do that. Because listening to God, truth, righteousness, and freedom actually hurts the souls of those who are not in favor of those mentalities. It doesn't hurt their ears, it hurts their souls. Acts chapter 7, verse 52 through 58. They even killed the ones who predicted the coming of the righteous one, the Messiah whom you betrayed and murdered. You deliberately disobeyed God's laws, even though you received it from the hands of angels. The Jewish leaders were infuriated by Stephen's accusations, and they shook their fist at him in rage. He was on trial, by the way. He had already had his rights taken away. But Stephen, full of the Holy Spirit, gazed steadily into heaven and saw the glory of God. And he saw Jesus standing in place of honor at God's right hand. And he told them, "Look, I see the heavens open and the Son of Man standing in the place of honor at God's right hand." Then they put their hands over their ears and began shouting so they couldn't hear. They rushed at him and they dragged him out of the city to stone him. This is what happens when liberals don't like to hear truth.
Representative Bottoms.
This is what, yes, ma'am.
You have 30 seconds remaining.
Thank you. This is what Rule 14 is. We are seeing today's Democrat Party covering their ears and attacking truth and light and morality. Ephesians 5 says, "Carefully determine what pleases the Lord. Take no part in the worthless deeds of evil and darkness. Instead, expose them." And that's what we've been doing, and that's what I will continue to do. It is shameful even to talk about the things that ungodly people do in secret.
Representative Bottoms, your time has expired.
Thank you.
The House will stand in a brief recess. The House will come back to order. Representative DeGraff.
Thank you, Madam Speaker. I would like to request a moment of personal privilege.
So granted.
Thank you, Madam Speaker. We've had a lot of battles, we've had a lot of debates, and that's good. When iron sharpens iron, sparks fly. Passionate about this document. Congress, July 4, 1776, the unanimous declaration of the 13 United States, and I'm passionate about this document because it brought together the United States of America. It established the bounds within which we live in liberty and outside of which we will experience tyranny. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with one another, to assume among the powers of earth the separate and equal station of which the laws of nature and nature's God entitle them. And the laws of nature and nature's God is the idea that the moral law, that the physical law is the natural law is the physical manifestation of the moral law, which the laws of nature and nature's God entitle them. A decent respect to the opinions of mankind requires them that they should declare the causes which impel them to separation. And these are the values that allowed a nascent backwater to stand up against the greatest empires in the world. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it and institute a new government, laying its foundations on such principles, the previous principles, and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Happiness is not frivolity, but seeking the best good for yourself and your own individual sovereignty. Prudence indeed will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind is more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms which they are accustomed. But when by a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under the absolute despotism, it is their right, it is their duty to throw off such a government and provide new guards for the future security. Such has been the patient sufferance of these colonies, and such now is the necessity which constrains them to alter the former system of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having direct object at the establishment of absolute tyranny over the United States. To prove this, let the facts be submitted to a candid world. He has refused to assent to laws, the most capital L, the laws of nature and nature's God, wholesome and necessary for the public good. He has forbidden his governors to pass laws, the laws of nature and nature's God, again, of immediate and pressing importance, unless suspended in their operation until his assent should be obtained. And when suspended, he has utterly neglected to attend to them. He has refused to pass other laws in accordance with the laws of nature and nature's God for the accommodation of large districts of people, unless those people should relinquish their right to representation in their legislature. He has called together legislative bodies at places unusual and uncomfortable. He has dissolved the representative houses repeatedly. He has refused for a long time, after such dissolutions, to cause others to be elected. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary. He has made judges dependent on his will alone for the tenure of their offices. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat their substance. He has kept among us in times of peace standing armies. That would be probably the equivalent of the alphabet soup. He has affected to render the military independent and civil power. Ladies and gentlemen, I just wanted to read that. We have a lot of disagreements, but this is the document that brought us out of being a nascent backwater. We're approaching 250 years.
Representative DeGraff, you have 30 seconds
Thank you, Madam Speaker. These are the values that brought us forward. These are the values, these are the bounds within which great studied men and leaders of this country determined and found from the study of history that we can live inside of liberty and individual sovereignty, and outside of which there is tyranny. And that is why we fight for these values. Thank you.
Thank you, Representative. Madam Majority Leader.
Thank you, Madam Speaker. I move to proceed out of order for third reading of bills.
Seeing no objection, we will proceed out of order for the third reading of bills. Madam Majority Leader.
Madam Speaker, I move to proceed out of order for immediate consideration of Senate Bill 170.
Seeing no objection, we will proceed out of order for the consideration of Senate Bill 170. Mr. Schiebel, please read the title to Senate Bill 170.
Senate Bill 170 by Senators Sullivan and Fenberg, also Representatives Bacon and Weissman, concerning extreme risk protection orders and in connection therewith making an appropriation.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 170 on third reading and final passage.
The motion before us is the adoption. Representative Bottoms.
Thank you, Madam Speaker. I'd like to make a motion to read this bill in its entirety.
The motion before us is to read the bill at length. That is a proper motion.
First Regular Session 74th General Assembly State of Colorado, revised this version, includes all amendments adopted on second reading in the Second House LLSNO. 23 to 511.02 Michael Dorr X 4347 Senate Bill 23 to 170. Senate Committees House Committees State, Veterans, and Military Affairs Judiciary Appropriations. A bill for an act. 101 concerning extreme risk protection orders and in 102 connection therewith, making an appropriation. Bill summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the reengrossed version of this bill will be available at http://leg.colorado.gov. The bill repeals and reenacts the statutory article related to extreme risk protection orders. Under current law, a family or household member and a law enforcement officer or agency can petition for an extreme risk protection order. The bill expands the list of who can petition for an extreme risk protection order to include licensed medical care providers, licensed. House amended second reading March 25, 2023. Senate third reading unamended March 13, 2023. Senate amended second reading March 10, 2023. Senate sponsorship Sullivan and Fenberg, Fields, Jaquez Lewis, Coker, Bridges, Buckner, Coleman, Cutter, Danielson, Exum, Ginal, Gonzalez, Hansen, Marchman, Moreno, Mullica, Rodriguez, Winter F., Zenzinger. House sponsorship Bacon and Weissman, Bosnecker, Duran, Froelich, Garcia, Joday, Joseph, Kipp, Parenti, Vigil, Woodrow. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing law. Dashes through the words or numbers indicate deletions from existing law. Mental health care providers, licensed educators, and district attorneys. The bill requires the Office of Gun Violence Prevention to expend funds annually on a public education campaign regarding the availability of, and the process for requesting, an extreme risk protection order. 1. Be it enacted by the General Assembly of the State of Colorado, 2 Section 1. In Colorado Revised Statutes, repeal and reenact, 3 with amendments, Article 14.5 of Title 13 as follows, for 13-14.5-101. Short title. The short title of this Article 14.55 is the Deputy Zachary Parish 3 Violence Prevention Act. 613-14.5-102. Definitions. As used in this Article 14.5, unless 7 the context otherwise clearly requires. 8. 1. Community member means a licensed health, care 9 professional, or mental health professional who, through a 10 direct professional relationship, provided care to the 11 respondent or the respondent's child within 6 months before 12 requesting the protection order, or an educator who, through 13 a direct professional relationship, interacted with the 14 respondent or the respondent's child within 6. months before 15 requesting the protection order. 16. 2. Educator means a teacher employed to instruct. 17. Students or a school administrator in a school district private. 18. School, charter school institute, or an individual charter 19 school, or a faculty member at an institution of higher 20 education. 21. 3. Extreme risk protection order means either a 22 temporary order or a continuing order granted pursuant to this 23 Article 14.5. 2. 170. 1. 4. Faculty member means a president, dean, professor, 2. Administrator, instructor, or research worker at an institution 3 of higher education. 4. 5. Family or household member means, with respect to 5. A respondent, any. 6. A. Person related by blood, marriage, or adoption to the 7 respondent. 8. B. Person who has a child in common with the respondent. 9. Regardless of whether such person has been married to the 10 respondent or has lived together with the respondent at any 11 time. 12. C. Person who regularly resides or regularly resided 13 with the respondent within the last 6 months. 14. D. Domestic partner of the respondent. 15. E. Person who has a biological or legal parent-child 16 relationship with the respondent, including step-parents and 17 stepchildren and grandparents and grandchildren. 18. F. Person who is acting or has acted as the respondent's 19 legal guardian. And 20. G. Person in any other relationship described in section 2118-6-800.3.2 with the respondent. 22. 6. Firearm has the same meaning as in section 18-1-90123.3h. 24. 7. Law enforcement officer means a peace officer that 25 is. 26. A. Employed by a political subdivision of the state, and 27. Certified by the P.O.S.T. Board pursuant to section 16-2.5-102. 3. 170. 1b. Authorized by section 16-2.5-113, when assistance is-2 requested by an individual or entity pursuant to section 324-33.5-412, for a c. Authorized by section 16-2.5-114, and who interacted 5 with the respondent in the scope of the law enforcement 6 officer's official duties. 7d. Employed by a district attorney, designated by a 8 district attorney, and authorized by section 16-2.5-132 or 916-2.5-133. 10. E. Employed by the Department of Law, designated by the 11 Attorney General, and authorized by section 16-2.5-128, 1216-2.5-129, or 16-2.5-130. 13. F. Authorized by section 16-2.5-136, 16-2.5-137, or 1416-2.5-138. 15. G. Authorized by section 16-2.5-120, or 16. H. Authorized by section 16-2.5-149. 17. 8. Licensed healthcare professional means a school 18 nurse who holds a current nursing license through the 19 Department of Regulatory Agencies, and who has applied for or 20 holds a special services license from the Department of 21. Education pursuant to Article 60.5 of Title 22, or a physician. 22. Physician assistant, or advanced practice registered nurse who 23 is a primary provider of health services to a respondent. A 24. Psychiatrist, or a licensed emergency room medical care 25 provider, license pursuant to Title 12. 26. 9. Mental health professional means a psychologist. 27. Licensed professional social worker, marriage and family. 4. 170. 1. Therapist, licensed professional counselor, or addiction to counselor licensed, registered, or certified pursuant to Article 3-245 of Title 12, a psychologist candidate, clinical social worker for candidate, marriage and family therapist candidate, license 5 professional counselor candidate, or addiction counselor 6 candidate registered pursuant to Section 12-245-3043, 712-245-4044, 12-245-5044, 12-245-6044, or 12-245-8043.7, 8 respectively, a school counselor who holds a Special Services 9 provider license with a school counselor endorsement issued 10 pursuant to Article 60.5 of Title 22, or who is otherwise endorsed 11, or accredited by a national association to provide school 12 counseling services. School psychologist license pursuant to 13 Section 22-60.5-210. School social worker who has obtained the 14 Special Services license with social work endorsement issued 15 pursuant to Article 60.5 of Title 22, or an unlicensed 16. Psychotherapist registered pursuant to Section 12-245-703. 17. 10. Petitioner means the person who petitions for an 18 extreme risk protection order pursuant to this Article 14.5. 19. 11. Respondent means the person who is identified as the 20 respondent in a petition filed pursuant to this Article 14.5. 21. 13-14.5-103. Temporary extreme risk protection orders 22, 1A, a family or household member of the respondent, a 23 community member, or a law enforcement officer or agency may 24th request a temporary extreme risk protection order without 25 notice to the respondent by including in the petition for the 26 extreme risk protection order an affidavit, signed under OATH 27 and penalty of perjury, supporting the issuance of a temporary. 5, 170. One extreme risk protection order that sets forth the facts tending to establish the grounds of the petition organ the reason for 3 believing they exist, and, if the petitioner is a family or for household member or community member, attesting that the 5 petitioner is a family or household member or community 6 member. The petition must comply with the requirements of 7 Section 13-14.5-1043. If the petitioner is a law enforcement 8 officer or law enforcement agency, the law enforcement officer 9 or law enforcement agency shall concurrently file a sworn 10 affidavit for a search warrant pursuant to Section 16-3-301.5 to 11 search for any firearms in the possession or control of the 12 respondent at a location or locations to be named in the 13 warrant. If a petition filed pursuant to Section 27-65-106 is also 14 filed against the respondent, a court of competent jurisdiction may 15th hear that petition at the same time as the hearing for a 16 temporary extreme risk protection order or the hearing for a 17 continuing extreme risk protection order. 18, b, notwithstanding any provision of law to the 19 contrary, a licensed healthcare professional or mental health 20 professional authorized TO file a petition for a temporary 21 extreme risk protection order. Upon filing the petition for a 22 temporary extreme risk protection order, IS authorized TO 23 disclose protected health information of the respondent as 20 for necessary for the full investigation and disposition of the 25 request for a temporary extreme risk protection order. When 26 disclosing protected health information, the licensed 27 healthcare professional or mental health professional shall 6, 170. 1. Make reasonable efforts to limit protected health information to the minimum necessary to accomplish the filing of the 3 petition. Upon receipt of a petition by a licensed healthcare for professional or mental health professional, and for good cause 5 shown, the court may issue orders to obtain any records or 6 documents relating to diagnosis, prognosis, or treatment, and 7 clinical records of the respondent as necessary for the full 8 investigation and disposition of the petition for a temporary 9 extreme risk protection order. When protected health 10 information is disclosed or when the court receives any records 11 or documents related to diagnosis, prognosis, or treatment or 12 clinical records, the court shall order that the parties are 13 prohibited from using or disclosing the protected health 14 information for any purpose other than the proceedings for a 15 petition for a temporary extreme risk protection order and 16 shall order the return to the covered entity or destroy the 17 protected health information, including all copies made at the 18 end of the litigation or proceeding. The court shall seal all 19 records and other health information received that contain 20 protected health information. The decision of a licensed 21 healthcare professional or mental health professional to 22 disclose or not to disclose records or documents relating to the 23 diagnosis, prognosis, or treatment and clinical records of a 24 respondent, when made reasonably and in good faith, shall not 25 be the basis for any civil, administrative, or criminal liability 26 with respect to the licensed healthcare professional or 27 licensed mental health professional. 7, 170. 1C. Venue for filing a petition pursuant to this Section 2 if the petitioner is a family or household member is proper in any 3 county where the acts that are the subject of the petition for occur, in any county where one of the parties resides, or in any 5 county where one of the parties is employed. This requirement 6 for venue does not prohibit the change of venue to any other 7 county appropriate under applicable law. 8.2. A petition for an extreme risk protection order by a 9 petitioner who is not a family or household member must file 10 in the county where the respondent resides. 11.2. In considering whether to issue a temporary extreme 12 risk protection order pursuant to this section, the court shall 13 consider all relevant evidence, including the evidence described 14 in Section 13-14.5-105-3. 15.3. If a court finds by a preponderance of the evidence 16 that, based on the evidence presented pursuant to Section 1713-14.5-105-3, the respondent poses a significant risk of causing 18. Personal injury to self or others in the near future by having in 19 the respondent's custody or control a firearm, or by purchasing, 20 possessing, or receiving a firearm, the court shall issue a 21 temporary extreme risk protection order. 22.4. The court shall hold a temporary extreme risk 23 protection order hearing in person, or by telephone on the day 24 the petition is filed, or on the court day immediately following 25 the day the petition is filed. The court may schedule a hearing by 26 telephone pursuant to local court rule to reasonably 27 accommodate a disability or, in exceptional circumstances, 2-8, 170. 1. Protect a petitioner from potential harm. The court shall 2 require assurances of the petitioner's identity before 3 conducting a telephonic hearing. A copy of the telephone for hearing must be provided to the respondent prior to the hearing. 5 for an extreme risk protection order. 6.5a in accordance with Section 13-14.5-105, 1, the Court 7 shall schedule a hearing within 14 days after the 8 issuance of a temporary extreme risk protection order. TO9 determine if a 364-day extreme risk 10 protection order should be issued pursuant to this Article 14.5. 11 notice of that hearing date must be included with the 12 temporary extreme risk protection order that is served on the 13 respondent. The Court shall provide notice of the hearing date 14 to the petitioner. 15b. Any temporary extreme risk protection order issued 16 expires on the date and time of the hearing on the extreme risk. 17. Protection order petition, or the withdrawal of the petition. 18.6. A temporary extreme risk protection order must 19 include 20a. A statement of the grounds asserted for the order. 21b. The date and time the order was issued. 22c. The date and time the order expires. 23d. The address of the court in which any responsive 24 pleading should be filed. 25e. The date and time of the scheduled hearing. 26. F. The requirements for surrender of firearms pursuant 27 to Section 13-14.5-108 and -9, 170. 1g. The following statement, 2 to the subject of this temporary extreme risk 3 protection order. This order is valid until the date for and time noted above. You may not have in your 5 custody or control a firearm or purchase, possess, 6 receive, or attempt to purchase or receive a firearm 7 while this order is in effect. You must immediately 8 surrender to the insert name of law enforcement 9 agency in the jurisdiction where the respondent 10 resides, all firearms in your custody or possession, 11 and any concealed carry permit issued to you. A 12 hearing will be held on the date and at the time 13 noted above to determine if an extreme risk 14 protection order should be issued. Failure to appear 15. At that hearing may result in a court entering an 16 order against you that is valid for 317 days. An attorney will be appointed to 18 represent you, or you may seek the advice of your 19 own attorney at your own expense as to any matter. 20. Connected with this order. 21.7. A law enforcement officer shall serve a temporary 22 extreme risk protection order concurrently with the notice of 23 hearing and petition, and a notice that includes referrals to 24 appropriate resources, including domestic violence, behavioral 25 health, and counseling resources, in the same manner as 26 provided for in Section 13-14.5-105 for service of the notice of 27 hearing where the respondent resides. -10, 170. 18a. If the court issues a temporary extreme risk 2 protection order, the court shall state the particular reasons 3 for the court's issuance. 4b. If the court declines to issue a temporary extreme risk 5 protection order, the court shall state the particular reasons 6 for the court's denial. 713-14.5-104. Petition for extreme risk protection order. 8.1a. A petition for an extreme risk protection order may be 9 filed by a family or household member of the respondent, a 10 community member, or a law enforcement officer or agency. If 11 the petition is filed by a law enforcement officer or agency, a 12 county or city attorney shall represent the officer or agency. 13 in any judicial proceeding upon request. If the petition is filed by 14 a family or household member or community member, the 15 petitioner, to the best of the petitioner's ability, shall notify the 16 law enforcement agency in the jurisdiction where the 17 respondent resides of the petition and the hearing date with 18 enough advance notice to allow for participation, or 19 attendance. Upon the filing of a petition, the court shall appoint 20 an attorney to represent the respondent, and the court shall 21 include the appointment in the notice of hearing provided to the 22 respondent pursuant to Section 13-14.5-105, 1a. The respondent may 23rd replace the attorney with an attorney of the respondent's 24 own selection at any time at the respondent's own expense. The 25 court shall pay the attorney fees for an attorney appointed for 26 the respondent. 27b. Notwithstanding any provision of law to the -11, 170. 1 contrary, a licensed healthcare professional or mental health 2 professional authorized to file a petition for an extreme risk 3 protection order, upon filing the petition for an extreme risk for protection order, is authorized to disclose protected health 5 information of the respondent as necessary for the full 6 investigation and disposition of the petition for an extreme risk 7 protection order. When disclosing protected health 8 information, the licensed healthcare professional or mental 9 health professional shall make reasonable efforts to limit 10 protected health information to the minimum necessary to 11 accomplish the filing of the request. Upon receipt of a petition by 12 a licensed healthcare professional or mental health 13 professional and for good cause shown, the court may issue 14 orders to obtain any records or documents relating to 15 diagnosis, prognosis, or treatment and clinical records of the 16 respondent as necessary for the full investigation and 17 disposition of the petition for an extreme risk protection order. 18. When protected health information is disclosed, or when the 19 court receives any records or documents related to diagnosis, 20 prognosis, or treatment or clinical records, the court shall 21 order that the parties are prohibited from using or disclosing 22 the protected health information for any purpose other than 23 the proceedings for a petition for an extreme risk protection 24 order, and shall order the return to the covered entity, or 25 destroy the protected health information, including all copies 26 made at the end of the litigation or proceeding. The court shall 27 seal all records and other health information received that -12, 170. 1. Contain protected health information. The decision of a licensed 2 healthcare professional or mental health professional to 3 disclose or not to disclose records or documents relating to the 4 diagnosis, prognosis, or treatment and clinical records of a 5 respondent, when made reasonably and in good faith, must not 6 be the basis for any civil, administrative, or criminal liability. 7. With respect to the licensed healthcare professional or mental aid health professional. 9. 2a. Venue for filing a petition pursuant to this section. 10. If the petitioner is a family or household member is proper in any 11 county where the acts that are the subject of the petition. 12. Occur in any county where one of the parties resides, or in any 13 county where one of the parties is employed. This requirement 14 for venue does not prohibit the change of venue to any other 15 county appropriate under applicable law. 16b. A petition for an extreme risk protection order by a 17 petitioner who is not a family or household member must filed 18 in the county where the respondent resides. 19. 3. A petition must 20a. Allege that the respondent poses a significant risk of 21 causing personal injury to self or others by having in the 22 respondent's custody or control a firearm, or by purchasing, 23 possessing, or receiving a firearm, and must be accompanied by an 24 affidavit, signed under oath and penalty of perjury, stating the 25 specific statements, actions, or facts that give rise to a 26 reasonable fear of future dangerous acts by the respondent. 27b. Identify the number, types, and locations of any -13, 170. 1. Firearms the petitioner believes to be in the respondent's current 2 ownership, possession, custody, or control. 3c. Identify whether the respondent is required to possess, for carry, or use a firearm as a condition of the respondent's 5 current employment. 6d. Identify whether there is a known existing domestic 7 abuse protection order or emergency protection order. 8. Governing the petitioner or respondent. 9e. Identify whether there is a pending lawsuit, complaint, 10 petition, or other action between the parties to the petition. And 11f. If the petitioner is not a law enforcement agency. 12. Identify whether the petitioner informed a local law 13 enforcement agency regarding the respondent. 14. 4. The court shall verify the terms of any existing order. 15. Identified pursuant to subsection 3d of this section governing 16 the parties. The court may not delay granting relief because of 17 the existence of a pending action between the parties. A petition 18 for an extreme risk protection order may be granted whether or 19 not there is a pending action between the parties. 25. If the petition states the disclosure of the petitioner's 21 address would risk harm to the petitioner or any member of the 22 petitioner's family or household, the petitioner's address may be 23 omitted from all documents filed with the court. If the 24 petitioner has not disclosed an address pursuant to this section, 25 the petitioner must designate an alternative address, at which 26 the respondent may serve notice of any motions. If the petitioner 27 is a law enforcement officer or agency, the address of record. -14, 170. 1 must be that of the law enforcement agency. 2. 6. A court or public agency shall not charge a fee for 3. Filing or service of process to a petitioner seeking relief for pursuant to this Article 14.5. A petitioner or respondent must be 5. Provided the necessary number of certified copies, forms, and 6. Instructional brochures free of charge. 7. A person is not required to post a bond to obtain relief. 8. In any proceeding pursuant to this section. 9. 8. The district and county courts of the state of 10 Colorado have jurisdiction over proceedings pursuant to this 11 Article 14.5. 1213-14.5-105. Hearings on petition, grounds for order issuance. 13. 1a. Upon filing of the petition, the court shall order a 14 hearing to be held and provide a notice of hearing to the 15 respondent. The court must provide the notice of the hearing number 16 later than 1 court day after the date of the extreme risk 17 protection order petition. The court may schedule a hearing by 18. Telephone pursuant to local court rule to reasonably 19. Accommodate a disability or, in exceptional circumstances, to 20. Protect a petitioner from potential harm. The court shall 21. Require assurances of the petitioner's identity before 22. Conducting a telephonic hearing. 23b. Before the next court day, the court clerk shall 24. Forward a copy of the notice of hearing and petition to the Law 25 enforcement agency in the jurisdiction where the respondent 26 resides for service upon the respondent. 27c. A copy of the notice of hearing and petition must be -15, 170. 1 served upon the respondent in accordance with the rules for 2 service of process as provided in Rule 4 of the Colorado Rules of 3 Civil Procedure or Rule 304 of the Colorado Rules of County for Court Civil Procedure. Service issued pursuant to this Section 5 takes precedence over the service of other documents, unless 6 the other documents are of a similar emergency nature. 7D, the court may, as provided in Section 13-14.5-103, issue 8A temporary extreme risk protection order pending the hearing 9 ordered pursuant to subsection 1A of this section. The 10 temporary extreme risk protection order must be served 11 concurrently with the notice of hearing and petition. 12.2. Upon hearing the matter, if the court finds by clear 13 and convincing evidence, based on the evidence presented 14 pursuant to subsection 3 of this section, that the respondent 15 poses a significant risk of causing personal injury to self or 16 others by having in the respondent's custody or control a 17 firearm or by purchasing, possessing, or receiving a firearm, the 18 court shall issue an extreme risk protection order for a period 19 of 364 days. 23. In determining whether grounds for an extreme risk 21 protection order exist, the court may consider any relevant 22 evidence, including but not limited to any of the following. 23. A recent ACT or credible threat of violence by the 24 respondent against self or others, whether or not such violence 25 or credible threat of violence involves a firearm. 26. B. A pattern of acts or credible threats of violence by 27 the respondent within the past year, including but not limited to. 16. 170. 1 acts or credible threats of violence by the respondent against to self or others. 3. C. A violation by the respondent of a civil protection for order issued pursuant to Article 14 of this Title 13. 5D. A previous or existing extreme risk protection order 6 issued against the respondent and a violation of a previous or 7 existing extreme risk protection order. 8E. A conviction of the respondent for a crime that 9 included, an underlying factual basis of domestic violence AS 10 defined. In Section 18-6-800.3, 1, 11F, the respondent's ownership, access to, or intent to 12 possess a firearm. 13G. A credible threat of or the unlawful or reckless use 14 of a firearm by the respondent. 15H. The history of use, attempted use, or threatened use of 16 unlawful physical force by the respondent against another 17 person, or the respondent's history of stalking another person. 18 as described in Section 18-3-602. 19 I. Any prior arrest of the respondent for a crime listed. 20 IN Section 24-4.1-302, 1, or Section 18-9-202. 21J. Evidence of the respondent's abuse of controlled 22 substances or alcohol. 23K. Whether the respondent is required to possess, carry, 24 or use a firearm as a condition of the respondent's current 25 employment. And 26L. Evidence of recent acquisition of a firearm or 27 ammunition by the respondent. 17. 170. 1-4 The court may, 2A examine under oath the petitioner, the respondent, and 3 any witnesses they may produce, or in lieu of examination, 4 consider sworn affidavits of the petitioner, the respondent, and 5 any witnesses they may produce, and 6B request that the Colorado Bureau of Investigation 7 conduct a criminal history record check related to the 8 respondent, and provide the results to the court under seal. 9-5 The court shall allow the petitioner and respondent 10 to present evidence and cross-examine witnesses, and be 11 represented by an attorney at the hearing. 12.6 In a hearing pursuant to this Article 14.5, the rules of 13 evidence apply to the same extent as in a Civil Protection Order 14 proceeding pursuant to Article 14 of this Title 13. 15.7 During the hearing, the court shall consider any 16 available mental health evaluation or chemical dependency 17 evaluation provided to the court. 18.8a Before issuing an extreme risk protection order, the 19 court shall consider whether the respondent meets the 20 standard for a court-ordered evaluation for persons with 21 mental health disorders pursuant to Section 27-65-106. If the 22 court determines that the respondent meets the standard, then 23I in addition to issuing an extreme risk protection order, the 24 court shall order mental health treatment and evaluation 25 authorized pursuant to Section 27-65-106 4D. 26B Before issuing an extreme risk protection order, the 27 court shall consider whether the respondent meets the 18, 170. 1 standard for an emergency commitment pursuant to Section 227-81-111. If the court determines that the respondent meets the 3 standard, then, in addition to issuing an extreme risk protection for order, the court shall order an emergency commitment 5 pursuant to Section 27-81-111. 6.9 An extreme risk protection order must include 7a a statement of the grounds supporting the issuance of 8 the order, 9b the date and time the order was issued, 10c the date and time the order expires, 11d the address of the court in which any responsive 12 pleading should be filed, 13e the requirements for relinquishment of a firearm, and 14 concealed carry permit pursuant to Section 13-14.5-108, and 15 f the following statement, 16 to the subject of this extreme Risk Protection 17 order. This order will last until the date and time 18 noted above. If you have not done so already, you 19 must immediately surrender any firearms in your 20 custody, control, or possession and any concealed 21 carry permit issued to you. You may not have in 22 your custody or control a firearm or purchase, 23 possess, receive, or attempt to purchase or receive 24 a firearm while this order is in effect. You have the 25 right to request one hearing to terminate this 26 order during the period that this order is in effect, 27 starting from the date of this order and continuing. Dash 19, 170. 1 through any renewals. You may seek the advice of an attorney as to any matter connected with this 3 order. 4 or 10, when the court issues an extreme risk protection 5 order, the court shall inform the respondent that the 6th respondent is entitled to request termination of the order in the 7 manner prescribed by section 13-14.5-107. The court shall 8 provide the respondent with a form to request a termination 9 hearing. 10, 11a, if the court issues an extreme risk protection 11 order, the court shall state the particular reasons for the 12 court's issuance. 13b, if the court denies the issuance of an extreme risk 14 protection order, the court shall state the particular reasons 15 for the court's denial. 16, 12, if the court denies the issuance of an extreme risk 17 protection order but ordered a temporary extreme risk 18 protection order, and a law enforcement agency took custody 19 of the respondent's concealed carry permit, or the respondent 20 surrendered the respondent's concealed carry permit as a 21 result of the temporary extreme risk protection order, the 22 sheriff, who issued the concealed carry permit, shall reissue the 23 concealed carry permit to the respondent within 3 days, at 20 for no charge to the respondent. 25, 13, if the court issues an extreme risk protection order 26, and the petitioner is a law enforcement officer or agency or 27 community member, the petitioner shall make a good faith. Dash 20, 170. One effort to provide notice of the order to a family or household 2 member of the respondent, and to any known third party, who may third be at direct risk of violence. The notice must include 4 referrals to appropriate resources, including domestic violence, 5 behavioral health and counseling resources. 613-14.5-106. Service of Protection Orders. 1. An Extreme 7 Risk Protection Order issued pursuant to Section 13-14.5-105 must 8 be served personally upon the respondent, except as otherwise 9 provided in this Article 14.5. 10. 2. The law enforcement agency in the jurisdiction where 11 the respondent resides shall serve the respondent personally. 12. 3. The court clerk shall forward a copy of the Extreme 13 Risk Protection Order issued pursuant to this Article 14.5 on or 14, before the next court day, to the law enforcement agency 15 specified in the order for service. Service of an order issued 16 pursuant to this Article 14.5 takes precedence over the service. 17 of other documents, unless the other documents are of a similar 18 emergency nature. 19, 4. If the law enforcement agency cannot complete 20 service upon the respondent within 5 days, the Law 21 enforcement agency shall notify the petitioner. The petitioner 22 shall then provide any additional information regarding the 23 respondents' whereabouts to the law enforcement agency to 20 for effect service. The law enforcement agency may request 25 additional time to allow for the proper and safe planning, and 26 execution of the court order. 27, 5. If an extreme risk protection order entered by the Dash 21, 170. 1 court states that the respondent appeared in person before the 2 court, the necessity for further service is waived, and proof of 3 service of that order is not necessary. 4. 6. Returns of service pursuant to this Article 14.5 must 5 be made in accordance with the applicable court rules. 6. 7. If the respondent is a veteran and there are any 7 criminal charges against the respondent that result from the 8th service or enforcement of the extreme risk protection order, the 9 judge shall refer the case to a veterans court if the jurisdiction 10 has a veterans court and the charges are veterans court 11 eligible. 1213-14.5-107. Termination or renewal of protection orders. 13. 1. Termination. A. The respondent may submit 1 written 14 request for a hearing to terminate an extreme risk protection 15 order issued pursuant to this Article 14.5 for the period that the 16 order is in effect. Upon receipt of the request for a hearing to 17. Terminate an extreme risk protection order, the court shall set 18. A date for a hearing. Notice of the request and date of hearing 19. must be served on the petitioner in accordance with the 20 Colorado Rules of Civil Procedure or Colorado Rules of County 21 Court Civil Procedure, that the court shall set the hearing 22 days after the filing of the request for a hearing to terminate 23 an extreme risk protection order. The court shall terminate the 24 extreme risk protection order if the respondent establishes by 25 clear and convincing evidence that the respondent no longer 26 poses a significant risk of causing personal injury to self or 27 others by having in the respondent's custody or control a 22 170 one firearm or by purchasing, possessing, or receiving a firearm. The two court may consider any relevant evidence, including evidence 3 of the considerations listed in section 13-14.5-1053. 4b, the court may continue the hearing if the court 5 determines that it cannot enter a termination order at the 6th hearing but determines that there is a strong possibility that 7 the court could enter a termination order at a future date. 8 before the expiration of the extreme risk protection order. If 9 the court continues the hearing, the court shall set the date 10 for the next hearing prior to the date for the expiration of the 11 extreme risk protection order. 12. 2. Renewal. A. The court shall notify the petitioner of 13 the impending expiration of an extreme risk protection order 1463 calendar days before the date that the order 15 expires. 16. B. A petitioner, a family or household member of a 17 respondent, a community member, or a law enforcement officer. 18. Or agency may, by motion, request a renewal of an extreme risk 19 protection order at any time within 63 calendar days 20 before the expiration of the order. 21. C. Upon receipt of the motion to renew, the court shall 22 order that a hearing be held not later than 14 days after 23 the filing of the motion to renew. The court may schedule a 24 hearing by telephone in the manner prescribed by section 2513-14.5-105(1)(a). The respondent must be personally served IN 26 the same manner prescribed by section 13-14.5-105(1)(b) and 27(1)(c). 23 170. 1d. In determining whether to renew an extreme risk to protection order issued pursuant to this section, the court shall 3 consider all relevant evidence and follow the same procedure for as provided in section 13-14.5-105. 5e. If the court finds by clear and convincing evidence 6 that, based on the evidence presented pursuant to section 713-14.5-105, 3, the respondent continues to pose a significant 8 risk of causing personal injury to self or others by having in the 9 respondent's custody or control a firearm, or by purchasing, 10 possessing, or receiving a firearm, the court shall renew the 11 order for a period of time the court deems appropriate, not to 12 exceed 1 year. In the order, the court shall set a return date 13 to review the order no later than 35 days prior to the 14 expiration of the order. However, if, after notice, the motion for 15 renewal is uncontested and the petitioner seeks no modification. 16 of the order may be renewed on the basis of the 17 petitioner's motion or affidavit, signed under oath and penalty 18 of perjury, stating that there has been no material change in 19 relevant circumstances since the entry of the order and stating 20 the reason for the requested renewal. 21. 3. If an extreme risk protection order is terminated or 22 not renewed for any reason, the law enforcement agency 23 storing the respondent's firearms shall provide notice to the 24 respondent regarding the process for the return of the 25 firearms. 26. 13-14.5-108. Surrender of a firearm. 1a. Upon issuance of 27 an extreme risk protection order pursuant to this Article 14.5. 24 170. 1. Including a temporary extreme risk protection order, the court too shall order the respondent to surrender all firearms by 3. I. Selling or transferring possession of the firearm to a for federally licensed firearms dealer described in 18 U.S.C. SEC 5923, as amended, except that this provision must not be 6 interpreted to require any federally licensed firearms dealer 7 to purchase or accept possession of any firearm. 8. 2. Arranging for the storage of the firearm by a law 9 enforcement agency. The law enforcement agency shall 10 preserve the firearm in a substantially similar condition that 11 the firearm was in when it was surrendered. If the respondent 12 does not choose the option in subsection 1a I of this section, 13 a local law enforcement agency shall store the firearm. 14. 3. Only for either an antique firearm, as defined in 1815 U.S.C. Sector 921, a 16, as amended, or a curio or relic as defined. 16 and 27 CFR 478.11, as amended, transferring possession of the 17 antique firearm or curio or relic to a relative who does not live 18 with the respondent after confirming, through a criminal 19 history record check, the relative is currently eligible to own 20 or possess a firearm under federal and state law. 21b. The court shall order the respondent to surrender 22 any concealed carry permit to the law enforcement officer 23 serving the extreme risk protection order. 24. 2. A. the law enforcement agency serving any extreme 25 risk protection order pursuant to this Article 14.5, including a 26 temporary extreme risk protection order in which the petitioner 27 was not a law enforcement agency or officer, shall request. Dash 25, 170. 1. That the respondent immediately surrender all firearms in the two respondents' custody, control, or possession and any concealed 3 carry permit issued to the respondent and conduct any search for permitted by law for such firearms or permit. After the law 5 enforcement agency or officer has custody of the firearms, the 6 respondent may inform the law enforcement officer of the 7 respondents' preference for sale, transfer, or storage of the 8 firearms as specified in subsection 1 of this section. If the 9 respondent elects to sell or transfer the firearms to a 10 federally licensed firearms dealer described in 18 U.S.C. SEC 11923, as amended, the law enforcement officer or agency shall 12 maintain custody of the firearms until they are sold or 13 transferred pursuant to subsection 1 I of this section. The 14 law enforcement officer shall take possession of all firearms 15, and any such permit belonging to the respondent that are 16 surrendered in plain sight or discovered pursuant to a lawful 17 search. Alternatively, if personal service by the law 18 enforcement agency is not possible, or not required because the 19 respondent was present at the Extreme Risk Protection Order 20 hearing, the respondent shall surrender the firearms and any 21 concealed carry permit within 24 hours after being 22 served with the order by alternate service, or within 24 hours after the hearing at which the respondent 24 was present. 25b. If the petitioner for an Extreme Risk Protection Order 26 is a law enforcement agency or officer, the law enforcement 27 officer serving the Extreme Risk Protection Order shall take. Dash 26, 170. 1. Custody of the respondent's firearms pursuant to the Search 2 warrant for firearms possessed by a respondent in an Extreme 3 Risk Protection Order, as described in Section 16-3-301.5, if a for warrant was obtained. After the law enforcement agency or 5 officer has custody of the firearms, the respondent may inform 6 the law enforcement officer of the respondent's preference for 7 sale, transfer, or storage of the firearms as specified in Section 813-14-105.54. The law enforcement officer shall request that 9. The respondent immediately surrender any concealed carry 10 permit issued to the respondent and conduct any search 11 permitted by law for the permit. 12.3. At the time of surrender or taking custody pursuant 13 to Section 16-3-301.5, a law enforcement officer taking 14 possession of a firearm or a concealed carry permit shall issue 15 a receipt identifying all firearms and any permit that have been 16 surrendered or taken custody of and provide a copy of the 17 receipt to the respondent within 72 hours after 18 service of the order. The officer serving the order shall file the 19 original receipt with the court and shall ensure that the 20 officer's law enforcement agency retains a copy of the receipt. 21. Or, if the officer did not take custody of any firearms, shall file 22 a statement to that effect with the court. 23. 4. Upon the sworn statement or testimony of the 24 petitioner, or of any law enforcement officer alleging that 25, there is probable cause to believe the respondent has failed to 26 comply with the surrender of firearms, or a concealed carry 27 permit as required by an order issued pursuant to this article. Dash 27, 170. 114.5. The court shall determine whether probable cause exists to believe that the respondent has failed to surrender all firearms 3, or a concealed carry permit in his or her custody, the 4 respondents' control, or possession. If probable cause exists, the 5 court shall issue a search warrant that states with 6 particularity the places to be searched and the items to be 7 taken into custody. 8.5. If a person other than the respondent claims Title T09 any firearms surrendered or taken custody of pursuant to 10 Section 16-3-301.5 pursuant to this section, and the Law 11 enforcement agency determines that he or she is the lawful 12 owner of the firearm shall be returned to him or 13 her if 14a. The firearm is removed from the respondent's custody, 15 control, or possession, and the lawful owner agrees to store 16 the firearm so that the respondent does not have access to or 17 control of the firearm, and 18b. The firearm is not otherwise unlawfully possessed by 19. The lawful owner. 26a. Within 48 hours after the issuance of an 21 Extreme Risk Protection Order, a respondent subject to the 22 order may either 23. I file with the court that issued the order 1 or more 24 proofs of relinquishment or removal showing that all firearms 25 previously in the respondent's custody, control, or possession, 26 and any concealed carry permit issued to the respondent, were 27 relinquished to or removed by a law enforcement agency, and Dash 28, 170. 1. Attest to the court that the respondent does not currently have any firearms in the respondent's custody, control, or 3 possession, and does not currently have a concealed carry 4 permit, or 5. 2. Attest to the court that 6a. At the time the order was issued, the respondent did 7 not have any firearms in the respondent's custody, control, or 8 possession and did not have a concealed carry permit, and 9. b. The respondent does not currently have any firearms 10 in the respondent's custody, control, or possession, and does not 11 currently have a concealed carry permit. 12b, if 2 full court days have elapsed since the issuance 13 of an extreme risk protection order and the respondent has 14 made neither the filing and attestation pursuant to subsection 15, 6, a, I of this section nor the attestations pursuant to 16 subsection 6, a, 2 of this section, the clerk of the court for 17 the court that issued the order shall inform the local law 18 enforcement agency in the county in which the court is located. 19 that the respondent has not filed the filing and attestation 20 pursuant to subsection 6, a, I of this section, or the 21 attestations pursuant to subsection 6, a, 2 of this section. 22, c, a local law enforcement agency that receives a 23 notification pursuant to subsection 6, b, of this section shall 24 make a good faith effort to determine whether there is evidence 25 that the respondent has failed to relinquish any firearm in the 26 respondent's custody, control, or possession or a concealed 27 carry permit issued to the respondent. 29, 170. 17. The Peace Officers Standards and Training Board shall 2 develop model policies and procedures by December 1, 2019. 3 regarding the acceptance, storage, and return of firearms for required to be surrendered pursuant to this Article 14.5, or 5 taken custody of pursuant to Section 16-3-301.5, and shall 6 provide those model policies and procedures to all Law 7 enforcement agencies. Each law enforcement agency shall 8 adopt the model policies and procedures, or adopt their own 9 policies and procedures by January 1, 2020. 1013-14.5-109. Firearms, return, disposal. 1. If an Extreme 11 Risk Protection Order or temporary Extreme Risk Protection 12 order is terminated or expires without renewal, a Law 13 enforcement agency holding any firearm that has been 14 surrendered pursuant to Section 13-14.5-108 or taken custody of 15 pursuant to Section 16-3-301.5, or a federally licensed firearms 16 dealer described in 18 U.S.C. SEC 923, as amended, with custody. 17 of a firearm, or a relative with custody of an antique firearm or 18 curio or relic pursuant to Section 13-14.5-108, 1. 3. Must 19 return the firearm requested by a respondent within 3 days 20 only after confirming, through a criminal history record check 21 performed pursuant to Section 24-33.5-424, that the respondent 22 is currently eligible to own or possess a firearm under Federal 23 and state law, and after confirming with the court that the 24 Extreme Risk Protection Order has terminated or has expired 25 without renewal. 26. 2. Any firearm surrendered by a respondent pursuant to 27 Section 13-14.5-108 or taken custody of pursuant to Section 30, 170. 116-3-301.5 that remains unclaimed by the lawful owner for at least 1 year from the date the temporary Extreme Risk 3 Protection Order or Extreme Risk Protection Order expired, for whichever is later, shall be disposed of in accordance with the 5 law enforcement agencies' policies and procedures for the 6 disposal of firearms in police custody. 713-14.5-110. Reporting of Extreme Risk Protection Orders. 8.1. The court clerk shall enter any Extreme Risk Protection 9 order or temporary Extreme Risk Protection Order issued 10 pursuant to this Article 14.5 into a statewide Judicial 11 information system on the same day the order is issued. 12.2. The court clerk shall forward a copy of an Extreme 13 Risk Protection Order or temporary Extreme Risk Protection 14 order issued pursuant to this Article 14.5 the same day the Order 15 is issued to the Colorado Bureau of Investigation and the Law 16 enforcement agency specified in the order. Upon receipt of the 17 copy of the order, the Colorado Bureau of Investigation shall 18. Enter the order into the National Instant Criminal Background 19 check system, any other federal or state computer-based 20 systems used by law enforcement agencies or others to identify 21 prohibited purchasers of firearms, and any computer-based 22 criminal intelligence information system available in this state 23 used by law enforcement agencies. The order must remain in 24 each system for the period stated in the order, and the Law 25 enforcement agency shall only expunge orders from the 26 systems that have expired or terminated, and shall promptly 27 remove the expired or terminated orders. Entry into the 31, 170. 1 computer-based criminal intelligence information system is 2 notice to all law enforcement agencies of the existence of the 3 order. The order is fully enforceable in any county in the state. 4.3. The issuing court shall, within 3 court days after 5 issuance of an Extreme Risk Protection Order or a temporary 6 Extreme Risk Protection Order, forward all identifying 7 information the court has regarding the respondent, along with 8 the date the order is issued, to the county sheriff in the 9 jurisdiction where the respondent resides. Upon receipt of the 10 information, the county sheriff shall determine if the 11 respondent has a concealed carry permit. If the respondent does 12 have a concealed carry permit, the issuing county sheriff shall 13 immediately revoke the permit. The respondent may reapply for 14 a concealed carry permit, after the temporary extreme risk 15 protection order and extreme risk protection order, if ordered 16, are no longer in effect. 17, 4, if an extreme risk protection order is terminated. 18, before its expiration date, the court clerk shall forward, on the 19th same day as the termination order, a copy of the Termination 20 order to the Colorado Bureau of Investigation and the 21 appropriate law enforcement agency specified in the Termination 22 order. Upon receipt of the order, the Colorado Bureau of 23 Investigation and the law enforcement agency shall promptly 24 remove the order from any computer-based system in which IT-25 was entered pursuant to subsection 2 of this section. 26, 5, upon the expiration of a temporary extreme risk 27 protection order or extreme risk protection order, the -32, 170. 1 Colorado Bureau of Investigation and the law enforcement 2 agency specified in the order shall promptly remove the order 3 from any computer-based system in which it was entered for pursuant to subsection 2 of this section. 5, 6, an extreme risk protection order does not constitute 6A finding that a respondent is a prohibited person pursuant to 18-7 U.S.C. Sector 922 D4 or G4. This subsection 6 does not alter 8 a temporary extreme risk protection order or an extreme risk 9 protection order, and a respondent subject to a temporary 10 extreme risk protection order or an extreme risk protection 11 order is prohibited from possessing a firearm under state law. 12. This subsection 6 does not change the duty to enter a 13 temporary extreme risk protection order or extreme risk 14 protection order into the appropriate databases pursuant to 15 this section. 1613-14.5-111. Penalties. Any person who has in the persons 17 custody, possession, or control of firearm or purchases. Purchases, 18 possesses, or receives a firearm with knowledge that the person 19 is prohibited from doing so by an extreme risk protection order 20 or temporary extreme risk protection order issued pursuant to 21. This Article 14.5 is guilty of a Class 2 misdemeanor. 2213-14.5-112. Other authority retained. This Article 14.5 does 23 not affect the ability of a law enforcement officer to remove a 24 firearm or concealed carry permit from a person, or conduct a 25 search and seizure for any firearm pursuant to other lawful 26 authority. 2713-14.5-113. Liability. 1. Except as provided in section -33, 170. 113-14.5-111. This Article 14.5 does not impose criminal, 2 administrative, or civil liability on any person, including a 3 community member, or entity for acts or omissions made in good for faith related to obtaining an extreme risk protection order or 5 a temporary extreme risk protection order, including but not 6 limited to reporting, declining to report, investigating, 7 declining to investigate, filing, or declining to file a petition 8 pursuant to this Article 14.5. This Article 14.5 does not impose 9 criminal or civil liability on a peace officer lawfully enforcing 10 an order pursuant to this Article 14.5. 11.2. A person who files a malicious or knowingly false 12 petition for a temporary extreme risk protection order, or in 13 extreme risk protection order may be subject to criminal 14 prosecution or civil liability for those acts. 15.3. A federally licensed firearms dealer, or Law 16 enforcement agency that stores a firearm as permitted by this. 17. Article 14.5 is not civilly liable for any resulting damages to 18. The firearm, as long as such damage did not result from the 19 willful and wrongful act or gross negligence of the person, or 20 law enforcement agency storing the firearm. 21.4. This Article 14.5 does not require a family or 22 household member of the respondent, a community member, or a 23 law enforcement officer or agency to file a petition for a 20 for temporary emergency extreme risk protection order or petition 25 for an extreme risk protection order. 26.5. A community member's employer shall not use a 27 community members' acts or omissions made in good faith related. -34, 170. 1. To obtaining an extreme risk protection order or a temporary 2 extreme risk protection order, including but not limited to 3 reporting, declining to report, investigating, declining to for investigate, filing, or declining to file a petition pursuant to this 5 Article 14.5 as a basis for discipline or termination. 613-14.5-114. Instructional and informational material, 7 definition. 1a. The state court administrator shall develop 8 standard petitions and extreme risk protection order forms and 9 temporary extreme risk protection order forms in more than 110 language consistent with state judicial department practices. 11. The standard petition and order forms must be used after January 12, 2020, for all petitions filed and orders issued. 13. Pursuant to this Article 14.5. The State Court Administrator may 14th consult with interested parties in developing the petitions in 15 forms. The materials must be available online consistent with 16. State Judicial Department practices. 17. B. The extreme risk protection order form must include 18. In a conspicuous location, notice of criminal penalties resulting. 19. From violation of the order, and the following statement. 20. You have the sole responsibility to avoid or refrain. 21. From violating this extreme risk protection order's 22 provisions. Only the court can change the order. 23. And only upon written motion. 24. 2. A court clerk for each judicial district shall create 25. A community resource list of crisis intervention, mental health, 26. Substance abuse, interpreter, counseling, and other relevant. 27. Resources serving the county in which the court is located. The -35, 170. One court shall make the community resource list available as Part 2 of or in addition to the informational brochures described in 3 subsection 1 of this section. 4.3. The State Court Administrator shall distribute a 5 master copy of the standard petition and extreme risk 6 protection order forms to all court clerks and all district and 7 county courts. 8.4. Courts shall accept petitions pursuant to sections 913-14.5-103 and 13-14.5-104 beginning on January 1, 2020. 1013-14.5-115. Effect of previous issued orders. The enactment 11 of SB 23 to 170 and the provisions of this Article 14.5 authorizing 12 the court to enter an order pursuant to Section 13-14.5-103 or 1313-14.5-104 do not limit, change, void, or otherwise impact. And 14. Extreme risk protection order entered by the court pursuant to 15 this Article 14.5 prior to the effective date of SB 23 to 170. Any 16 such order remains in effect until it expires by its own terms or 17 is terminated by the court. 1813-14.5-116. Severability. If any provision of this article 1914.5 or the application thereof to any person or circumstance is 20 held invalid, such invalidity does not affect other provisions or 21 applications of this Article 14.5 that can be given effect without 20 to the invalid provision or application, and to this end the 23 provisions of this Article 14.5 are declared to be severable. 24. Section 2. In Colorado Revised Statutes, add 24-33.5-118, as 25 follows, 26-24-33.5-118. Extreme Risk Protection Order Information 27 Hotline. 1A. The Department shall, subject to available. -36, 170. 1. Resources or within existing resources, establish a hotline to receive and refer calls from the public about extreme risk 3 protection orders, and provide the callers with information about filing for an order and about other relevant resources. 5. The department is not required to establish a dedicated phone 6 number for the hotline, and may instead use an existing phone 7 number used by the department to receive and respond to public 8 requests or inquiries. The hotline shall not provide legal advice 9 or serve as an avenue for an individual to file a petition for a 10 temporary extreme risk protection order or an extreme risk 11 protection order. 12b. The hotline shall not advise a caller on the 13 ramifications concerning the filing or false filing of a petition 14 for a temporary extreme risk protection order or an extreme 15 risk protection order. The hotline may refer a caller to the 16 appropriate venue in which the petition may be filed for further. 17. Information concerning such ramifications. 18.2. The department shall collaborate with any other 19 state agency to obtain the information necessary or beneficial. 20. For responding to the requests. 21. Section 3. In Colorado Revised Statutes, 25-20.5-1205, add 22.3, as follows, 2325-20.5-1205. Federal grants, other funds, gifts, grants, and 20 for donations. 3. The office shall expend funds annually on a public 25 education campaign regarding the availability of, and the 26 process for requesting, an extreme risk protection order 27 pursuant to Article 14.5 of Title 13, and as described in Section 37, 170. 125-20.5-1203, 2a. 2. Section 4. In Colorado Revised Statutes, 13-3-101, repeal and 3 reenact 13, as follows, for 13-3-101. State Court Administrator Report Definitions, 5 repeal. 13. the State Court Administrator, or the 6 administrators designee shall present at the judicial 7 departments hearing pursuant to Section 2-7-203 Statistics 8 related to extreme risk protection orders in Article 14.5 of this 9 Title 13. The statistics must include the number of petitions filed 10 for temporary extreme risk protection orders, the number of 11 petitions filed for extreme risk protection orders, the number of 12 temporary extreme risk protection orders issued and denied, the 13 number of extreme risk protection orders issued and denied, the 14 number of temporary extreme risk protection orders 15 terminated, the number of extreme risk protection orders 16 terminated, and the number of extreme risk protection orders 17 renewed. The State Court Administrator or the administrators. 18 designee shall also report state court data related to all 19 persons who are subject to any temporary emergency risk 20 protection order or emergency risk protection order and who, 21 within 30 days after the issuance or execution of the 22 protection order, are charged with a criminal offense. The 23 report must include the nature of the criminal offense, 24 including, but not limited to any offense for violation of the 25 emergency risk protection order, and the disposition or status of 26 the criminal offense. 27 Section 5. In Colorado Revised Statutes, repeal and reenact. -38, 170. 116-3-301.5 as follows, 216-3-301.5. Search warrant for firearms possessed by a 3 respondent in an extreme risk protection order. 1. Any court may forth issue a search warrant to search for and take custody of any 5 firearm in the possession of a named respondent in an extreme 6 risk protection order or temporary extreme risk protection 7 order filed pursuant to Article 14.5 of Title 13, if the application 8 for the warrant complies with all required provisions of Section 916-3-303 and also provides facts sufficient to established by 10 probable cause, 11a, that the named person is a named respondent in and 12. Extreme Risk Protection Order or Temporary Extreme Risk 13 Protection Order filed pursuant to Article 14.5 of Title 13, and 14b, that the named person is in possession of 1 or more 15 firearms, and 16c, the location of such firearms, and 17d, any other information relied upon by the applicant. 18, and why the applicant considers such information credible, and 19, reliable. 22. The return or disposal of any firearm taken custody 21 of pursuant to this section shall be accomplished pursuant to 22 Section 13-14.5-109. 23 Section 6. In Colorado Revised Statutes, 18-12-203, repeal 24 and reenact 1G4 as follows, 25 18-12-203. Criteria for obtaining a permit. 1. Beginning May 26, 2003, except as set forth in this section, a sheriff shall issue a permit 27 to carry a concealed handgun to an applicant who 39, 170. 1G is not subject to 2, 4, a temporary extreme risk protection order issued 3 pursuant to Section 13-14.5-103, 3, or an extreme risk protection for order issued pursuant to Section 13-14.5-105, 2, 5 Section 7. Appropriation. 1. For the 2023-24 state fiscal 6 year, $140,462 is appropriated to the Judicial Department. This 7 appropriation is from the General Fund. To implement this act, the 8 Department may use this appropriation as follows. 9a, $110,008 for trial court programs, which amount is based on 10 an assumption that the Department will require an additional 1.1 FTE, and 11b, $30,454 for capital outlay. 12.2, for the 2023-24 state fiscal year, $238,846 is appropriated to 13 the Department of Public Safety. This appropriation is from the General 14 Fund and is based on an assumption that the department will require an 15 additional 2.8 FTE. To implement this act, the department may use the 16 appropriation for the Extreme Risk Protection Order Hotline. 17 Section 8. Safety Clause. The General Assembly hereby finds 18 determines and declares that this act is necessary for the immediate 19 preservation of the public peace, health, or safety. 40, 170.
We will stand in a brief recess.
The House will come back to order. Members, we are on third reading of bills. I want to start with a reminder about our rules and decorum and how we speak in the well. We will demonstrate respect to all members. We will recognize that our individual perspectives on policy is valuable to our conversations. We are here to listen and recognize and respect those perspectives. As is listed in our rules on decorum, we will not impugn the motives of others. We will not speak to their intentions. We will honor and respect one another as we move forward in the debate today. I ask for you to engage in authentic debate and appreciate your attention in this moment. Thank you. Madam Majority Leader.
Madam Speaker, I move Senate Bill 170 on third reading and final passage.
Representative Bockenfeld.
Thank you, Madam Speaker. It's an honor to serve with you.
And an honor to serve with you.
Folks, it was quite enlightening to hear the reading of the bill, and I think it's just as important that we understand what the fiscal impact of this bill may be. So if you will bear with me. In regards to Senate Bill 23-170, the revised fiscal note dated March 24th, 2023, using draft number LLS 23-0511, with the prime sponsors of Senator Sullivan and Finberg and Representative Bacon and Weissman in the House. The bill topic is Extreme Risk Protection Order. The summary of the fiscal impact. There's no state revenue impact. There is a state expenditure impact. There's no state transfer. There's no impact on the table refund. But there is a local government impact. And there's no statutory public entity impact. The bill allows community members, educators, licensed healthcare professionals, mental health professionals, and district attorneys to petition for an extreme risk protection order. Starting in fiscal year 2023-24, the bill increases state and local expenditures on an ongoing basis. The appropriation summary. The bill requires and includes an appropriation of $379,308 to various state departments. Fiscal note status. This revised fiscal note reflects the re-engrossed bill as amended by the House Judiciary and Appropriations Committee. Table 1, fiscal impacts under Senate Bill 23-170. Revenue. There's no revenue impact for the budget year, fiscal year of 23-24, and there's no revenue impact for the out year of fiscal year 24-25. Expenditures. From the general fund, for budget year, fiscal year 23-24, there's a $379,308 fiscal impact. In fiscal year 24-25, that fiscal impact expenditure drops to $377,499. Centrally appropriated for fiscal year 23-24, it's $68,466. In the out year of fiscal year 24-25, it's $76,279. That creates a total expenditure for fiscal year 23-24 of $447,774. In the out year of fiscal year 24-25, that amount decreases to $453,778. Total FTE for fiscal year 23-24, 3.9 full-time equivalents. That increases in fiscal year 24-25 to 4.2 full-time equivalents. There's no transfers in fiscal year 23-24. There's no transfers in fiscal year 24-25. Other budget impacts, general fund reserve. In fiscal 23-24, we are going to reserve $56,896. That decreases in fiscal year 24-25, where we reserve only $56,625. Summary of the legislation. The bill repeals and reenacts state law regarding extreme risk protection orders, also known as ERPLs. Under the current law, a family or household member and a law enforcement officer or agency can petition for an ERPL. The bill expands eligible petitioners to community members, educators, licensed healthcare professionals, and mental health professionals. Clarifies which law enforcement officers may petition for an order, to include district attorneys, and clarifies that the venue where petitions may be filed. The bill also requires the Colorado Department of Public Health and Environment, CDPHE, to spend funds on a public education campaign regarding the availability of and the process for requesting an ERPL. Finally, the bill requires the Department of Public Safety, also known as DPS, to establish a hotline to receive and refer calls from the public about ERPLs, to provide callers with relevant resources, and to collaborate with other state agencies to obtain information necessary or beneficial for responding to requests. Background and assumptions. To determine if there would be an increase in ERPL petitions, the fiscal note analyzed 2 states that currently allow medical professionals to petition for an ERPL. Those states are New York and Maryland. In reference to New York, in 2022, the state of New York passed a bill which expanded who can petition for an ERPL to include healthcare professionals and requires law enforcement to file ERPLs in certain situations. According to a news release from the New York Governor's Office on October 22nd, 2022, ERPLs more than doubled after the passage of the law. In reference to Maryland, Maryland also allows healthcare professionals to petition for ERPLs. According to district court data from Maryland, the state saw 573 ERPL cases filed from January 2022 through September 2022, or about 64 cases per month. Maryland data for 2022 can be found online if you go to the fiscal note. Assumptions. Based on the data discussed above, the fiscal note assumes that by increasing the number of individuals who may petition for an ERPL, the number of ERPLs issued will increase. Because the New York law included a provision that required law enforcement petition for an ERPL in some cases, And because Maryland had more ERPO petitions than Colorado since its law was enacted in 2018, the fiscal note estimates a more conservative increase in Colorado than those in those other states. The fiscal note assumes that the number of ERPO petitions in Colorado will increase by 50%. From January 1st, 2020 through December 31st of 2022, there were 380 ERPO petitions filed, or about 127 cases per year. Assuming a 50% increase, this will result in an additional 64 cases per year. State expenditures.
Representative Buckenfeld, you have 1 minute remaining.
Thank you, Madam Speaker. State expenditures. The bill increases state general fund expenditures in the Judicial Department and the Department of Public Safety by $450,000 per year beginning in fiscal year 23-24. In addition, the bill increases the workload to the CDPHE. Expenditures are shown in Table 2 in detail below. Because I'm running out of time, you can go to the fiscal note online and see that table. In the Judicial Department, starting in fiscal year 23-24, expenditures in the Judicial Department will increase to hear additional ERPO petitions. Specifically, the bill will increase magistrate cost and attorney and mental health evaluation workload as described below.
Representative Buckenfeld, your time has expired.
Thank you very much, Madam Speaker.
Thank you. Representative Weissman.
Thank you, Madam Speaker. Good morning, members. When we spoke about this bill yesterday, personally, I spoke to questions of due process, legal details, who we engaged with, and why certain things came to be in the bill. I think this morning I wanted instead to speak squarely to the mental health aspect of what this policy is about. I've been around here long enough to know that when debate about what I will just call firearms policy broadly comes up, mental health also always comes up, and it should. What I do disagree with is the idea that the one can always be set off against the other. I think in a big complex society with big complex problems like ours, we have to grapple with things together. Not everything sorts itself into nice little buckets. And if I think about this policy, specifically in the context of other firearms policy, and I'll speak only in the past to not verge into other things before us. You know, in recent years, and some members of the body now were here for this and some weren't, but you know, we've grappled with safe storage, we've grappled with lost and stolen firearms, we've grappled with background checks, we've grappled with how the Second Amendment intersects with voting locations. All of those are what I would consider more in the way of general firearms policy bills. I think of everything that we have grappled with on this subject, ERPO, Extreme Risk Protection Orders, is actually the most squarely connected to mental health issues. Probably the witness testimony that I will remember most durably and for the longest time from the other night, and that's saying a bit because it was a long night in committee when we heard this bill, was from a witness who spoke of how his own mother took her life with a firearm last year. This is somebody that a lot of us probably actually know. You know, I've also been thinking this morning, getting ready to come in here, of a friend, and I spoke of her story recently too, who just had a really terrible life growing up, honestly. Sexual assault, domestic violence, nobody being there for her. All of this before age 20. and got to where in life she didn't want to face the pain anymore. And she tried to escape from that pain. She did not use a firearm, she used other things. And she's still here, and I'm very grateful for that. I doubt that she'd still be here if she had tried the other way. You know, and I could share more stories. I know that we all could. But in thinking about what ties all of that together, what is that experience that some people struggle with in life? I got to thinking of the Inferno of Dante. Nel mezzo del carmen di nostra vita mi ritrovai per una selva oscura che la diritta via era smarrita. In the middle of the journey of life, I found myself in a dark wood, for I had lost the right path. There are a lot of things that can knock someone off the right path and leave them in a dark wood. A lot of that probably falls under the umbrella of trauma, but that's a separate conversation. I spoke about a few examples. Other members have been courageous enough to speak of their own. It's possible to be in that dark wood for a long time. It's possible to wonder if you'll ever find the right path again. It's possible for the canopy to be so dense you wonder if you'll ever will feel the warmth of the sun on your face again. Sometimes your view of the sun diminishes to where it's no bigger than the head of a pen. So a few things matter in particular when somebody is lost in that dark wood. One important thing to remember is that there is always a way out, even if you can't see it. Another thing to remember is to not do anything that can't be undone. Now, as I referred to yesterday, our ability as a society to talk about mental illness has come a long way in the lifetimes of most of us in this room, but it's still a difficult subject to talk about. And as we continue to grapple with that, I want to say that there is a public interest in making sure that we do things that we can do to reduce the incidence of mental illness ending in death by suicide. Because every life that we save that way counts for something, and it very certainly also counts for that someone and a lot of the other someones who know that person who's been struggling. Now, this matters in the context of this bill because firearms happen to be quite good at doing things that cannot be undone. When it comes to any complex problem, I readily acknowledge that no one bill is going to solve that problem in the entirety. And I don't assert that this bill will solve that problem in the entirety, but I do assert that it will help. And I ask all of us to really, really think about that this morning. Dante's Inferno ends this way. E quindi uscimmo a rivedere le stelle. Thence we came forth to behold the stars. Please vote yes.
Representative Wilson.
Thank you, Madam Speaker. I'd like to start with reading the letter from my county commissioners. This letter was actually directed to the sponsors, but I'm sure they sent us all a copy. On behalf, and since we're talking about mental health, that is a concern in my county, in my district, because we have seen youth suicide, and we've seen more than we'd like to. On behalf of the Board of County Commissioners, please accept this letter voicing opposition to Senate Bill 23-170, Extreme Risk Protection Order petitions. It is clear that the intent of the bill's sponsors is to detect issues that could result in an individual either hurting themselves or others and preventing it from occurring. While this is an admirable and logical goal, the focus should be to ensure that individuals who are dealing with mental health issues have access to the resources they need. Licensed educators are not trained mental health professionals and may not have the expertise to correctly identify and report nuanced mental health behaviors that may result in the suspension of someone's rights. Others contemplated this bill, such as contemplated in this bill, such as medical and mental health care providers, require a certain level of trust to work effectively with their patients. Injecting teachers and medical providers into highly charged taking carries a high risk of destroying the trust on which people rely. If teachers and mental health and health professionals observe concerning behavior, they already have the avenues to notify authorities without directly engaging in the court process. This protects the teachers and the healthcare providers because they are not the ones doing it. It protects that trust. We urge lawmakers to focus on the factors contributing to mental health instability in our state and identifying long-term ways to promote the resiliency and well-being of our residents. We ask that this legislation be postponed indefinitely. You know, when we're talking about mental health and we're talking about mental health providers, and I know we've discussed it, as a veteran and much of my caucus being veterans, this hits home. Veteran suicide is, I mean, we call it 22 a day. I think it's actually up from that. But a lot of these members would not seek mental health care knowing that it might be used against them, knowing it might be used against something they might collect or something they enjoy, their only release. I'm around a lot of veterans. I live, you know, in a district that includes the Air Force Academy. I know how many veterans and active military use their firearms as a release at the firing range on a Sunday afternoon, and that helps them through. This makes their mental health care a danger to their other releases. Continuing on with mental health and red flag laws, I want to talk about mass shootings for a moment. The McLeaver Institute did a study in 2022 analyzing red flag laws and mass shootings. I'll start with the Highland Park mass shooting. 8 people were killed on July 4th, 2022 in a parade in Highland Park, Illinois by a mass shooter. Not only did the shooter, Robert Crimo, slip past Illinois' red flag law with ease, but it was determined he would have even slipped past federal red flag laws. This is in despite that Illinois having a red flag law that allows judges, family members, law enforcement to request firearms restraining orders for individuals determined to be high risk. So they already have this. At one point, threatening others to a point where police took away his knives. So that's kind of the point of this, is to take away something that somebody can harm themselves with otherwise. They did that. But after that, he got through multiple background checks and was allowed to buy firearms multiple times over the following years. Even PolitiFact conceded that having a red flag law in place will not stop mass shootings. In Uvalde, Texas has no red flag law in place, but not even a federal red flag law in place would have stopped the Uvalde shooter. He had no record of mental health or criminal aberrations. His own grandpa admitted that there was nothing that the shooter was doing that would be considered worrisome. He had no idea that the shooter bought firearms and firearms accessories, sent worrisome correspondence to others, put images on social media of his firearms. The only way the shooter could have potentially been stopped would be the presence of a red flag law and somebody willing to speak up about it. And that's what we see with all these shootings is, yes, somebody might have known something wrong, but they didn't do anything. However, if the family members were not aware of the shooter's odd behavior, there would have been no reason to report anything and would have made the law mute. Then there's the Buffalo shooting. In 2022, 10 people were shot by a shooter at a grocery store in Buffalo, New York. This was despite New York having a red flag law in place. Again, the shooter had obvious, worrisome signs that included making threats towards other students and being investigated subsequently after, telling a teacher, "I want to murder and commit suicide," being looked over by a professional in regards to his mental health, but then being released, proclaiming online that how he had lied to the police and made it through the mental health evaluation, having an online public diary in which he spoke of wanting to commit mass murder. New York's law allows for administrators in school, this started in school, allows for administrators in school and family members to ask for an ERPO. His parents were oblivious to the warning signs. The police and school officials did not act despite of the warning signs. New York's red flag law's inability to stop this tragedy resulted in one anti-2A activist telling NBC it was designed exactly for this circumstance. Now I want to get to the numbers real quick. When you look at the numbers when it comes to mass shootings and red flags, the numbers are pretty clear. The average amount of mass shootings per 100,000 residents was higher in states with red flag laws than states without. What does that tell you? The average number of people killed in mass shootings was higher in states with red flags than without. So not only is it more common in states with red flag laws, but it's also more people die. I would hope that the red flag law is not intended, and these changes to expand it, first of all, not intended to increase the amount of shootings and the amount of death, but also not understanding that it's not going to increase effectiveness. It does not do that. The statistics show that. Thank you.
Representative Vigil.
Thank you, Madam Speaker. It's an honor to serve with you, and I'm enormously grateful for your leadership this weekend.
It is an honor to serve with you.
So members, obviously, I rise in support of this bill. On the night of November 19th, 2022, we lost 5 precious lives in my district, while many others were altered forever. Suspect in this atrocity, despite what you may have heard from this well in recent days, is very much being held accountable. For one, he was dealt a rigorous beating on the floor of Club Q at the hands of a few good guys without guns. He is being held without bail. He is facing 323 charges, not only for murders and attempted murders, but also for assault and bias-motivated crimes. He will very likely never live again outside of state custody. But the lives of Ashley Paugh, Derek Rump, Daniel Aston, Raymond Green Vance, and Kelly Loving are gone forever. And I have met with many of these survivors and seen their wounds and heard their stories of how those bullets have permanently altered their bodies. And I can't stop thinking how incredibly bizarre it is. We have no problem bringing the law down very hard after the fact, after the carnage, after the massacre, after precious lives are gone and cannot be brought back. But to interrupt a major threat and prevent it from occurring at all, somehow a much bigger lift. So here we are to have conversations about bills like this. Here are some things we know about that assailant. In June of 2021, he forced an evacuation of his entire neighborhood with a bomb threat. He stood intoxicated and well-armed, threatening to become, and these were his exact words, the next mass killer, saying he was ready to die that day and take everyone else with him. In my city, we've seen a young black man be shot in the back and killed for a fraction of that level of threat to public safety. Salem also expressed white supremacist and anti-LGBTQ sentiments, ran a neo-Nazi website, posted content like mass shooting training videos, and even an image of a rifle scope trained on a gay pride parade. And don't think for a second he is the only one in our fair city demonizing the LGBTQ community. Now, do I know with absolute certainty that the specific provisions of this bill absolutely would have prevented that atrocity? No, because nobody can know that for sure. But what I will tell you with absolute certainty is that our community in Colorado Springs and El Paso County, collectively, we dropped the ball. Somebody needed to intervene. And if the range of individuals available to make that call, to initiate that intervention, if the tools were more available, something could have been done. Kelly and Raymond and Derek and Ashley and Daniel should still be here. It's a predictable act of violence we're talking about, not a lightning strike. It didn't come out of the blue. He told us who he was. He said what he wanted to do. He threatened it multiple times. And we're only allowed to do something. This state only has an interest in doing something about it after lives are irretrievably lost. We can disarm hate, and we can put time and distance between a person in crisis and lethal means. Please vote yes.
Assistant Minority Leader Puglisi.
Thank you, Madam Speaker. And it's heartbreaking to follow the good representative from El Paso County and also share her sentiments. The loss of life is incredibly difficult. I kind of want to put a different thought out there. You know, I had come up here at one point and told you about a woman who was a survivor from her abusive husband and, you know, got out of the bathroom, saved her children, got them to safety, and tried to figure out what her next steps were. The second part of that story is that while she's trying to figure out how to protect her family, he went to the courthouse and got a restraining order against her, or attempted to get a restraining order against her, saying that she was a harm to him and to her babies. Anybody that knew this woman would know that that was completely false. But the court system still had to investigate it. And what we've seen is, I mean, he wanted to publicly humiliate her. She was incredibly strong, or known as incredibly strong in her community, to some people very intimidating. And so he knew that going to the courthouse and doing this would be of significant harm to her. But more importantly, what he knew was that he had the potential of taking her babies away from her with this false accusation. And thank God that's not the direction it went in, and she got her babies. But the fact of the humiliation she went through, the trauma she went through, having to defend herself from this false report was incredibly difficult, and something that she is going to feel for the rest of her life. She was able to fight it, but there are so many abused women that don't have that opportunity, or have findings against them that are not true. Again, this woman did not, and she was lucky. But not everybody is so lucky. And so I wake up every morning and say this mantra that I want to be a good human today. It's really how I start every one of my days, be a good human. But unfortunately, there are just people in this world that are not good humans. And we can pray for them, and I do, but they're just not good people. And they will use the system in a nefarious way against them. And to me, I want us to be very mindful and thoughtful of the cracks in the system that do exist. And you'll hear more about this throughout my time here, however long I am here. because I do think there are a lot of cracks in the system that this legislature needs to fix. But I want us to be mindful of how the system can be turned around and used against especially abused women in a way that was never intended. And I urge a no vote. Thank you.
Representative Taggart.
Madam Speaker, it's an honor to serve with you.
It is an honor to serve with you.
This discussion on SB 170 has been probably one of the most emotional things that I've had to go through since I've been here. Most people would describe me, and I've heard some descriptions about me. I heard another description yesterday as relatively quiet, calm, logical, even a word that I was halfway intelligent yesterday, which I appreciate. I don't always think of myself that way, but I appreciate that. Some of my colleagues asked me this morning, "How are you, Rick?" I had just come from my car in absolute tears, which people don't see out of me very often. And it has to do with this bill, because it has brought back memories of one of my closest friends who committed suicide. Please, please, please don't. That's hard for me when you stand. Please don't. I'm not equipped as a professor to do a petition, and I'll tell you why. This man who helped me and a team bring Swiss Army during our tenure together to be the #2 exporter of watches in all of Switzerland. This man that I stole from Breitling. This man that I traveled around the world with. This man who knew every sushi bar in every country we ever went to, which amazed me. This man that drove a Mini Cooper at speeds that scared the bejesus out of me. And I grew up in a race car, and he still scared me. And when he wasn't driving that, he was driving this huge Yukon, if you can imagine, in Switzerland. This man that spent 10 years with me, helping me build this business, helping me the weekend before at the big Basel Trade Fair, where we drove for 4 hours from Basel to Zurich. This man that I should have seen, he was in trouble. And 2 days later, he took his life with a gun. I failed him. I wrote a very long book for him that was presented at his memorial, that is in my office at the university, along with JB smoking a cigar, which I can't stand smoke, but because I love this man so much, I did. I failed him. I failed his wife. I failed his son. And now I'm being asked as a professor to spot somebody that is in trouble, whether it's suicide or the potential of harm. I can't do that. I formed the Suicide Coalition in Grand Junction, Colorado, because I cared so deeply about this subject. But it doesn't take the failure away. And every time I put on one of our watches, I remember that man and his smile and the love that I will always have for him. Please don't ask us as educators to do this. I can teach you business strategy. I can teach you about international business. I love to mentor students. I think I'm one of the more popular professors on campus. But when it comes to students in crisis, I want to take them to the experts. I'm not equipped to do it. I don't want to judge it. I don't want to write a petition on it. Please, there are experts on campuses across Colorado. We have campus police. In our particular case, it's the Grand Junction Police Department. They're equipped to do this. They're equipped to get through the rumors if there are rumors on campus. I don't want to go through the rumors. I could potentially hurt a student because I take a position on a subject like this that I don't want to do. I want to teach. I want to mentor. I want to share my experiences with my students. I don't want to relive this suicide, which I do every day. And I failed. Please, keep this more narrow. We as educators just are not equipped to do this, and I can only speak for myself. Thank you.
I am so sorry for your loss, Representative. Representative Armagost.
Thank you, Madam Speaker. That's a tough one to follow. But along the same lines as my colleague was talking, I've mentioned before, I got to serve as a suicide intervention specialist in the military for about the last 5 years of my service, and was thankful that I didn't have to see anyone in my unit to make that ultimate decision. However, as some of you know, I had to exit yesterday to go to a 20-year reunion to a Iraq deployment in 2003, where I was able to reunite with people that I haven't seen in 20 years. Of that group, we have a handful, literally, 5 people from our platoon that have since that time taken their life. So with a lot of raw emotions today, it is tough to have lost. It is tough to be a person that knows they can make a difference, a person that knows they can make a call, and please sit down, to make a call and simply change that outcome for somebody. And I've had the opportunity to do that, and it is a draining experience to literally talk somebody off the edge of suicide or worse, even homicide. But in those occasions, I've had multiple conversations with somebody, because I've always offered myself as that outlet. If somebody ever wanted to hurt themselves or other people, call me. Day or night, I'll answer the phone. And I did. And when I'd answer the phone, I would assure them if they had a condition of, please just don't call the cops. Please don't do anything about this. I just needed somebody to talk to. And I would just ask them in return, if you can promise me that I'll see you tomorrow, I won't. But if you can't make me that promise, then I'm going to have to intervene and have law enforcement intervene. And that's a condition that I thought was appropriate. I think there is a scope. Do I like the way the original red flag law exists? No. But I do think there are portions of that can be effective to further give law enforcement an ability to intervene without somebody, because those people that I know or knew that took their lives, they didn't leave that opportunity. They made a very impulsive decision without any sign of doing so. And there are people that are going to do worse things, like homicide. We're going to deal with mentally ill people. But to expand that to a scope that I think we're doing more harm than good on mental health. For those people that are worried about that, they need someone to talk to, but they're worried about losing what's near and dear to them because of their feelings, because of their idea, their hopelessness. We're going to force those people to stifle that. We're going to force those people to stifle that to the extent that they sink deeper into whatever pit they're in, whether they're going down a suicidal path or a homicidal path. We're enabling that. So I would ask everyone in here to consider that. Again, asking you, pleading for you to consider that. And this bill, for the way it's written currently, before this bill can go through, we're giving law enforcement what they're already doing and what we have seen in studies as being the most successful way of getting this done. Those petitions that were filed by law enforcement that were completed were over 90%. I think keeping that the way it is and narrowing this to that is important. However, expanding that to mental health care providers, medical providers, I think we're digging that hole deeper for those people that need that mental health treatment and are afraid to get it because they're afraid of losing what's near and dear to them. And I'd hate to see more lives lost because of that. So I would strongly plead and encourage a no vote on this bill. Thank you.
Representative Amabile.
Thank you, Madam Speaker. I'm up here today to speak in absolute support of this bill. And yesterday I told you all that I had testified in favor of the bill in 2019, the original bill. I belong to a group. It's parents of adult children with serious mental illness. And we meet every week on Zoom and talk about what's happening with our families. And when we hear about a mass shooting or any kind of a disturbance in our communities, we have a different reaction than probably most of you have. Because we think that could be my person who did that. And we all feel terrified. We feel like the world is going to blame us for what happened because we raised a monster. But let me just tell you that we're out there every day trying as hard as we can to get help for our people. And there are so many hurdles that are thrown up in our way every day in every way. And this thing is a way of saying, hey, we need help. We need the community to help us get our people the help that they need. And the other thing that happens to us after these tragedies is that we get to hear the community come out and talk about what was this family thinking? Where was this family? After the King Soopers shooting, the amount of blame and shame that got directed at the family of the shooter because they didn't do anything. Well, they didn't know what to do. They didn't have any support. They tried, but they didn't know what to do. And then we all blame them. It's their fault. Well, it's our fault because we have failed people who have serious mental illness. And this bill is the intersection. It is the place where we say, okay, let us help people who have mental illness. And I've heard everybody in this chamber talk about how we have to do that. And this is the time. This is the bill. This is the way that we do that. We know somebody's in trouble, and we stop them before something horrible happens. That's what we're here to do. This bill, I can't even believe it's a controversy. It is so in line with what I have heard everybody in this building talk about. And so I just, we need help, we the parents, because our children are not monsters. They are not disposable humans. They are beautiful. My kid is as beautiful as anybody's. And he's sweet, and he's smart, and he's charming, but has a serious illness. And when that gets out of control, if his mental health practitioner knows about it, if his doctor knows about it, if anybody knows about it, I want them to try to get him help before something bad happens. So I beg you all to please think about it in a slightly different way and to vote yes. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. It's a difficult day. It's a very difficult day. We've all dealt with this. We all want to, an issue that I have is that this is being posited in the way that if you oppose this bill, you're for mental health crisis and you're for mass shootings. And I think that needs to be separated. We need to have those conversations. Those are legitimate conversations. But we've been tasked with solving these problems inside the bounds that protects individual sovereignty. This bill does not protect individual sovereignty. And that's my overall issue. We're tasked with that. We already talked about how the fear is that this violates the Second Amendment, and we're assured that it doesn't, but it also violates the Fifth and the 14th. And it also violates the 6th, where you have a trial, or you don't have a trial. You don't have a public trial. You don't get to confront your witnesses. I think something that we can learn from history in that with these bills is that no matter how well-intentioned, and I'm going to say that I do believe that this bill overall has good intentions, but it does not relieve that it's problematic. And we can't just pass it. We can't just pass it on a team sport basis and ignore the problems with it. And we can't say that, oh, well, confronting the bill and not wanting to pass it is tacitly the same as promoting mental health issues. We could. And just off the hand, $75 million to electric buses, the millions of dollars that we found that are spent on mental health being sent to NGOs that deal with nothing of mental health. When I was a deputy ops group commander, one of the things that we had to deal with was suicide. A man committed suicide. It was a marital issue. And then when they went into his computer and found out what was going on, he had been online. There are sites online that coach you how to kill yourself, how to convince people that you're okay. We have online bullying issues. We have internet coaching to do that. We have oppressive government that makes people feel that their future is being taken away from them. We don't do anything with that. We pile on. We don't take away the First Amendment, despite knowing that that so many of these issues are there. We don't take away the First Amendment and tell every movie theater to shut down. And when somebody does complain about a violent movie, then they're vilified. So we can't just make these false relationships between not caring and not liking this bill, because that's how we get bad bills. One of the things I tell what I would consider my Government 101 class is that what it says it is, it ain't. And I think down the road, because it's very easy to see how this bill can be weaponized against political opponents. And then it becomes what this bill that was ostensibly for public safety becomes about swatting political rivals in the name of safety. And that becomes a definite problem, because that doesn't go away. We tried to have that section specifically removed in page 4-8 through 10 with a partisan office. Do I have a problem with the AG right now? Not that I know of. But that Attorney General office and those 3 sub-paragraphs, those people don't have anything to do. They don't have any knowledge. The closest that they're going to have of any knowledge is an individual is through the phone tag process, We tried to address that. We were literally shouted down because this is a team sport and our opinions don't matter.
Representative
yes, ma'am,
DeGraff.
I understand, thank you. The more society drifts from truth, the more it'll hate who speak it. I think I like to pull these things from history because history is a warning from the future. And we can look to the past to see what's going to happen. The welfare of the people has always been the alibi of tyrants. Crisis is the rallying cry of tyrants. I'm not saying they're tyrants, these are laws that are being put on the books that can be weaponized, and they will be weaponized, that can be guaranteed. Those who voluntarily put power in the hands of a tyrant must not wonder when it's turned on themselves. These laws put power, unaccountable power. There's reasons that we have the values that I spoke of. We're called to solve these problems, but we're called to do it inside the box. We're called to do it inside the box, this very inconvenient box that guarantees individual sovereignty, because when we step outside of that box, when we start solving problems outside of the box with the laws of, with good intentions and the laws of wishful thinking, we devolve into tyranny. And it's happened repeatedly throughout history, to the point where you can just pretty much say that is guaranteed to happen. That is not the intent of the sponsors, but this bill leaves those avenues open. Benjamin Franklin, they that give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. If we go through this, bill, I already talked about page 4, section 8 through 10. I expect that will be used in short order by any one of the 3 subparagraphs that are listed there. All unaccountable persons, with no repercussions. We've already talked about that. There's no repercussions to this bill. The penalty of perjury, which won't be enforced, hasn't been enforced, and in essence, it amounts to nothing more than a stern look. That's a hand slap, if best. Beyond a reasonable doubt, good cause. How emergent is this? Because the hearing is going to be within 14 days. So you have 14 days. Is this emergent? There are other processes. We've already talked, the county commissioners have sent us the letter and said, we have processes to do this. We could take that $500,000 and we could educate people on the processes that are already there, that have already been vetted, that we've already said, hey, I think these comport with individual sovereignty, and they recognize that we have a problem, and we can use that. We can use things like competency hearings, and we can have a due process method. But instead, we have a 5:17 a.m. showing in Maryland, and this is what we'll have here: kicking in the door, and somebody's going to get shot. And then we'll use that as further excuse, or it will be used as further reason. I shouldn't say excuse because that would imply motive, but it will be further reason to paper over the issue with more legislation, and we continue to suppress the individual. The preponderance of evidence, not a criminal standard. Good cause shown, not reasonable doubt. 15 subparagraphs of individuals. Family member, household member, community member, law enforcement agency. It sounds so good, but there are 15 subparagraphs of who those people are. Unaccountable, probably unknown, authorized to disclose protected health information. Once that's out, it's out. Under penalty of perjury, to disclose the petitioner's address. The petitioner is kept safe, which is understandable, but you have a due process for a
Representative
reason.
DeGraff, you have 1 minute remaining.
Thank you, ma'am. Clear and convincing evidence, not a real standard. That's very arbitrary. In determining the grounds, tendency in that direction. There's a lot of tendencies. Tending towards. That can be anything. Evidence of abuse. What are some reasons? Evidence of abuse. Evidence of a recent acquisition of a firearm or ammunition by the respondent could be part of determining the grounds. Just says some or all of those have to be used by somebody that's completely unaccountable. Says you just bought a weapon, you're probably unsafe. We can go through the court process. It doesn't have to be due process. 50-50. Meh. Somebody dies. So what? 50-50. I know that's not the intent of the intent of the. I trust that the
Representative
intent is
DeGraff,
good.
your time has expired.
I urge a no vote on this, not because it's a bad intention, but because it needs to go back and be reworked.
Representative DeGraff. Representative Hartsook.
Thank you, Madam Speaker. Thank you very much. Ladies and gentlemen, I would like to give you something to think about. I know everybody is busy reading and thinking about different things. But if I could have you look at me for a second, and then I would ask you, Madam Speaker, if I may indulge for a moment, please look at someone different across the aisle and think about what you are feeling and what you are thinking and about what they are thinking and what they are feeling. And this isn't just a judicious exercise, this is a serious one. Now, I will submit to you that we cannot understand people's intent. We can't understand their feelings. We don't know what they're going to do. In my combat experience, I've dealt with zealots. I had a lot of combat power at my disposal, and yet I've not been able to stop a zealot with an intent to kill someone or a group of people. 2020 hindsight, when we see crimes and violence happen here in America, we're like, we should have done this, we should have done that, I should have seen this, I should have seen that. That's 2020 hindsight. You cannot see that in advance. If I could have done that in my combat deployments, we wouldn't lose people. But we can't. As parents, we don't know when our kids are going to get a skinned knee, let alone when there's going to be violence at school. If we could prevent a skinned knee, we would, but we can't. What makes us think we can prevent violence and intent from someone? Some people will think it's in a law, some people will think it's in God, some people will think it's in something out there. Many, many times, bad things happen to good people. I don't know why, but they do. Our purpose collectively is to try and find the best way forward. Sometimes we muddle through that. Sometimes we get it right, sometimes we get it wrong. But I would assume that we're all trying to do the right thing, as any parent will try to protect their child. We can feel guilt when our kids get hurt or when something very horrible goes wrong. And that's not fair to ourselves either. We are not masters of the universe, no matter how much we think we can control the situation. We cannot. You have to have a certain amount of faith and trust. You can do the best you can, and sometimes bad things happen to good people. Maybe when we're all standing in front of God, that probably one of the questions I'd want to ask is why? Because I cannot stand in front of you and tell you why. I just know it happens. I know it happened in combat.
I know it happens at home. And I remember one situation where a friend who was retired had not shown up for work. I went to his house, and I've been around in the military and other folks that have committed suicide. Didn't know what I was going to walk into, but I did it anyway. Fortunately, at that situation, it turned out okay. Got him the help he needed, and everything's going just peachy keen now. I did that because I had built relationships, not because of the power of a law or something out there, but because I had a relationship. I would encourage all of us that sit on these different seats and aisles, and as we started this with my speech and asking you to look at each other and think about that, to continue to build those relationships. Go to someone who's different and try to learn. We did that in the freshman class when we started. We try to do it now. It's hard. It's flat hard. You know it, and I know it. I do not believe that the power of the government can make people sit down and talk. It cannot make people prevent things. We can do it here. We can do it out there. We can do it in every place we go. Let the change start with me. Thank you.
Representative Frizzell.
Thank you, Madam Speaker. I have not had the occasion to do this yet, so yay. It is an honor to serve with you, ma'am.
And an honor to serve with you.
So, colleagues, it's been a long weekend for all of us. We have heard many, many, many stories, personal, anecdotal, of people who have needed firearms for protection, wanted firearms for protection, who should never, ever, ever have a firearm in their possession, people who have had their firearms taken away unreasonably. Lots of stories. This is an emotional conversation. And Madam Speaker, I want you to know, I appreciate your words from earlier about decorum in this chamber and compassion for those around you. Mental health is a significant issue where I come from in Douglas County. And almost 10 years ago, in 2014, the Douglas County Commissioners had the foresight to create the Douglas County Mental Health Initiative. It was a big deal. This isn't just for unincorporated Douglas County, but it unites all of the community partners in addressing unmet health needs. It connects people to mental health services, and it prevents those who really are in need from falling through the cracks of the mental health system, because that's a really, really easy thing to have happen. I think we all know that. We talk a lot about it, actually. One of the first really amazing efforts was the creation of community response teams in Douglas County. They started off with 2, kind of a pilot. These community response teams pair a member of law enforcement with a mental health clinician, and that streamlines access to mental health and substance abuse services, and it serves the purpose of bypassing emergency services. These are people who will come to your home, to your school, to see what you need, how you can best get services and help. So over the years, this program's grown, which is actually not great because it's had to grow, along with the mental health issues that we've seen all over our country. Now, Douglas County has 2 youth community response teams, specific to our kids. I think that was a great idea because our youth have different problems than adults. But these youth community response teams provide communication between schools, homes, and the community. My point is, these community response teams are the types of folks who really should be evaluating whether an extreme risk protection order should happen. They should be the first step. They're not available everywhere. But just anecdotally, since the youth community response teams were created, and that was in 2019, so they've been going for about 4 years now. They've had around 300 encounters with youth in Douglas County, all over Douglas County. 33% of those were treated in place. 34% were placed directly into a mental health facility, getting them the help that they needed so badly and urgently. And another 30% of them were released to a parent or back to class. Of all of these kids, only 3% had to go to an ER. But the other thing that I think is really great about this is there have literally been 0 arrests made because these kids have gotten the help that they needed. So my point, because there is one, I promise, is that if we're having these conversations, we need to walk the walk with mental health. We need to put our money where our mouth is, and let's address the flip side of the coin. Because I don't really feel, because we keep having these conversations, because we keep having these breakdowns with mental health issues, because it is so rampant, let's step up our game on that. That's my ask for today, but I'm also asking for a no vote on this bill. Thank you very much.
Representative Weinberg.
Thank you, Madam Speaker. It's a privilege to serve with you.
And a privilege to serve with you.
General Assembly 74, my constituents in Loveland have really been deeply concerned on this. There is a final fear for them that expanding what was already enacted a couple years back with all the shootings, which again yesterday in Aurora we had one. So I'm surprised we've heard nothing about so far. This is happening. I hope the bill sponsors, I know that they have good intentions. I hope with all my heart that this will carry forward and help the situation. But I'm betting it won't. I hope to God that simple things that are coming through that are being portrayed as simple, which in my eyes and people that are speaking to me in Loveland, are way more complicated. And I think we're putting a lot of complexity on what really the issues are. I rise in opposition of this bill for the 77,000 people I represent in Loveland, and I hope that after long debates that we've had, that you would take a second to look into what we're about to do with this one and expanding who can defend themselves. I urge a no vote. Thank you for your time.
Representative Winter.
Thank you, Madam Speaker. So I'd just like to share something with you from rural Colorado. This was an article that was done, actually, one of my county commissioners was part of this. And if you guys just don't mind, I mean, this is, I think, pertinent to what we talked about, and I just want you to know kind of why I brought the points I did yesterday. It was called Without Access to Care, Anxiety, Depression, and Addiction, Stalk Rural Coloradans. Kiowa County, which is in my district. Simply coping can be lonely, and here in southern Colorado, where the brown fields sweep to the blue horizon, struggles come on as slow as drought or with the sudden intensity of a dust devil. There's desperate isolation in a place where everybody knows everybody else's business, says Laura Nagy, a mother of two who has lived on the Eastern Plains for all of her 58 years. She has to grow 2 children and says grace with her husband and son over about 13,000 acres in Kiowa County, between Kit Carson and Lamar, a flat, dry place that's more a mix of Kansas and Oklahoma than the Rocky Mountains. It was late in 2012 when the wheels fell off, she explained, in a barn half the size of an airplane hangar, surrounded by hulking farm machinery on the edge of a field. The drought was kicking the daylights out of their property. Market prices for cattle were depressed, and then God threw in a cruel insult. A wildfire burned 700 acres of grass that was supposed to sustain their cows. We didn't have cattle. We didn't have crops. We didn't have any income coming in. Sorry, because my family's been through this. Other than what little we were getting in crop insurance from the drought, she recalled. After the cows finished grazing her fields in October, Nagley was alone with her worries. Her outgoing personality turned inward. She really left her house. No, please. Sit down, please. Her outgoing personality turned inward. She rarely left her house in ease. And when she did go outside, it was a constant struggle with anxiety. Her daughter and her friends were concerned, and her family staged an on-intervention when she said she wasn't coming home to Greeley to celebrate Christmas that year, a tradition she'd previously held sacred. There's many times I thought, Lord, if I don't wake up in the morning, that might be the next best thing. The first solution was to get her away from Eads, where there was virtually no professional help. She stayed with her parents in Greeley, a big city by Plains standards, while she got intensive counseling and found a path forward that's been less about medication and more about faith and opening up to others. I thought it was time to speak up, said Nagley, about taking publicly in speeches and interviews. It's not easy to discuss it. It's kind of a personal thing, but it helped me hear other people's stories about how they've gotten through tough times. Poverty, distance, and stigma. In the small, far-flung communities of rural Colorado, getting help for mental health concerns is a tall task with high cost and uncertain outcomes. Statistics and studies show that the rates of depression, suicide, and substance abuse are as prevalent as in urban areas of the state, and in some instances much higher. In southwest Colorado, the suicide rate is 3.18 per 100,000 residents compared with a 20.2 per 100,000 statewide, which is the 10th highest among the states on the Eastern Plains in a statistical region that includes Albert, Lincoln, Kit Carson, and Cheyenne counties. The rate is 28.7. 9 of 10 Colorado counties with the highest rates of overdose deaths have populations of less than 50,000. 22 rural counties don't have a licensed psychologist, and 24 counties do not have a licensed addiction counselor. Mental health providers scramble to overcome what's called a windshield time to reach those who need help. Services lag despite the best intentions of state and local governments, partners across a variety of rural agencies, and slowly changing views on getting help with mental concerns. They lag because people out here in general are too poor to pay the taxes to generate much more in the way of services than they would already have. State and local agencies grapple with solutions to overcome poverty, distance, and stigma. Emphasis on stigma. Crisis dollars tilt toward the country, averaging nearly $10 per capita in rural counties, compared with about $4 in urban counties, said Robert Worthen, the director of Colorado Official Office of Behavioral Health in the State Department of Human Services. But when you don't have many people, the economies of scale crush a lot of solutions that take public dollars. In other places, local mental health programs often are heavily subsidized by local tax base or sales tax. Amid the poverty of the San Luis Valley and Eastern Plains, such investments quickly fall out of reach, layered on top of the dilemma of finding psychologists and counselors willing to work in towns of a few thousand of even 100. If you don't have at least a mix of wealthy and with poverty, you're not going to be able to raise enough tax revenue to local efforts. But if you have the money, you still got to recruit the workforce. Now, this comes to what I explained to you guys yesterday about the stigma. They don't want to travel to a place where their car will be seen, said Mo Caller, a former state legislator from Jefferson County, who is the advocacy director of Mental Health Colorado. They may not have a problem going to a hospital or a health clinic, but because their car could be there for anything, but people are hesitant to go to mental health center that's a standalone facility. They're really reluctant to do that. And that was my concern yesterday. A lot of these people are steeped, just like we are, in the Second Amendment, and they have these beliefs. And if they're afraid of somebody seeing their car in a parking lot of a hospital, that it could be put in together that they're getting mental health care, I just urge you, don't you think that if they thought their guns were going to be taking, like I said, it's not a gun issue. For us, it's a self-preservation issue. It's a constitutional issue. It's the protection of our lives. And I'm scared, and I hope not, like the rep from Denver said, we hope there's no ill-intended consequences to this. And we're not preaching that from this podium. But I'm scared there will be. I'm scared these same people that are afraid to see their car in the parking lot in rural Colorado are going to realize that there is a chance that a doctor that may not be from rural Colorado, that don't know the way we talk to each other, don't know our culture, don't know our heritage, is going to pull the order on them. That worries me, because we were making ground. Like I said, the Farm Bureau was giving anonymous vouchers and people were taking them. We talk about saving lives, they're all lives. And in rural Colorado, I'm afraid it's going to have an ill effect. I really am. I wouldn't be up here pouring my heart out to you all if I didn't. The code of going it alone. There's been a code out here for as long as anybody can remember. Your problems are yours alone. And that way of thinking can feed the invisible beast that gnaws away at people's emotional well-being. The economic and emotional cycle, like the cycles of blizzards and droughts, is especially tough on young adults. They tend to learn from experience and old-timers about how to weather the tough times in farming and ranching, setting back emergency sources and feed and money. New farmers and ranchers are often living from year to year. One storm or one bad market wipes them out, and sometimes takes away with it its family legacy. Some of us have been out there farming that ground for 4 or 5 generations. It's our lives. No vacations. No money for anything. Land rich, money poor. Devoting your whole life to this. Strapped to the earth. A little piece of the earth. Trying to make a living. Trying to carry on a legacy, and there's pressure with that, obviously. I've lived through it. You'd have a good year, and a hail would come and take away your alfalfa. And when you don't have alfalfa, what happens? You can't feed your cows. And when you can't feed your cows, you can't take them to sale. And when you can't feed your cows, you can't feed your kids. And when I talk about consequences, I know what you're trying to do. Don't think I don't. For my constitutional reasons, those are there for me too. But that's why I ran those amendments, because I'm afraid. I'm afraid.
Representative Winter, you have a minute left.
Thank you. Just remember sometimes, folks, we say it up here all the time, and I don't mean this in a bad way, but there's always butterfly effect to law. And I know you all want to save people, But the people that you're trying to save aren't any more important than these people right here. And I sure in the hell hope that people will not quit going to receive help and the gains that we've gotten in rural Colorado, because unfortunately I think it's going to be something that really happens. I've called some people yesterday and talked to them. They're like, I'd never go now. I'd never go. And I'm telling you, I'm not just making that up. I called some old timers like I would never go knowing this. So all I ask you is if there's any way we could try to fix some of this before eventually it goes through, just think about it. I don't want to see we fought to gain ground in rural Colorado and break this stigma, and I don't want to see it be furthered. Thank you, Madam Speaker. I urge a no vote on this bill unless we can work something out. Thank you.
Thank you. Representative Soper.
Thank you, Madam Speaker. Thank you, members. I rise in opposition of Senate Bill 170. I heard this bill in House Judiciary, but I also heard the underlying bill back in 2019 in House Judiciary and remember that particular floor debate. Many of the arguments are very similar to 2019, building on who can file an extreme risk protection order or an ERPO, expanding it from close family and law enforcement to a list of others to include educators, medical professionals, DAs, and even the AG. While on a logical listing to build upon, you may be able to get behind DAs. Educators and medical professionals are a bit different. And there is a real fear that someone who is at their doctor having a very honest conversation, the doctor or the medical professional should be able at that particular point in time to be a friend, to be able to listen, not immediately make a call to the courthouse and put in an ERPO. I've often been asked, Matt, how would you propose reducing suicides and gun violence in our society? And that's a very tall question. If it was easy, we would have already done it. This is probably the most challenging question of our time. As we look at statistics, it's no secret. Gun violence, suicides, over the last almost 150 years of the history of our state has increased exponentially with the rise of what I would say has been a couple of phenomena that has happened. One has been we're more likely to be isolationists as individuals. The ability to be on our phones, looking at our laptops, working from home, not being part of a club, or going to church, having a community of friends that you go hang out with. We're pushed more into our corners, but also being desensitized by having certain video games and certain movies. I admit, I've probably seen thousands of murders in my lifetime. And I don't think any of them were real, but it's gotten to where it's very difficult to tell the difference between certain news reports and what I've seen in dramas. I believe in the noble efforts of what is trying to be accomplished here. The ability to stop something before it happens. But I do want to hit on one thing that has certainly been troubling. And we brought it out in committee, and it deserves to be mentioned again here on the House floor. And it's that firearms, unlike any other property, unlike any real property or any other corporeal property, actually are connected to our Constitution. You may not have a constitutional right to own real property. You may not have a constitutional right to own a car or drive that car, but there is a constitutional right, both in our state and our federal constitution, to own a firearm. and the ability of a citizen to use the courts to deprive another citizen who has not been charged with, nor convicted of a crime, nor charged with an inchoate offense, meaning what I like to call a pre-crime offense or an attempt, or convicted of an inchoate offense. The ability to take personal property or corporeal property that is connected to a constitutional right casts a chilling effect on the constitutional protections in the Second Amendment of the U.S. Constitution in Article 2, Section 13 of the state constitution. It also pulls out Article 2, Section 15 of our state constitution, which talks about taking. It's much more specific than the takings clause of the Fifth Amendment in the U.S. Constitution. To argue just slightly against myself on the takings part, since presumably the firearms would be returned to the individual, it would not fully undermine these particular clauses. But on the point of just the takings of the firearms, when I read the bill, if you turn to page 23 of the bill, it talks about who's allowed to temporarily have possession of the firearm. And there's 3 people that are allowed to have these. One would be a federally licensed firearms dealer, where you would sell or transfer possession. The other one would be a law enforcement agency. And the third one is kind of interesting. It talks about an antique firearm or a curio firearm. And I didn't look up exactly what curio firearm was. But here the court would allow a friend to be able to take possession of those antique firearms, or the curio firearms, understanding that there's a lot of value in a firearm. And yesterday, I was back for some hospital meetings, but I ran into a friend who asked me if I had heard of a certain pistol, and I've forgotten the name, and I said, no, I hadn't. And he said, well, this is a very unique kind. It has a Syndiclor barrel, if I can say it, and it fires from underneath, and it's the only one that's been made like that. And he said he was able to buy one at an auction, and they're very expensive, and he didn't plan on firing it or touching it because of the value that's tied to that particular gun. And as I read this, I think about when I was young. I remember, we've had a close-knit family. My grandfather, being the farmer and the rancher, had the neighbor come over. And the neighbor handed my grandfather his pistol. And he told my grandfather, I've been struggling. Would you hang on to this for me? And my grandfather did. I, of course, was too young to know exactly what he did with it, but I do remember that conversation very, very clearly. And what's missing from the list here is the ability to do just that. To say to a friend, if you're struggling, maybe you understand that I've been served in ERPO, but at least someone who is a friend, who's not in your same household, would be one who would be able to respect the guns, not damage them, make sure that they're in the same state that they left as they're returned. And that's not provided for here. I could go on with a few other things for why I do not support this bill. I thought my colleague from Grand Junction listed a very strong and compelling reason about how we're putting a lot on our educators and our medical professionals. I do kind of fear being put in those particular shoes. How do you recognize that someone, especially as a teacher, my mom was a teacher for 40 years. If a student is struggling and going through certain stages of life and certain fact patterns like the breakup with a significant person.
Representative Soper, you have 1 minute.
Thank you, Madam Speaker. How how you understand and parse out just the struggle that we've all had to encounter. And every single person in this chamber has had those same times when you've had heartbreak and frustration and anger. And if you didn't, actually, I'd like to talk to you if you didn't, because we've all had these same feelings. But being able to parse out, when is it a feeling that that particular professional needs to report an ERPO on, and when is it a feeling when you need to give them a hug, you need to listen to the person, you need to be a friend to the person, and you need to reach out and really just try to be the best person you can there, rather than immediately making things worse by involving the courts and law enforcement. I'd respectfully ask for a no vote. Thank you.
Representative Lindsay.
Thank you, Madam Speaker. It's an honor to serve with you.
And an honor to serve with you.
It took me a minute to get my thoughts together this morning. It's been a very difficult week for me with a lot of the news going on. And so my colleague spoke earlier about listening to each other and engaging authentically. And I know that I come here to do that work, and I spend a lot of time when we're in this chamber for these very long debates, paying apt attention to all of your different stories, your life experiences that bring you to the place with policy that we're all at. And so I thought I'd share a little bit about how I've come to be on my policy when it comes to the bills that we're seeing today. And sadly, it took me a minute because I just started to jot things on a pad of paper that have informed my view on gun violence prevention. And it took me a minute to kind of look up when things were, and then I could rank them. So I'll just start. Number one, in 1999, I graduated high school in 1996. I went to Chatfield High School, which is Columbine's rival high school. At the time, I was working at the Dillards at South Glen Mall, and was working a shift when I saw one of the sheriff's deputies bolt through the junior department. I could tell something was wrong. Obviously, didn't know what it was, but it was Columbine. I was 20, 21. This kind of thing hadn't happened in my school life before, so this was my, kind of first eye-opening experience with a mass shooting in a community that I lived in that impacted people I know. A classmate I grew up with, his younger stepbrother was one of the victims at Columbine. And this whole new world, emerged for me at that time, as it did for all of us. And this is by no means a comprehensive list. But number two on my list was several years later, after I'd already had 4 kids. And we went to Jazz in the Park at City Park here in Denver. It's a very common thing that people in the metro area do on Sundays. I had me and my 4 little kids there, my husband, my 2 cousins, a bunch of friends from roller derby. We were out to have a great night with our picnic. It happened to be the same evening where a fight broke out amongst individuals, and there was a shooting in the park, and a police officer was killed. My oldest daughter, Rowan, was playing under a tree, and bullets hit the dirt near her feet. And so I have always had this prevailing feeling of I hear what other members say about how they feel safe. I tend to feel less safe when there are people that I don't know or trust, with weapons. So that's where I come to this. And I appreciate that we're all not on the same view on this. But that really made me afraid sometimes to be in public, because you just never know. Number 3, and this was barely a month later. My dad's birthday is July 20th. one of the favorite things me and my dad do. Every Sunday, we go to the movies a lot of times. I live in Aurora, so our theater is the Aurora Century 16 Theater. That theater is in my district. I'm many Sundays not in session at that theater. For my dad's birthday, we were gonna go see the Batman movie. We would have seen it the night of the 20th. We don't do midnight showings, too old. But this was mere weeks after the event at City Park, where places that my family regularly frequents, people are being killed. And a couple years later, I was taking my children to a road trip. We drove down to Louisiana, and it happened to be the week where there was a movie theater shooting in Lafayette, Louisiana, a couple days before. I'm also a huge movie buff, as many of you may know. I'm in a movie theater as much as I can be. And so as I'm driving through Louisiana and then realizing, I look, oh, this is Lafayette, like there is this map of tragedy everywhere I go, that I can't drive anywhere, even when I'm on vacation with my children. I mean, just these incidents, not only happening in a place I'm driving, but in a place I go to, like for a while, every Wednesday night I'd be at a movie theater, and then I'm looking around and who's in this theater with me, and all I'm trying to do is be in a place and live my life. So obviously that impacted me. May 7th of 2019, I was watching my niece Rachel in Lakewood, and I got a call from one of my friends whose kids go to STEM in Highlands Ranch. And so it's just everywhere. I feel not only 2 or 3 or 4 degrees away, it's like every time something happens, it is impacting myself or people that I know. And I'm really not understanding why we just have to live like this. I don't understand why we accept this as a status quo, as a world that my kids have grown up in and will continue to grow up in. And then I'll just kind of fast forward a little bit to when I was a legislative aide for a short time for my predecessor. My first day on the job, I went to the press conference because there was a shooting in the park across the street from Aurora Central, which is the high school in my district. Not long after that, maybe some weeks, there was a shooting at the other high school in my district, Hinckley. And then in 2022, just this past fall, when all of us are knocking doors like we are during campaign season, I had targeted a particular precinct for a Sunday. The night before, because of a domestic violence incident, 4 people were shot and killed, murdered, blocks from my home. And then, I mean, and I think about ERPO and any opportunity to have ever prevented any of these things that I'm talking about. And I'm just one person, and this is just one little neck of the woods. I'm here for it. I don't understand why we wouldn't want every tool to be able to discern any kind of risk to prevent any of these things that I'm experiencing really on the regular. Which brings me, I do appreciate my colleague from Loveland, sorry, my brain, bringing up Aurora last night in my district, in HD 42, at Aurora Mall. There was a shooting in the parking lot between the food court and the movie theater, which is a parking lot. I have my daughter, when she had a birthday a few years ago, we walked a bunch of children across that parking lot from the movie theater about a sad dog movie to the food court. This is my home ground where my children are growing up, where all the children in HD 42 and Northeast Aurora are growing up. This is unacceptable. And so anything, including this,
Representative Lindsay, you have 1 minute remaining.
that could possibly prevent any of that from happening, I'm with my colleague from Boulder. Anything that we can do to prevent this, I don't know why it's controversial. I ask for your support on this. I feel like one of the reasons it's hard to talk about Aurora, and my part of Aurora especially, people have very specific thoughts and feelings about my district and about the people that live there. And so when there is a shooting of a teenager in Northwest Aurora, and I go on the comments on Twitter or on Facebook, people will just say horrible things about Aurora. They deserved it. They're all thugs and horrible kids there, and that's just the climate of Aurora. People live there. I live there. I have 4 children who are growing up
Representative
there.
Lindsay, your time has expired.
I urge an aye vote. Thank you.
Thank you. Representative Evans.
Thank you, Madam Speaker. As I often do on these policies, the ultimate question that I ask is, does this work? Because every single person in this room understands that the violence in our community is unacceptable. Every single person in this room wants to do something about it. But the art of legislating, the art of passing policy, boils down to the very simple question, does it work? I learned that phrase when I was flying helicopters for the United States Army. Because you see, when you strap into the helicopter, the only thing that matters is what we're doing working? In the aircraft, rank means nothing. Policy means nothing. Laws mean nothing. As a pilot in command, I was authorized to violate every federal law if I thought that that is what was necessary to preserve the safety of my aircraft and crew. And so when I come to policy discussions like we're having today, I try to carry a little bit of that pragmatism with me and ask myself, is the policy at hand something that will work? Will this save people? We've heard dialogue from the sponsors about how this will protect law enforcement. And so I ask, does this work? And unfortunately, I don't think it does. When it comes to law enforcement, the data is clear. In the decade before the first red flag went into effect in Colorado, Colorado was suffering just over 1 officer annually killed by gunfire. 1.1 to be precise, with 0 canines killed in that 1 decade prior to the first red flag. In the years after that first red flag order went into effect, the rate went up to 1.66 officers killed annually by gunfire, with 2 canine officers killed in just those 3 years. And so I don't think that this protects officers. In fact, my concern is that it endangers officers. Because you see, when I was a supervisor out on the streets, I was often called to situations in which somebody was contemplating harming themselves. I would often have a frantic, panicked family member call and say, my loved one is in that home. They're armed. They're contemplating hurting themselves. And I would have to have a very realistic conversation with that family member, and I would have to say, look, when your loved one is in an acute crisis, and they have the means to harm themselves, they also have the means to harm me. And so if I compress time and distance, if I close the distance with that person in order to try to offer them help, there is a very, very real chance that then I end up doing them harm instead of being able to help them. And I don't want to escalate a situation. I don't want to compress time and distance. I don't want to force a confrontation with somebody that's in an acute crisis, because that sets the stage for a tragedy where I end up, or my officers end up, hurting that individual in an attempt to offer them help. And that's one of my concerns with this, is that the data and my own experience shows that this does not protect law enforcement. Rather than allowing law enforcement the time and the space to work to de-escalate a situation, this forces a confrontation with folks who absolutely need help. But we all know from experience that you cannot forcibly help someone who is not in a position to receive help. I'm a huge fan of co-responder programs, as the good representative from Douglas County mentioned. But one of the things that I found working in the field, hand in hand with mental health care professionals, with co-responders, is that in the field, there are two things that are absent that would normally be present when somebody goes to seek assistance from a mental health care professional. In the field, when somebody is in an acute crisis, they're not in a position to receive that help. And number two, they're not willing to receive that help. Now, the next morning, when things have calmed down, when they've decided, yeah, I absolutely need to get some help here, then those two things are present. And that's where the good mental health care providers in our state can go to work, because those two basic premises have been met. Someone is in a position where they can receive help, and they know at a certain level that they need help. They are seeking that help. But the problem is, when we create a policy that forces law enforcement to have a confrontation with somebody in order to take away something that they view as a deeply held right, we've seen the passion that exists in this room over this issue. That passion exists outside this building. That passion exists in our communities. And so I'm afraid that the unintended consequences of this, of passing a rule, a law, that requires a confrontation, an escalation, in order to try to offer help to somebody, actually has the reverse effect. Not only does it put our law enforcement officers in danger, not only does it put our community members in danger who do need help, but it also makes those folks less likely to seek help. We heard the good representative from Southeast Colorado talk about this. Folks have to feel safe in asking for help. They have to feel that there is trust when they go to a mental health care provider, to a doctor, when they go to school, when they interact with educators. And so my concern is that under this policy, those individuals who do need help will not seek that help. When we insert the government between a doctor and their patient, when we insert the government between a provider and their patient, when we insert the government between an educator and their student, that breaks trust. That degrades the open and honest relationship that should exist. There was testimony to this extent in the committee where we heard this, where providers said, with this in place, I am afraid that I will lose patients, and the patients that I do have will not speak honestly and openly with me. And so if we create a situation, if we build a law where people do not seek the help that they need because they are concerned about potentially triggering a violent confrontation between them and law enforcement, where law enforcement is removing a deeply held, passionately protected belief that they have, their Second Amendment right to own a firearm, they just won't seek help. And that is why we've debated this for so long. We can all do math. We all know the numbers 19 and 46. We know that this is going to pass. But the reason we debate this, the reason we stand down at the well, is to try to mitigate these unintended consequences, to try to craft good policy that involves bipartisan dialogue and that does not have all of these unintended consequences. That's why we stand here. That's why we debate this. Because we want to have that bipartisan collaboration to reduce these unintended consequences so that at the end of the day, we can answer that question that I just asked. Does this work? Does this protect our communities? And right now, my great concern is that it doesn't.
Representative Evans, you have 1 minute remaining.
Thank you, Madam Speaker. My great concern is that in 4 years, 6 years, someone else is standing down here at this well, reading another list of names, reading a list of names of folks from rural Colorado, reading a list of names of law enforcement officers, reading a list of names of people who did not seek help because they were afraid that if they had an honest conversation with their doctor, with their educator, with their mental health provider, that a deeply, deeply held thing would be taken away from them. And so out of that fear, piled on top of the existing stigma in seeking help, those folks did not seek help. And I am afraid that in 4 more years, 6 years, we will be reading a list of names of
Representative Evans,
folks
your time has expired.
who did not receive help. I urge a no vote. Thank you.
Representative Holtorf.
Thank you, Madam Speaker. To my colleagues in the chamber, difficult times we face in Colorado and across our great country. As we talk about this bill, Senate Bill 23-170, and expanding ERPO. In testimony, we talked about abuse of ERPO under the current statutory provisions, where about 2/3 of those reports are not credible and don't have standing to move forward. I'm very concerned that with this expansion of the ERPO authority, that number will grow. The number of reports will grow, and that statistic will grow. In my humble opinion, the bill is too broad. I understand the bill sponsors' desperation, desires, intent, because of our problems in society. I know about cutting a wide swath. When there's a lot of hay to cut, you got to cut a wide swath to get it laid down. I understand what that means. But sometimes you don't do a good job of cutting the field. You leave a lot of hay up. Maybe you drive too fast. Maybe you break more sickle teeth. And when you're done cutting, it looks really ratty. And you get a lot of volunteer that comes back, and there's just a lot of problems with that hayfield if you don't do it right. Now, not to use a simple country analogy, this complicated problem is much larger than cutting hay. My fear, as I've thought about this bill, is that with respect to the abuse of ERPO in its expanded form, now juveniles that have juvenile parent conflict and those folks that are involved in that juvenile's life may abuse ERPO against their parents. And boy, raising all my girls, were there times when my girls did not like their father. I sucked the fun out of their lives when they were teenagers all the time. But I felt that was my job as a parent, to guide them and protect them. That's my first concern. The next concern I have is the domestic violence and abuse in family conflict between spouses or partners. We've all lived that. Exchange of words, dishes and plates start to fly. This opens the door for that now because of its broad effect. Now even a neighbor who hears somebody screaming across the street could call, as I understand this law, and invoke this ERPO by filling out a petition. What about lovers' quarrels and breakups? We've all had those. We've all had those. And then there is the backlash of retribution or trying to get even. And then someone does this. Maybe they're rolling the dice against perjury, or maybe they don't care. Or maybe they're smart enough to know statistically they won't get prosecuted anyway, because the courts are too full. There's no time for that. We have other things that are more important to do. We just had a shooting in our community, and now we're dealing with that. But unfortunately, the list is larger than that, because now you have school faculty and parent conflicts in this country with the crisis of education and who has the right to teach kids what. It's a real problem. Will teachers call out parents? I don't know. It's a real concern. Neighborhood disputes and vindication. Fence line squabbles in the country, Hatfields and McCoys. Those things are oftentimes generations old and they don't go away. And anybody that thinks they can gain an advantage or get some time of vindication, even so devious in rural Colorado as to say, that rancher over there, Holtorf, he's got problems, he isn't right in the head. Well, people in my community already know that, don't worry. But they'll say, you can go get his guns, and maybe that might lead to our ranch failing. And the whole time they just wanted to get that pasture or two across their fence line. And it was all a big scheme and plan. These are not unrealistic stories, ladies and gentlemen. And I've got to turn the page because we've passed a lot of bills here. In the time I've been here, going on 4 years, we've passed a lot of bills trying to solve these problems. I'm not going to talk too much about the bills. I just want to go over some of them. Since 2013, House Bill 1224, House Bill 1229, House Bill 1298. We went for about 7 years, and then we came in with the original red flag, House Bill 1177. Then we came a year or two later and went to House Bill 1355, Senate Bill 078, this is in 2021, House Bill 1255, Senate Bill 256, House Bill 1298, House Bill 1299. This last year, House Bill 1086, all trying to address this same thing. Well, we've thrown the toolbox at this broken engine. Now we're looking for more tools. But what has happened? Here's what is sad. And I'm not saying this to disparage anybody. I just want to make a point, and then I'm going to finish on something that is important. Crime's up, violent crime's up over 20%, murders are up 50, 60%, 20, 30%. Right here in Colorado, robberies are up 15+%, assaults up 40, 45%, vehicle theft up 112%. Oh boy, it's a mess. It's a mess. Why? Whew. Well, that gets to the real problem. And this bill and others like it don't solve the problem. Ladies and gentlemen, the problem is about the health of the human spirit and the health of our societies. We are sick. Our societies and communities are sick. Our youth are sick. We need to heal. We need to heal our human spirit. We need to heal our communities, and we need to find healing in our societies. But if we don't know what the sickness is, if we don't point to the prognosis of what the sickness is, we can't find the proper remedy. Drug abuse in a drug culture that I've rejected all of my life. Mental health caused by so many things in our society, and technology is not helping us. Societal decay. Norms and values. And I know it's Sunday.
Representative Holtorf, you have 30 seconds remaining.
Thank you, ma'am. The timing is perfect. Those things like family values that are hard in broken homes, when 6 or 7 out of 10 homes are broken. Economic crisis, inflation, crimes and violence. We've got to address what are the real problems so we can seek to solve them. This, ladies and gentlemen, will not change. We'll be back here next year and the year after talking about more gun violence.
Representative, your time has expired.
Thank you, Madam Speaker. I urge a no vote on this, and I urge us to talk about real solutions to the ailing
Holtorf.
problems in our society. Thank you, ma'am.
Please, thank you. Representative Story.
Thank you, Madam Speaker. It's a pleasure to serve with you.
And a pleasure to serve with you.
Members, this bill is about expansion of the parties who can petition for an extreme risk protection order. It provides that licensed medical care providers, licensed mental health providers, licensed educators, and DAs can petition for an extreme risk protection order. It's not a demand on their scope of work. It's an opportunity to report. It's an opportunity to report if they hear something, if they see something, if they witness something that they believe could lead to someone harming themselves or others. It's an opportunity. It is not a demand on the scope of their work. What currently is in place in Colorado is not working often enough. Gun violence is rising, kids are dying, people are completing suicide. Coloradans are demanding that we take action. They have marched to the Capitol recently. They have rallied on the West Steps. Coloradans are screaming for us as legislators to take more action. Insanity is doing the same thing over and over and over again and expecting a different result. Now is the time to take action and provide opportunities for others who hear something, who see something, who know that someone may hurt or harm themselves or others possibly with an opportunity with a weapon. This is why we have to pass this bill. I urge your vote and support on this bill today.
Representative Bradley.
Thank you, Madam Chair. I know this is a very hard topic for all of us, and we have our reasons for how we speak. That doesn't fall on deaf ears. We have stories that shape each of us and why we decide to do the things that we do. The ACLU of Rhode Island had an analysis relating to extreme risk protective orders in March of 2018. The summary of this is the pending legislation would allow family members and law enforcement officers, just those two groups of people, to petition a judge to issue an extreme risk protection order against an individual who legally owns firearms, but who is alleged to pose a significant danger of causing personal injury to others. While the ACLU of Rhode Island recognizes the bill's laudable goal, we are deeply concerned about its breadth, its impact on civil liberties, and the precedent it sets for the use of coercive measures against individuals, not because they are alleged to have committed any crime, but because somebody believes they might someday commit one. The court order authorized by this legislation could be issued without any indication that the person even poses an imminent threat to others. I've talked to you about domestic violence victims, people that are in a toxic relationship who have a significant other that files a false ERPO, and those people are left like sitting ducks. This order could be issued without any evidence that the person ever committed or has even threatened to commit an act of violence with a firearm. I read several examples of this yesterday, one of which left a man dead. The court order would require the confiscation for at least a year of any firearms lawfully owned by a person and place the burden on him or her to prove by clear and convincing evidence that they should be returned after that time. If denied, the person would have to wait another year to petition for return of his or her property. So we are now taking a person's right to self-defense for what we know is that ERPOs do not work to stop homicide and mass murders. Rep. Wilson quoted all the statistics that we needed on that, and that was just law enforcement and mental health providers before we are expanding this broadly. I could actually think about this bill. I could actually think about this bill and go back to my constituents if it was proven to work. And then we have the representative from Boulder and Aurora asking what the controversy is. Taking guns away from people, that there's no evidence that it helps prevent crimes is the controversy. Because of fear, you're taking away my comfort in knowing how to protect my home and my children against an intruder. Even before a court hearing was held and a decision was made on a petition for an ERPO, police could be required to warn potentially hundreds of people that the individual might pose a significant danger to them. Without the presence of counsel, individuals who have no intent to commit violent crimes could nonetheless unwittingly incriminate themselves regarding lesser offenses. The heart of this legislation's ERPO process requires speculation on the part of both the petitioner and judges about an individual's risk of possible violence. But psychiatry and the medical sciences have not succeeded in this realm, and there is no basis for believing courts will do any better. The result will likely be a significant impact on the rights of many innocent individuals in the hope of preventing a tragedy. Any legislation should focus on addressing serious, imminent threats to the public safety while safeguarding robust due process procedures before granting the courts and law enforcement agencies potentially intrusive power over the liberty of individuals charged with no crime. That was their summary. I'm a healthcare worker. I've been a physical therapist for the last 24 years. It's a job that I love, and right now it's a job that I miss tremendously. I have treated whole families. I've treated kids, I've treated wives, I've treated their husbands, and I spend hours with my patients every week. These patients are like family to me. One of the biggest reasons I decided to leave a job I love so much is because I felt our state was in deep trouble and I needed to help. I had a friend, a patient. She was my dental hygienist, and we were thick as thieves. We told each other everything. She would come at 6 a.m. every Tuesday and Thursday, and she was the only one I would have in that room, and we had a lot of one-on-one time together. She had 3 different surgeries on her knee, and I think that anyone that's been through physical therapy can understand the ups and downs associated with rehabbing a knee that then tears again and you have to have another surgery. There were plenty of ups and downs. And please don't stand. The last day of her life, she worked. She saw a few friends of mine that day. She was having a hard day. We were in the midst of COVID. She was a single mom. She knew that her kids were going to be pulled out of school again, and she was going to have to make the decision whether to work and put a roof over her kids' head or leave them at home at 16 and 14, and she felt tremendous guilt about that. She worked at my dental office. There was only 6 people that worked there, 2 dentists and a couple of staff. They were like a family to all of us, to their patients, to her. That day, she was having such a hard day, like we all do. Mental health days, we all take those, we all have hard days, that the owner, a dentist, a healthcare worker, decided to let her go. He felt like she needed the rest. There were no signs. He thought she just needed to go home and kind of regroup. That was around noon. My phone rang at 3 p.m. that day that her 18-year-old son had gone to check on his mom, and she was dead of a self-inflicted gun wound. I said, there's no way. Please don't stand. She would not want that. She will strike us all down. I said, there's no way. Someone broke into her house and killed her. There's no way my beautiful, brave, courageous friend would take her life. This was a mistake. We need to find out the culprit, because there's no way she would have done that. I had just been with her. My friend had just seen her hours before. I, like Rep. Taggart, who gave me the courage to do this today, failed my friend and her 2 beautiful sons. I, as a healthcare worker, her boss as a dentist, both of us, her friends, could never have guessed that our friend with a smile that could brighten the darkest room, that loved being a mom more than anything in this world, would leave her 2 boys on this earth without her. Please don't ask healthcare workers, PTs like me, OTs, dentists, to do the work that only mental health care workers are trained to do. We are not equipped to bear that responsibility. Please don't ask my sister, who is a 6th grade science teacher, who is not equipped to bear that responsibility if a university professor just told you that he is not capable to make that decision either. This bill is too broad, and I respectfully urge a no vote. Thank you.
Representative Catlin.
Thank you, Madam Speaker. It's an honor to serve with you.
And an honor to serve with you.
Thank you. Members, I'm here to make a plea. We all know that violent crime is on the rise, and I'm wondering about the thoughts to take away or restrict a person's access to legal means of defense. I know the purpose of the ERPO is to protect people from actions of an abstinence of somebody they think's dangerous. But if the law could be used to leave vulnerable individuals at risk, shouldn't we think about that? We've heard about angry boyfriends, lovers' quarrels, all of those things. I won't go over that list, but they're in our mind. So if one of these is placed and it leaves people without the means of protection, are we not creating a potential victim because of our good intentions? Dismissing the fears of these individuals that are afraid, particularly young women, could and would be a mistake. No woman or man, young or old, should fear for her or his life. Now, I understand we're thinking we need to do something more. We've done something. This is in place. It has worked. I think we've heard something like 339 cases. But the ones that didn't work or weren't attempted are the ones who get the press. There's been no discussion of what family members and law enforcement have been able to do. But we come today to expand that number of people who could do something. When moms and dads and husbands and wives don't do anything, what makes us think that someone who barely knows you will do something? I'm trying to follow along with logic in regards to a stranger will do something quicker than someone who knows you and loves you. And I'm having a hard time with that. I don't follow that part. By multiplying the people to request an ERPO should be concerning to everybody here in Colorado, because we don't know if we strike someone that could file as being dangerous that day. You know, some of you know me, some of you don't. Some of you might think I'm dangerous. You never know. Some days I look dangerous, I imagine. But that's my point. If I were that dangerous, if I was starting to feel that bad, and my wife, who knows me as good as anybody in the world, if she doesn't think I'm that far out, why would you? You know, it concerns me that either by error or malfeasance, these could be misused to incorrectly applied to someone who owns a gun, but who are not dangerous if those individuals that think he is are not present during a hearing to assess the danger that I pose. It seems like we would do this, file the petition, bring the man in, the person in, and say, "What's up with you?" And I would be able to say, "My cat died," or whatever it is that had me that day. But this happening because someone was impressed by something I said and not being able to say, "This is what I meant by that," puts me back into the system with a nick on my name. Whether I'm in trouble or whether I'm not, mentally or emotionally, I now have trouble with the system. You know, I would rather be working on crime than I would on this. You know, I'm not sure. I've spoken about mountain lions. I've done some of those kind of things. And they're real world things. But I want you to think about these things from my point of view. That if there's a problem and we address it with the person who could be at risk, Wouldn't we have done something right then to have stopped something from happening? If the judge could see, whoa, Mark's got problems, right then we would do something. So I'm concerned about people that are in emotional distress, suffering through the police knocking at the door, or, as we've heard before, kicking the door down, and leaving that person there, feeling violated, feeling like his home's been attacked, feeling like he has, where do I go from here? We didn't help the mental health of that individual. If anything, we may have intensified it. So, colleagues, I want you to think about this today. And I know it probably won't make much difference. But I want you to think about, we make a lot of noise and a lot of news about people that were falsely charged and now they're let out of some terrible sentence, and we all cheer that. Rightfully so, because that person gets out. But we have not done anything about addressing the person who had one of these filed either through malfeasance or error. I think we ought to think about that. I would ask you to please vote no on this bill.
Representative Young.
Thank you, Madam Chair. I don't often come down here when we're talking about a bill, but I have a unique perspective on this particular bill and the work it's trying to accomplish. I've spent my entire career working with children and often their families when they're in pain. And I began doing suicide assessments and threat assessments in the early 2000s. My first, this is in my work as a school psychologist, which I did until I came to this legislature. In 2000, my first suicide assessment was with a girl who was 9 years old. I'm very happy to report that working with her, we did have a successful outcome, but she fits with a whole landscape of children and youth that I've worked with on this particular issue, trying to keep them safe, trying to keep their families safe, working with schools after you had someone who successfully completed, and the pain of the peers who are involved and the families who are involved, going to schools and working with schools in a mental health situation after a parent successfully completed, and the pain that that would cause, and the fear that that would cause for other children who worried about their own parents' safety. So when I saw the current, the original version of the bill and the extension of asking for additional people who can report for ERPO, and it included counselors, but it did not include school psychologists nor social workers. And I asked for the addition of those two professions, since I know that we are highly involved in threat assessment and suicide assessment. Unfortunately, in the state of Colorado, because we have been hit by these things so often, and fortunately, we do have excellent training provided to school professionals who do that. And I see that school psychologists and school social workers and counselors who are involved would take that training and make a very professional decision determining if they felt like they needed to pursue an ERPO. It is difficult for me to talk without tearing up no, sort of revisiting over the years all the many families and youth that I've worked with who have experienced the pain and depth of depression that would lead them to these choices. I am happy to say that with the technology that we have, we've also been successful in schools in warding off contagion with suicides. And I see this as being another success tool that mental health professionals in schools at the very end of making decisions of intervention might be able to successfully use. And I know we've said this at the well before, but the reality is any life that we can save is so important. And I can tell you, after all my years of experience, that it is not just that one life that you're going to impact. You're going to impact the next generation. You're going to impact the peers around those students who don't have to experience this awful loss of a peer. And we know that if you as a parent successfully complete, you automatically increase the likelihood that your children will contemplate suicide and unfortunately successfully complete. So I felt compelled to share this information with you today, and I'm happy to have one-on-one conversations with anyone who would like to dialogue about this. And this is why I will be an aye vote today. Thank you.
Representative Bottoms.
Thank you, Madam Speaker. I want to address this from the concept of mental health. I spent an hour the other day talking about the statistics on this. I don't think this accomplishes what it's supposed to, but let me explain some of the mental health reasons why. So we've had some different people get up here and talk about their training or whether they have the ability. 2 or 3 different representatives said they don't have this kind of training, but they would fall in this category. And I want to tell you a little bit about kind of the history for me on some of this. I have extensive training in this arena, extensive. I've never told you my degrees or background or anything, but I have a lot of training. You have to as a pastor. It's part of the process, it's part of the education. You take seminars, you do everything. We do this with all of our staff. They're extremely well trained to deal with the idea that somebody would be dangerous. We have safety teams at our church that they're trained to see this. So I come at this from 3 decades plus of this is exactly what I do. And I'm going to show you some things with this. And please don't stand for anything that I'm saying here. A few years ago, almost 10 years ago, one of my good friends, and he was a board member in my church, his family had been at our youth camp on the other side of on the West Slope. And he was in Colorado Springs, and his family was headed in a different place and had a head-on collision, killed the entire family. So he came to me. Well, this is how it happened. I didn't know about this. It was 2:30 in the morning, and the 2 sheriffs escorted him to my house and knocked on my door. And one of the sheriffs, who actually just found out a little bit more information about him the other day, but he said, "Can you handle this?" And I said, "Yeah, you brought him to the right place. I am trained to handle this." Now, couple that with the fact that he was a very, very good friend. So we sat for hours at our house trying to figure this out. I mean, you spend the first day or 2 just going, this didn't really happen. Then quite a few hours later, we went over to his house, my wife and I, and we sat there. And our job, we had one job. Basically suicide watch. That was our job. I've done this so many times I can't even count it, where I've interacted with people like this. Over the next few days, we processed some of this. We had the funeral, we did a bunch of stuff. And I knew he was still at risk, just retired from the military, solid guy, but I knew he was still at risk. And so my family and I talked about this. And he was a good friend, but not like this, as I'll explain. My whole family said, why don't we just make him part of the family? And for the next 3 years, every Sunday afternoon, he ate with our family. Because why? These ideas are not 1 week or 2 weeks or a month. These ideas, the concept that a teacher can figure this out, it's just not possible. The idea that we're going to broaden this out to the next door neighbors, that's actually not only not possible, that's dangerous. That's dangerous to us as a people. I got a call one day. By the way, I have about hundreds of these stories, but I'm just going to give you a couple. Got a call one day from a lady that apparently she had visited the church I was pastoring a few months before. I don't remember meeting her, any of that stuff, but she said, or actually a friend of hers called me and said, can you go over to so-and-so's house? I said, I don't know who that is. Gave me the address, I went over there, and the mother of the son was just standing out in the yard, just standing there. Her and her husband both. This is bizarre, but I drove up and got out, and they said, are you Pastor Scott? I said, yeah. She said, our son just took his life. Can you go in the garage? I didn't want to. Who wants to do that? But I go in there, and he's taken his life. So now, that's what I do. I'm saying as a pastor, this is what I do. This is what I have done for decades. When somebody calls me and says, this happens all the time, they will call me and say, can I come talk to you? I don't know them sometimes I do. I'll say, can I come talk to you? Yes, you can. Is there anybody at your church right now? I want to come to your office. Is there anybody there? Yeah, we have the staff, we have this group or whatever. Is there a time I can meet you when no one is there? So we try to figure that out. I've met people at 9 o'clock at night. Call my wife up, because I don't meet with women alone, and call my wife up and say, hey, we're having a meeting at 9. Because why? A couple of representatives already mentioned this. They do not want the stigma that comes along with this. The idea that you would go, and I'm a safe zone a lot more than like a psychologist, psychiatrist. I'm a pastor. Nobody knows for sure what they're coming to talk to me about, but there's a stigma. When we start making this where anybody has this, we broaden this envelope out so that anybody can do this, you're undercutting the actual, if there, and again, I don't think there's legitimacy in the first bill because of this same reason. Maybe police officers, I do think they actually have a responsibility to this to some level. But you're going to undercut this. You vote this bill in, and you're going to undercut people that really need help from getting help. They will never go near specifically, now if they're not a gun owner, maybe, but see, this bill is about gun owners needing this help, not non-gun owners. But if you do this, gun owners are not going to put themselves out there. It's too dangerous for them. They can't take a chance. I know a guy that owns a $30,000 shotgun. He's never fired it. He's never gonna fire it. But under this bill, that gun will be taken. It just sits over his mantle. That's why he bought it. But this gun will be taken for that. That guy's never gonna go down and talk to somebody when he's struggling. It's not gonna happen. He can't afford that. And so we're going to be putting people in danger in the process of saying, well, we're going to help them, which we do this a lot in this house. We put people in danger. We put their lives, their families in danger because we think we've got a plan to fix for maybe this person. And so thousands, tens of thousands, hundreds of thousands, they're at risk because of this person. That's not the way you legislate. You've got to do this from the concept of constitutionality and the rights of the people, and then the needs of the people. And when we get down to the needs of the people, this bill will harm that. This bill will undercut that. And so just from years and years of experience of working with people that are at-risk people, I see it, I recognize it. It's difficult to actually recognize. I'll give you a quick one. The person that shouts the loudest that they're going to commit suicide, they're not the one that commits suicide. That's the way it works. The person that is going to commit suicide, you've actually got to know what those signs are.
Representative Bottoms, you have 1 minute remaining.
Thank you, Madam Speaker. So we're putting this in the hands of people that really don't know what they're doing, and that is a bigger danger. That's a bigger danger. So we're going to isolate a group, set them off to the side and say, we really aren't interested in helping you because, not from us, that's not what we're saying, but that is what they will hear, and that's what will happen with this. So I strongly urge a no vote on this bill. Thank you.
Representative Luck.
Thank you, Madam Speaker. I want to thank the members of the majority who came down today so far, and any others who intend or will subsequent to my remarks. Thank you for engaging. Truly, there are 65 of us in here trying to work through issues that 6 million of people out there are also trying to work through. And it's really helpful to not have to assume what people are experiencing or thinking or how they're processing, but to actually hear it from your own mouths. It struck me for the first 2 years that I've been in this body, and again in committee just last week, how people can have very similar experiences and reach exact opposite conclusions. There was a representative I used to sit next to who survived the Columbine shooting. He was there as a student. He would speak very differently than a representative, now senator, who tragically lost his son in the Aurora shooting. We all have our own stories. I have mine. I remember being a very young girl and being swept up in the evening after bedtime in order to go to the hospital because my grandfather had shot himself in the head. He had shot himself because the medical profession wouldn't believe that he was suffering pain. They thought it was all in his head. And he cried out to them. But he was one of those guys who kept everything inside. So as far as I know, no member of the family knew it was coming. Miraculously and gratefully, he survived that. And he lived for probably another 15 or 20 years. My uncle, however, who suffered from a lot of mental health issues and who nobody seemed to want to help, wasn't so lucky. We had worked with him for months. We had called all sorts of people. He had been on M1 holds. And we thought actually he was getting better. We saw that when the family was around him and supporting him, he was in a much better spot. And one morning, after eating breakfast with the love of his life, they intended to go to the grocery store. She went to get quickly ready. He went outside. She thought that he was going outside to prepare the car, prepare for their trip. But when she came out, she discovered that instead he had doused himself in gasoline and set himself on fire. These are devastating stories that we have heard and that we have lived. Nobody is challenging that. The question is, what do we do about it? Obviously, the members on my side of the aisle don't think that this is the right thing to do about it. Not because we don't value life, but because our understanding of how to best protect that life is to not further put in question the idea of being able to defend oneself. One thing that wasn't fully vetted in my remarks yesterday that I thought about last night and this morning is Thanksgiving. I'm sure many of you have seen those articles that come out around Thanksgiving that talk about how to deal with this type of family member. Insert your political party here. I know in my situation, in these particular stories, my family members did better when they were surrounded by family. Like my colleagues have suggested, I do fear that there will be empty seats increasingly as people fear being turned in by their own family member because they said something crazy that somebody else didn't really understand. But more than that, I fear the disconnect that we are continuing to build within our communities. We need each other. We need each other. I need this side of the aisle as much as I need this side of the aisle to make me whole, to help me grow. The same holds true for those folks out there. So again, I thank you for engaging. And I thank you that you do have different stories that you've shared, that you've reached different conclusions. But how do we balance all of these things? That is the job that we have. How do we balance all of these interests, all of these stories, and make something that is better for those to come than we have right now? And I am a strong believer that the way we do that is by anchoring our ideas and our policies and long-standing, age-old principles. Liberty is an eternally perilous condition, for it compels us to trust one another and to respect the reciprocal nature of rights. Some of you coming to my district might be fearful when you go to my church or our community events, because more than likely every third person is going to be open carrying. That's something that makes me feel secure, but it may not make you feel secure, and I get that because of your experiences. But that is the reciprocal nature. That is the tension that we experience between liberty and security, this age-old tension that we are grappling with in this bill. I desire to live in a society where mutual trust and respect for our God-given rights openly combat dangers of our inherently fallen nature, rather than to live in a polity that strips the individual of all that makes us human in a vain pursuit of security. That's where I fall on this issue. But not to discredit the intentions, but to simply say that what we do should be more than something. It should be the right thing. So thank you for taking the time to grapple with these things. They are weighty questions.
Representative Luck, you have 1 minute remaining.
Thank you, Madam Speaker. And each of us, because we have the ability to push one or the other button, will forever have to live with the consequences of that. Thank you.
Minority Leader Lynch.
Thank you, Madam Speaker. Members, you've heard from the entirety of my caucus, who I must say are far more eloquent with more stories than I have, so I'll be brief. We hold firm that this legislation goes against our constitutional rights. And there are a few times when you'll hear from the entirety of my caucus. And that is when we believe that constitutional rights, sanctity of life, and just bad ideas are being brought forward. Unfortunately, this bill is all the above. Some of the things that we didn't hear enough of, and I'd like to reiterate, is that this bill creates an opportunity for a law that won't get enforced. There's areas and jurisdictions that simply won't do it. I don't think that's good governance. The other thing is, to enforce it, we're going to have to put law enforcement officers in a really dangerous position. This is a tough one to enforce. This is one that as you've heard from all the stories, the laughing, the crying about, folks hold firearms near and dear for different reasons. Not always bad. And it makes people that had no desire or no inclination or no ill will or intent, makes them criminals. And that's just not fair. And it's one thing for the government to take away your constitutional rights, but it's another when you have citizens that are put in that position to take away your constitutional rights. Members, we were against this in 2019 when we believed it was a bad idea. We were hoping that this would be an improvement through its expansion, and it's not. I would encourage a no vote. Thank you.
Assistant Majority Leader Bacon.
Members, as we close out as a sponsor of the bill, I do want to say thank you for a lot of what we've heard today in the last couple of days. Thank you for your candor. Thank you for your willingness to explore. And for many of you, thank you for extending your hands. I heard from my colleague from Douglas County a request to let it begin with him. I'd like to ask that if you'd have me, I'd love to walk with you. My colleague from Las Animas, thank you for bringing up conversations about stigma. we had a chance to talk about what my community faces with that. And for what it's worth, I do think all of us actually in this chamber have an interest in beginning to talk to our neighbors and our families about actually going to therapy, because it's going to take some work to change that culture. We talked also about those who have, if not given the best parts of their lives, their bodies to protect this country. And they too need a hand to say, in return, we owe you these services and these supports. And we've heard about people talking about the need of protection. And I just want to say that we do have tools out there that are similar to this, but we're expanding it to be able to provide similar touch points. There is actually protection orders for domestic violence, to which we actually copied the remand language for your weapons, word for word. But I want to be sure, too, that as we go into the vote on this bill, that we're talking about what it does, the realities of what the bill says, and the realities, not the realities, but the conversation as it touches upon the tension that we are discussing in regards to our rights. So first, just to be clear, this bill is not expanded to your neighbors. The bill is expanded to mental health professionals and licensed health professionals, as well as educators in K-12 and in higher ed. The bill does not also require anyone to report. And I wanted to say that again on the microphone to be sure that we have on the record what the bill does. The bill doesn't just say you need a preponderance of the evidence. It says preponderance if there is an imminent risk that you can prove, not only imminent, but substantial risk. So there is a level to which you have to prove. You have to prove that there is an imminent, you have to prove that there is a substantial risk, not just because you think it's going to happen. Clear and convincing is the highest standard of scrutiny or evaluation, if you will, in the civil protection side. And like I said yesterday, because of the deference to the right, that is why it is required. But even there, you still have to prove substantial risk. And while many of us are concerned about if we would need to report someone, this bill is putting in front of us, we're asking about all those times when we can, for the times that we know we can help somebody. Are we in a position to actually do that? And the answer for many of us in this state are no. We asked to ourselves, if we know someone is in crisis, would you pull the weapons out of their hands? Or would you let it remain there? And regardless of what the answer is for you, for one of those answers, you do not actually have the ability to do that, if not for this bill. But for what it's worth, in regards to some of the talking points that we've had today, I will say that for a lot of us, we have been listening to all arguments and all sides, but we have to caution ourselves not to pick and choose the pieces and the portions. Because I want to point out something, thank you, Mr. Minority Leader, my colleague from Weld County, in regards to thinking about the enforcement of this bill. I just want to put it out there. One of the reasons that we're bringing this is because we have a group of people who might even call themselves minorities that do not have access to this because of elected peoples. It's not just the Attorney General. That politics piece goes both ways. And when you're in a community and you are crying and demanding help, and somebody who is part of the government says to you, no, I'm not sure why that doesn't bother us. Part of the reason we are expanding this bill is so we don't have to confront a wall and a gatekeeper who will not respond to the cry for help. We have put ourselves in the position to have created gatekeepers to safety, where by all accounts, even what I heard today, we are all responsible for that, but some people are in the position from keeping us and accessing that. That is a cause for concern. So instead, we created a space to say, as we have the right to in building statute and law, if we want this to be evenly applied to the state, we will create the avenues, because it has been demonstrated that that is not the case. And so we will not put people in the position to which they will be begging for help and not be able to get it. That is the opportunity of what we have to do with this bill as well, that has not been discussed quite often. And for what it's worth, we do ask these questions. Do you have the right to speak? Sure. But what you don't have the right to do is incite and do hate speech. Do you have right to your property? Sure. But if the public says we need to put a highway through it, we seem to have been okay with that too. And so now when we are in the place of saying, again, if we know someone is going to hurt someone, we will give you the highest level of deference. We are not taking your property forever. But we are going to stand in that tension and choose. And at this point, we have an opportunity to say, this is not the solution for all of our problems, but it is one of the multifaceted pieces. And in that tension, we will stand to put ourselves in a place to prevent another 41,000 deaths. And so on behalf of people who have been asking for help, we will put you in a position to where you can get it. And so members, thank you again. It is tough, but we got to stand in the tension and be sure everyone has access. And that is where we are coming from. And we hope that in concert, we can also talk to people about getting help and change those outcomes. We can also talk to people about how to keep your firearms secured or how to train and use them well. But if you know, not your neighbor, but you are in a position because you have that relationship of how to help someone in crisis, because for all the data we talked about, it didn't work. We didn't talk about all the times that it did. That we are able to do so. And that is worth legislating for. Thank you again, members. We urge an aye vote.
Seeing no further discussion, the question before us is the adoption of Senate Bill 170 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ortiz, how do you vote?
Yes.
Representative Ortiz votes yes. Representative Gonzalez-Gutierrez, how do you vote?
Yes.
Representative Gonzalez-Gutierrez votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Wilford, how do you vote? Representative Wilford, we could not hear you.
Yes.
Representative Wilford votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Herod, how do you vote?
Yes.
Representative Herod votes yes. Please close the machine. With 44 aye, 19 no, and 2 excused, Senate Bill 170 is adopted. Co-sponsors. Representatives Ortiz, Gonzalez-Gutierrez, Herod, co-sponsor. Representative Epps, Representative Wilford, co-sponsor. Please close the machine. Madam Majority Leader.
Madam Speaker, I move to proceed out of order to Senate Bill 168.
Seeing no objection, we will proceed out of order to Senate Bill 168. Mr. Shebel, please read the title to Senate Bill 168.
Senate Bill 168 by Senators Hawkes, Lewis, and Kolker, also Representatives Mabry and Parenti, concerning gun violence victims' access to the judicial system.
Representative Mabry.
Thank you, Madam Speaker. It is an honor to serve with you.
It is an honor to serve with you.
I move Amendment L75 and ask that it be displayed.
Representative Mabry, we need to move the bill first.
Oh, sorry, Madam Speaker.
That's okay.
I move Senate Bill 23-168
On third reading and final passage.
on third reading and final passage.
Thank you. The bill has been properly moved. I'll ask you to restate your motion for the amendment.
I move Amendment L75 to Senate Bill 168 and ask that it be properly displayed.
And Representative Mabry, we're going to back up a step. We need to ask for permission to bring an amendment on third reading. So I'll ask you to withdraw your first motion and proceed to ask for permission.
I withdraw that previous motion and move.
No, ask for permission.
I ask for permission to
Bring the amendment.
to bring a third reading amendment.
Thank you, Representative Mabry. I appreciate that. Members, the question before us is the permission to bring an amendment on third reading to Senate Bill 168. Seeing no discussion, Mr. Shebel, please open the machine and members proceed to vote. Representative Gonzalez-Gutierrez, how do you vote?
Yes.
Representative Gonzalez-Gutierrez votes yes. Representative Ortiz, how do you vote?
Yes.
Representative Ortiz votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative McLaughlin, how do you vote? Representative McLaughlin, you are on mute.
Yes.
Representative McLaughlin votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Mabry, to be crystal clear, I do need for you to move to ask for permission. We do not want to make an error in the motion.
I move to ask for permission to bring a third reading amendment.
Thank you. Representative Herod is excused. Representative Wilford is excused. Please close the machine. With 43 aye, 19 no, and 3 excused, the motion to grant permission for a third reading amendment is adopted. Representative Mabry.
Thank you, Madam Speaker. All right, members, let's try this again. I move Amendment L75 to Senate Bill 168 and ask that it be properly displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. Members, you've heard my co-prime sponsor, tell the story over and over again about how there was a family from Colorado who lost their daughter in the Aurora shooting. And they brought a lawsuit to try to hold a gun dealer accountable in that space. And They weren't seeking financial damages. They just wanted improved safety practices to try one aspect of preventing similar tragedies like that, to try one aspect of preventing similar tragedies like that, just to get them to change their business practices a little bit. And so with this amendment, we want to name this act in honor of their daughter that they lost in the Aurora shooting. So we want to name this bill the Jesse Redfield Gawi's Act for gun violence prevention, or for gun violence victims' access to justice and firearm industries accountability.
Representative Parenti.
Thank you, Madam Speaker. Colleagues, we know that a lot of you have very long histories with this family. We know that many of you have been touched by their story personally, and we ask for and I vote on this amendment. Thank you.
Representative Soper.
Thank you, Madam Speaker. Nothing against the family or the victim here, but I am going to ask for a no vote, and it's for a very specific reason. It's that in committee it brought out that they sued under state law, or at least the Brady campaign shows Colorado law, to try to point out that there wasn't a good remedy. But there was a remedy under federal law, under PLACA, and if they had chosen the federal courts, more likely than not, they would have been successful. And that's the reason why I asked for a no vote. Thank you.
Seeing no further discussion, the motion before us is the adoption of Amendment L075 to Senate Bill 168 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ortiz, how do you vote?
Yes.
Representative Ortiz votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Herod, how do you vote?
Yes.
Representative Herod votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Gonzalez-Gutierrez, how do you vote?
Yes.
Representative Gonzalez-Gutierrez votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Please close the machine. With 45 aye, 18 no, and 2 excused, the amendment is adopted. Representative Mabry.
Thank you, Madam Speaker. Members, we had very lengthy debate on this bill. I believe we've probably spoken more than around 10 hours on this legislation. You've heard me speak at length. You've heard my co-prime sponsor speak at length. Last night, I talked about why it is important to me to work on gun violence prevention legislation. I just want to echo some of the comments made from my colleague from Aurora. We hear a lot about the inner city, urban environments. People talk a lot in a negative way about my district and specifically about crime in my district. Westwood in Denver is in my district. Westwood is one of the communities in Colorado that is most plagued by gun violence. When I knocked doors in Westwood, mothers wanted me to come to the Capitol to do something about gun violence. This is what's happening. My community is impacted by this. That's why I ran for office. I ran for office to fight for my community. I ran for office to fight for my city and my district. And I know that all of us are passionate about that. But I am deeply passionate about that. And I view this legislation as a piece of the puzzle to address gun violence prevention. This issue is, again, I'm going to say it again, this is uniquely an American problem. This is uniquely an American problem. We heard about a shooting, and I really appreciate our colleague from Loveland bringing this up. We heard about a shooting last night, happened in Aurora. Almost every day, we hear about a shooting. Almost every day. Last week, students crowded this building and demanded us to do everything in our power to do something to stop gun violence, to do something to stop gun violence in their communities. Their peers are dying. They're afraid to go to school. They're afraid to go to school. They're sick of active shooter drills. During the campaign season, there was talk of cat litter being in classrooms. And the reason why that was brought up, it was disparaging, but the reality is that I have heard there is cat litter in classrooms, and the reason why is when there's an active shooter situation and a classroom is locked down, they actually set up litter boxes for kids to go to the bathroom when they're locked down. Teachers have said that in Colorado. That was mentioned on 9 News during the campaign. This is the reality that our students are facing, where teachers are having to prepare for lockdown situations. We have to do something about this, and I view this as one piece of the puzzle. Again, there are 120 guns. There are more guns than people in the United States. There are more guns than people in the United States. 120 guns for every 100 people. Every 100 people in this country. And 91% of children that are killed with guns in high-income countries are killed in the United States. We have to do something about this, and I view this legislation as a very small piece of the puzzle. We have to give those who are dealing in uniquely dangerous products an incentive to create reasonable business practices to prevent their products from getting in the hands of dangerous people. That's what the family was trying to do. The family who we honored this morning was trying to do. They tried to bring a company that sold a drum that held 100 bullets for an assault weapon to somebody online without doing any sort of background check. They tried to hold them accountable to say, hey, maybe you should look into who's buying these things, these tools that are uniquely suited to allow the shooting of 100 people in less than a minute. Again, our colleague from Arapahoe County often talks about this is the only tool. This is the only tool that you can use to kill this many people that quickly. This is different than anything else. An assault weapon, an accessory to an assault weapon. If the shooter that night brought anything else in, they couldn't have committed as much damage as they did in the amount of time that they did. And companies that are dealing in those dangerous products should have a reasonable set of standards in place to make sure that their products aren't getting in the hands of dangerous people. Now, again, we've heard a lot about the potential impact on this legislation on companies that deal in things that are not firearms. Last night, our colleague from Mesa County talked about the danger of, or how it might pose a burden if you get to court, if you have to get to court to disprove this. You're not going to get there. No attorney is going to take on a frivolous case because they will be at risk. They will be at risk of having, no attorney in this instance is going to take on a case that would, where the link would be that attenuated. They would be at risk of putting their clients in line under Colorado's laws that prevent lawsuits, that prevent substantial justification. There has to be a tight enough link to make a facial case that the specific action by an industry member could lead to foreseeable harm. That is an incredibly high bar to meet. This is an incredibly high bar to meet. And it's a bar that other industries already have to meet. This sort of civil liability exists for other industries. Colorado uniquely protects the gun industry. Only Colorado, Arkansas, and Indiana protect the gun industry like this. And I'm honored to stand in support of this legislation, and we ask for an aye vote.
Representative Buckenfeld.
Thank you, Madam Speaker. It's still an honor to serve with you.
And still an honor to serve with you.
Madam Speaker, I'd like to ask for the bill to be read at length.
This is a proper motion. The bill will be read at length.
First Regular Session 74th General Assembly State of Colorado, revised this version, includes all amendments adopted on second reading in the Second House LLSNO. 23 to 119.01 Jane Ritter X 4342 Senate Bill 23 to 168. Senate Committees House Committees State, Veterans, and Military Affairs Judiciary. A Bill for an Act. 101 Concerning Gun Violence Victims' Access to the Judicial. 102 System. Bill Summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the reengrossed version of this bill will be available at http://leg.colorado.gov. Current law limits product liability actions against manufacturers of firearms and ammunition to situations in which there was a defect in the design or manufacture of a firearm or ammunition. The bill repeals that limitation. The bill defines the terms firearm industry member, and firearm industry product, and requires. House amended second reading March 25, 2023. Senate third reading unamended March 13, 2023. Senate second reading unamended March 10, 2023. Senate sponsorship Jaquez Lewis and Coker, Cutter, Danielson, Fields, Marchman, Sullivan, Coleman, Fenberg, Gonzalez, Hansen, Moreno, Rodriguez, Winter F. House sponsorship Mabry and Parenti, Bacon, Dixon, Epps, Garcia, Joday, Kipp, Titten, Vigil. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing law. Dashes through the words or numbers indicate deletions from existing law. Each industry member that is engaged in the manufacture, distribution, importation, marketing, or wholesale or retail sale of an industry product in Colorado to establish and implement reasonable controls and precautions related to the industry product and its control, firearm industry standards of responsible conduct. A cause of action is created for a person or entity that suffered harm as a result of an industry member violation of the firearm industry standards of responsible conduct, or for the Attorney General or the Attorney General's designee for enforcement and remedy of any harms caused as a result of an industry member's violation. An intervening act by a third party, including unlawful misuse of an industry product, does not prevent an industry member from being liable. A cause of action may be brought within 5 years after the date that the violation occurred or the harm was incurred. 1. Be it enacted by the General Assembly of the State of Colorado, 2 Section 1. In Colorado Revised Statutes, repeal Part 5 of 3 Article 21 of Title 13. For Section 2. In Colorado Revised Statutes, add Article 27 to Title 5-6 as follows. 6 Article 27-7 Firearms and Ammunition Manufacturers 86-27-101. Short title. The short title of this Article 27 is the 9. Gun Violence Victims' Access to Justice and Firearms Industry 10 Accountability Act. 11-6-27-102. Legislative Declaration. 1. The General Assembly 12 finds and declares that 13. A. The State of Colorado has a compelling interest in 14 protecting the life, health, safety, and well-being of Colorado 15 residents. 16, b, unlawful and irresponsible conduct by the firearm 17 industry pose significant risks to the life, health, safety, and -2, 168. 1. Well-being of Colorado residents. 2. C. Our state and our nation have a long-standing 3. Historical tradition of prescribing standards of responsible for conduct and accountability for industries whose business 5. Practices may cause harm to the public. 6. D. The Federal Protection of Lawful Commerce in Arms 7. ACT preserves states' critical authority to enact laws. 8. Prescribing and enforcing standards of responsible conduct, and 9. Accountability for firearm industry members. 10. EIT is the policy of this state that firearm industry 11 members have a lawful duty and responsibility to take 12 reasonable precautions to prevent foreseeable risks to life. 13. Health, safety, and well-being of the citizens of Colorado. And 14. F. IT is further the policy of this state that victims 15 harmed by firearm industry members' wrongful and unlawful 16 conduct, and public officials acting on behalf of the people of 17 Colorado, shall not be barred from pursuing civil actions. 18. Seeking appropriate justice and fair remedies for those harms in 19. Court, including civil actions for harms caused by negligent 20. Entrustment of firearm industry products, consistent with any 21 limitations or immunities otherwise provided in state or federal 22 law. 23. 2. Therefore, the General Assembly declares that it is 20 for the policy of this state that product liability for injury, 25 damage, or death caused by the discharge of a firearm, or 26 ammunition is not based upon the inherent potential of a firearm. 27 to cause injury, damage, or death when discharged. It shall be -3, 168. 1. The further policy of this state that a civil action in tort for 2. Any remedy arising from physical or emotional injury, physical 3 damage, or death caused by the discharge of a firearm, is not for based upon the inherent potential of a firearm to cause injury, 5 damage, or death when discharged. 66-27-103. Definitions. As used in this Article 27, unless the 7 context otherwise requires. 8. 1. Firearm industry member means a person, firm, 9. Corporation, or any other entity engaged in the manufacture, 10. Distribution, importation, marketing, or wholesale or retail. 11. Sale of a firearm industry product. 12. 2. Firearm industry product means 13. A. A firearm, as defined in Section 18-1-901. 14. B. Ammunition. 15. C. A completed or unfinished frame or receiver. 16. D. A firearm component or magazine. 17. E. A device marketed or sold to the public that is 18 designed or adapted to be inserted into, affixed onto, or used in 19. Conjunction with a firearm if the device is 20. I. Reasonably designed or intended to be used to increase 21. A firearm's rate of fire, concealability, magazine capacity, or 22. Destructive capacity, or 23. 2. Reasonably designed or intended to increase the 20 for firearm stability and handling when the firearm is repeatedly 25 fired, and 26. F. Any machine or device that is marketed or sold to the 27 public, or reasonably designed or intended to be used to. -4, 168. 1. Manufacture or produce a firearm, or any other firearm, 2. Industry product as described in this subsection. 2. 3. Firearm trafficker means a person who acquires, for transfers, or attempts to acquire or transfer a firearm industry 5 product for purposes of unlawful commerce, including, but not 6 limited to, a subsequent transfer to a person who is prohibited 7 by state or federal law from possessing the firearm industry 8 product. 9. 4. Reasonable controls means reasonable procedures, 10. Safeguards and business practices that are designed and 11. Implemented to do all of the following. 12. A. Prevent the sale or distribution of a firearm industry 13 product 2. 14. I. A straw purchaser or firearm trafficker. 15. 2. A person who is prohibited by state or federal law 16 from possessing a firearm industry product, or 17. 3. A person the firearm industry member has reasonable 18 cause to believe is at substantial risk of using a firearm. 19. Industry product to harm themselves or unlawfully harm. 20. Another or of otherwise unlawfully possessing or using a 21. Firearm industry product. 22. B. Prevent the loss or theft of a firearm industry 23. Product from a firearm industry member. 24. C. Ensure the firearm industry member does not promote 25 or facilitate the unlawful manufacture, sale, possession, 26. Marketing, or use of a firearm industry product. And 27. D. Ensure the firearm industry member complies with all. -5, 168. 1. Provisions of state and federal laws. 2. 5. Straw purchaser means an individual who 3. Wrongfully purchases or obtains a firearm industry product on for behalf of a third party who is the actual purchaser or 5. Transferee. The term straw purchaser does not apply to an 6 individual obtaining a firearm industry product as a bona fide 7 gift for a person who is not prohibited by state or federal law 8 from possessing or receiving a firearm industry product. For the 9 purposes of this subsection 5, a gift is not a bona fide gift if the 10 transferee has offered or given the transferor a service or 11 thing of value to acquire the firearm industry product on the 12 transferees' behalf. 13. 6. Unfinished frame or receiver means any forging. 14. Casting, printing, extrusion, machined body, or similar. Article 15, that has reached a stage in manufacture when it may be readily 16 completed, assembled, or converted to be used as the frame or 17. Receiver of a functional firearm, or that is marketed or sold to 18. The public to become or be used as the frame or receiver of a 19. Functional firearm once completed, assembled, or converted. 26-27-104. Firearm Industry Standards of Responsible Conduct. 21.1. This section applies to a firearm industry member engaged in 22. The manufacture, distribution, importation, marketing, or 23. Wholesale or retail sale of a firearm industry product that 24 meets any of the following conditions. 25. A. The firearm industry product was sold, made, 26. Distributed, or marketed in this state. 27. B. The firearm industry product was intended to be sold. 6. 168. 1. Made, distributed, or marketed in this state. Or 2. C. The firearm industry product was used or possessed in 3. This state, and it was reasonably foreseeable that the product would be used or possessed in this state. 5. 2. A firearm industry member shall 6. A. Establish and implement reasonable controls 7. Regarding its manufacture, distribution, importation, 8. Marketing, and wholesale or retail sale of firearm industry 9 products in this state, and 10. B. Take reasonable precautions to ensure the firearm 11 industry member does not sell or distribute a firearm industry 12 product to a distributor or retailer of firearm industry 13 products that fails to establish and implement reasonable 14. Controls. 15. 3. A firearm industry member shall not manufacture, 16. Distribute, import, market, or offer for wholesale or retail sale 17. A firearm industry product that is 18. A. Designed, sold, or marketed in a manner that 19. Foreseeably promotes conversion of a legal firearm industry 20. Product into an illegal firearm industry product, or 21. B. Designed, sold, or marketed in a manner that is 22. Targeted at minors or individuals who are legally prohibited 23. From purchasing or possessing a firearm. 24. 4. In addition to subsections 1, 2, 3 of this section, a 25 firearm industry member shall comply with the following laws. 26. When engaged in the manufacture, distribution, importation, 27. Marketing, or wholesale or retail sale of a firearm industry. 7. 168. 1. Product. 2. A. The Colorado Consumer Protection ACT, Article 1 of 3 this Title 6. 4. B. The Unfair Practices ACT, Article 2 of this Title 6. 5. C. The Colorado Antitrust ACT of 1992, Article 4 of the 6 Title 6, and 7. D. Article 12 of Title 18. 86-27-105. Cause of action for violations of standards of 9. Responsible conduct. 1. A person or entity that has suffered 10 harm as a result of a firearm industry member's acts, or 11 omissions in violation of Section 6-27-104 may bring a civil action 12 pursuant to this Article 27 in a court of competent jurisdiction. 13. 2. The Attorney General, or the Attorney General's 14 designee, may bring a civil action in a court of competent 15 jurisdiction to enforce this Article 27 and remedy harms caused 16 by any acts or omissions in violation of Section 6-27-104. 17. 3. In an action brought pursuant to this section, if the 18 court determines that a firearm industry member engaged in 19 conduct in violation of Section 6-27-104, the court shall award 20 just and appropriate relief, which may include but is not limited 21-2, 22A, injunctive relief sufficient to prevent the firearm 23 industry member and any other defendant from further 20 for violating this Article 27, 25B, compensatory and punitive damages, 26C, reasonable attorney fees, filing fees, and reasonable 27 costs of action, and 8, 168. 1D, any other just and appropriate relief necessary to enforce this Article 27 and remedy the harm caused by the 3 violation. 4. In an action brought pursuant to this Article 27, and 5. Notwithstanding any intervening act by a third party, if a 6 firearm industry member's knowing violation of this Article 27(7) creates a reasonably foreseeable risk that harm would occur, 8. The firearm industry member's violation is presumed to be the 9 proximate cause of the harm suffered by the plaintiff. 10. 5. An action brought pursuant to this section must be 11 commenced within 5 years after the date that the violation 12 occurred or the harm was incurred. 13. 6. A civil action brought pursuant to this section may be 14 brought in 15. A. The county in which all or a substantial part of the 16 events or omissions giving rise to the claim occurred. 17. B. The county of residence of any one of the natural 18-person defendants at the time the cause of action ACCRUED. 19, C, the county of the principal office in this state of any. 20 of the defendants that is not a natural person, or 21, D, the county of residence for the plaintiff if the 22 plaintiff is a natural person residing in Colorado. 23-6-27-106. Limitations. 1. Nothing in this Article 27 limits 24 or impairs in any way the right of the Attorney General, or any 25 person or entity, to pursue a legal action pursuant to any other 26 law, cause of action, tort theory, or other authority. 27. 2. Nothing in this Article 27 limits or impairs in any way. -9, 168. 1. An obligation or requirement placed on a firearm industry 2 member by any other authority. 3. This Article 27 must be construed and applied in a for manner that is consistent with the requirements of the 5 constitutions of Colorado and the United States. 6. Section 3. Severability. If any provision of this Act or the 7 application thereof to any person or circumstance is held invalid, such 8 invalidity does not affect other provisions or applications of the Act. That 9 can be given effect without the invalid provision or application, and to tend this end, the provisions of this Act are declared to be severable. 11. Section 4. Effective date. This Act takes effect October 1, 2023. 13. Section 5. Safety Clause. The General Assembly hereby finds, 14 determines, and declares that this Act is necessary for the immediate 15 preservation of the public peace, health, or safety. -10, 168.
Representative Bockenfeld.
Thank you, Mr. Chair. It's an honor to serve with you.
It's an honor to serve with you as well.
Members, it's a little bit amusing to me, this march that we had here on the Capitol a few
One
days-
moment, Representative Bockenfeld. Members, the reading of the bill at length is concluded, so please return to your desks. If you need to have a conversation, please take it off the floor. Representative Bockenfeld.
Thank you, Mr. Chair. You know, it's somewhat amusing to me, the march that we had on the Capitol here the other day, where we had all these young people who want to blame the gun. The gun's the problem. It's not beyond me if we really want to get to the root of the problem of why we have young people and people creating violence in our society, people who are committing suicide. Why don't we get to the root of the problem? If we want to start blaming things other than the human being themselves that are committing these violations of life or of law. I think we should run a bill and take cell phones away from children. You want to see a march on this Capitol? Let's take away TikTok, Jackass, BeReal, Instagram, YouTube, Snapchat. That's what's poisoning the minds of our children. It's not the gun, it's the cell phone. Mr. Chair, I think it was a mistake to limit debate on this bill. I think most of you have seen that we rolled in a file cabinet over here full of potential amendments. Amendments that we could have still made on this bill, but our hands got tied. That was a mistake. Mr. Chair, I'd like to make a motion that we remand this bill back to seconds.
The motion before us is whether to remand this bill back to second reading. Is there discussion? Representative Parenti.
Thank you, Mr. Speaker Pro Tem. Colleagues, we urge a no.
Representative Luck. Representative Luck.
Thank you, Mr. Speaker Pro Tem. So I rise in support of this motion. we have yet to begin to really dive into the consequences of this bill and the arguments that were submitted to us as for the rationale for this bill. In fact, I have here an article that challenges the opening statement of one of the bill sponsors vis-a-vis the U.S. murder rates compared to other countries, and it dispels that very clearly. We have other amendments to run, we have other information to present, and to fail to be able to take into account these things before we look at destroying an entire industry, because that's what this bill will do. It will destroy the entire firearms industry.
Members, I'm sorry to interrupt Representative Luck. Members, this is third reading. Please keep it extremely quiet. Representative Luck.
Thank you, Mr. Speaker Pro Tem. I've lost my thought process. Let me go back here. So we have a lot of things to consider as we look at eliminating, in essence. That's in essence what this bill will do in practice, whether that's the intention or not. That is in practice what this bill will do, eliminating the entirety of the firearms industry. In Colorado for sure, but it also will have ramifications across these United States. And so we need to be able to have a full conversation about that, a much more robust conversation before we employ this type of action on not only our state but others. Like I said, there are many documents that we have to counter the assertions of those proponents of this bill. This particular article talks about how the United States, it says much of the political thinking about violence in the U.S. comes from unfavorable comparisons between the U.S. and a series of cherry-picked countries with lower murder rates and with fewer guns per capita. We need to be able to hear what these experts have put together. We can't do that right now on thirds. And so I rise in support of this motion to send it back to seconds and to have that full conversation. Thank you.
Representative Bockenfeld.
Thank you, Mr. Chair. Staff reminded me that my motion was somewhat out of order, and I'd like to restate it. I would like to refer this bill back to seconds.
Thank you for clarifying your motion. Representative DeGraff.
Thank you, Mr. Chair. I'm standing, not rising, in support of this motion for the reasons that we need to have this full discussion. This discussion was truncated yesterday, and that's unfortunate. There's a lot. Legislation of this magnitude should not be done as a team exercise, a team sport exercise. Now, I do appreciate my colleagues leading off with a joke. I think that's, especially given the gravity, I think the joke was, no attorney will take on a frivolous case. That did get a chuckle, and I do appreciate the humor involved in that. But I am wondering, going to PLCAA, and that we should actually look at the entirety of the law, where the possibility of imposing liability on an entire industry for harm that is solely caused by others is an abuse of the legal system, erodes the public confidence in our nation's laws, threatens the diminution of a basic constitutional right and civil liberty, invites the disassembly and destabilization of other industries and economic sectors lawfully competing in the free enterprise system of the United States, and constitutes an unreasonable burden on interstate and foreign commerce of the United States. So notwithstanding the very good intentions of my colleague and the very deep problems that plague our state, but ultimately we're talking about self-control. And we need to address, perhaps, does this deal with the heart of the issue, which is a heart issue? Or do we just paper over it and we say, we're going to do something because doing something makes us feel good? Whether that something is legitimately based, we've already looked at some of the stats that have been proposed, that this is a uniquely American problem. Another uniquely American problem is liberty. Liberty itself is a uniquely American problem. And there is a tumult of liberty, and there is a quiet of servitude. These types of laws move us over to the quiet of servitude, and we need to make sure that that quiet of servitude is really where we want to send our constituents, because this does send our constituents down there. Why is the possibility of imposing liability on an entire industry for harm that is solely caused by others? We are talking about third-party liability here. Third-party liability. And we couldn't even eliminate concealability. Why? Because this was viewed as a team sport exercise.
Representative DeGraff, be a little bit careful about the team sport references. I know what you're trying to do, but please stick with why this bill should go back to second reading.
Thank you, Mr. Chair. I think it should go back to seconds because we did not have the full discussion. And having the full discussion would be making it a discussion. Points presented, points countered, points represented. Coming out of motions made, motions accepted. Coming out of committee did not make this bill a whole bill. Coming out of committee just meant that it had some merit to be considered on the floor. That's it. This level of legislation should not be considered odious if it reaches 10 hours. This type of legislation, this type of infringement, potential, let's say just potential infringement on the unalienable rights, and then the Bill of Rights itself, this should be a discussion that takes days, if not weeks. That we consider it a problem, that we consider this a problem to say, man, we did 10 hours of discussion on this. It wasn't 10 hours of discussion, it was 10 hours of us talking. This is a high degree of legislation. What are we talking about? Imposing liability. What are the risks of this if we do it wrong? The diminution of a basic constitutional right. And really, everything in here, everything in this law is pretty much addressed in placa as don't do it. But it does give I can't really find it, but it does say the use of firearms and ammunition in the United States are heavily regulated by federal and state. And that's the only thing, I guess, that's what allows the states to more heavily regulate. I can't find the phrase that's used in there, that's used for justification, but that's all right. But that they're heavily regulated. So when this came out, when this was put in, it was that the rules around this are already heavily regulated. And so our solution is to more heavily regulate them, is to say, you know what? Every piece of paper and every bit of ink that we put on this problem before didn't solve it. You know what we should do? We should do the same thing. Somebody just briefly said and I do appreciate that we actually did have a discussion this morning. Doing the same thing over and over is insane. Taking another piece of paper, taking another 15 pages or whatever this is going to end up and putting it on top of this is insane. And we need to have a more careful discussion. It needs to be a careful discussion. 10 hours is not a careful discussion. The idea that we need to jam through as much legislation, when you tell your constituents, does anybody tell your constituents that this body is going to pass 700 laws in a year? Do they look at you and go, wow, that's awesome? Because usually when I talk to my constituents and I say, how many laws do you think we could pass legitimately in 120 days? And they will say, I don't know, 10, 12, maybe 50 at highest. And then when you say 500, and they're, well, no, it's not even 500, it's 600, 700. They look at you and their jaw just absolutely drops because there are not 600 good ideas in a year. This is not a good idea. The Congress told us it is not a good idea because this is an abuse of the legal system. It erodes public confidence in our nation's law. It threatens the diminution of basic constitutional right and civil liberty. It invites the dissembly and destabilization of other industries and economic sectors lawfully competing in the free enterprise system of the United States. And for what? We have a couple lawyers, God bless them, but they're telling us no attorney will ever take a frivolous lawsuit. And that still gets a good laugh. I think I'm going to use that one a lot. No attorney is going to take a frivolous lawsuit. A frivolous lawsuit, it's a risk reward. Why would they take that? Because just the very risk of putting this type of legislation is considered a threat. The possibility of imposing liability on an entire industry. It's not the act of imposing, it's the possibility. Congress looked out at this and said, if you consider the possibility of this, this is implementing the possibility. This is implementing everything that PLACA has said, and the justification is that, well, it's already heavily regulated, so what's another regulation? It's wafer thin. We need to have a conversation around this. The goal, the purpose of this body is, well, maybe not. When I came here, I had hoped that the purpose of this body was not to rubber stamp as much legislation through this room as possible. I was clearly mistaken in that. But I would really like to get back to doing the business of the people instead of doing business on the people with legislation like this. I get it, the intent. The intent is wonderful. We want a limit. We want to hold people responsible. There are responsibilities. There was, for the namesake, we've already discussed that there was another avenue. So many of these bills that we're talking about, there has been other avenues. But we don't look at the other avenues. We don't look at the other and look and see, does that need something? Could we just do that? No. The solution of this body is to throw another law on top, to put another law in those red books that nobody reads.
Representative DeGraff, you are
Yes,
out of
sir.
time. I'm sorry I didn't give you the warning. I didn't want to interrupt your flow.
Thank you, sir.
Representative Bockenfeld.
Thank you, Mr. Speaker Pro Tem, and my apologies. Must be lack of sleep these days.
You know, I'm not worried about it. I just thought I would clarify for you. When it's the House, it's Speaker Pro Tem. When it's Cow, it's Chair. I'm not too hung up on it. I just thought I would clarify. Representative Bockenfeld.
Thank you very much. Now I'm well educated. Mr. Speaker Pro Tem, I want to talk about re-referring this bill back to seconds, and if you'll bear with me. We heard the bill read at length, and I think that most of the members here, when the bill was read at length, can understand the complexity of this bill, and I think it's also important that we read the fiscal note at length, and hopefully to entice members to agree that this bill needs to be re-referred back to seconds. So if you'll bear with me, in regards to Senate Bill 23-168, the fiscal note is LLS 23-0119. The prime sponsors are Senator Yaquez Lewis and Senator Kolker. The representatives are Representative Mabry and Representative Parenti. The fiscal analyst on this bill is Clayton Mayfield. The bill does generate state revenue. The bill does generate state expenditures. There's no state transfer. There's no Tabor refund impact. There is a local government impact. There is no statutory public entity impact. The bill allows a person or entity to bring suit for damages against the firearm industry members. Starting in fiscal year 2023 to 24, the bill may minimally increase state and local expenditures and revenue on an ongoing basis. In regards to the appropriation summary, no appropriation is required. In regards to the fiscal note status, the fiscal note reflects the introduced bill. So let's talk about the summary of the legislation. The bill repeals the limitations on claims that can be brought against a firearm manufacturers. It allows a person or entity to bring claims for damages against firearm industry members who violate standards of responsible conduct specified in the bill, and provides that a firearm industry member must comply with the Colorado Consumer Protection Act, the Unfair Practices Act, and the Colorado Antitrust Act of 1992. So let's talk about state revenues and expenditures. To the extent that the civil cases are filed, the bill may increase state expenditures for the Judicial Department and the Department of Law as described below. Any corresponding increase in fine and fee revenue is expected to be minimal. So the Judicial Department. The bill has the potential to impact revenue and workload in the trial courts. However, it is assumed that most firearm industry members will comply with the provisions of the bill, and any revenue and workload increase will be minimal. I think that's I'm sorry, I don't mean to divert from the fiscal note here, but I think that's an interesting analysis that's done on this bill. It's basically saying that the industry will comply. They must believe that because they must believe that the industry already complies as much as possible and it didn't need a bill. The state revenue from civil filings are subject to Tabor. So let's talk about the Department of Law and the impacts there. The bill gives the Attorney General the discretion to initiate actions under consumer protection and antitrust laws, which the fiscal note assumes will be accomplished within available department resources. Again, the analyst doesn't believe there's going to be a huge impact. What is the necessity of this bill? State revenue from the penalties in these actions is typically classified as a damage award and not subject to Tabor. To the extent the bill results in any legal challenges, the department will seek resources through the annual budget process. So let's talk about local government impact. Similar to the state, to the extent civil cases are filed, Denver County Court may experience an increase in workload and revenue. It's interesting that Denver County Court is the one who would experience the increase of workload. I guess maybe other counties aren't as impacted as much. This is a Denver County law, not a Colorado law. That's what it tells me. Any workload for district attorneys is anticipated to be minimal. as consumer protection cases are typically handled at the state level by the Attorney General. Effective date. This bill takes effect on October 1st, 2023. In order to prepare this fiscal note, the following contacts had to be made. Counties, the Judicial Department, the Department of Law, and municipalities. Mr. Speaker Pro Tem, I'm going to restate the fact that we rolled in a file cabinet over here full of potential amendments on this bill, and we were not given the opportunity to make those amendments because there was limited debate. I ask that you please vote yes on re-referring this issue back to seconds so we can have full discussion on this bill, so we can make sure that it's worth our time and effort. Apparently, the fiscal analyst didn't see a heck of a lot of impacts from this bill. It feels good. But I think we're regulating the wrong item. I'm going to go back to the fact and restate, let's go after those cell phones. That's where the poison is. The poison's at TikTok. The poison's in YouTube. The poison's in Snapchat. The poison's in Be Real. They're poisoning our children's minds. And there may be some adult minds being poisoned too by these websites. But what have we done? We know China's behind TikTok. If anybody's done any due diligence, you'd realize that we've been under attack. We've been under attack for a number of years. That's what's poisoning the mind of our children. But what do? There's a big battle going on in Washington, D.C. today. Oh my God, what should we do about TikTok? And guess what? We got parents. You know, the same parents that are down here marching with their children at the Capitol last week. We got parents that says, oh my God, don't take TikTok away from my child. We got some of them that are in TikTok themselves. I mean, they're, oh my God, let's get rid of the guns, but don't you touch TikTok. Don't you touch Snapchat. Now, I have this debate with my children because my grandchildren, you know, they're just like everybody else's children and grandchildren.
Representative Bockenfeld, you are out of time.
Thank you very much, Mr. Speaker Pro Tem.
Representative Wilson.
Thank you, Mr. Speaker Pro Tem. I'm a little concerned at the amount of knowledge the previous representative has about cell phone apps and social media apps, and wow. This bill needs to go back to seconds. This bill is kind of the 7 degrees of Kevin Bacon in law, where anything that touches anything in any way can be liable. There is an extremely concerning clause in this bill which would allow for a member of the firearm industry to be sued for a third-party misuse of the firearm. An intervening act by a third party, including, but not limited to, the unlawful misuse of a firearm industry product, does not prevent a firearm industry member from being liable for harm caused by a firearm industry member's violation of this article. This would put innocent people at risk for being held liable for other people's criminal actions. No one should have to live in fear of being punished for the crimes committed by strangers who they had the misfortune of selling a product to. You know, we offered some very reasonable amendments to protect businesses, to protect peoples, to protect other states from getting trapped in our web, and they were turned down. I think there is plenty to do, plenty of work still to be done on this bill. This bill places blame on firearm manufacturers and retailers rather than actual criminals. The state of Colorado should be focusing its energy on its limited resources when it comes to mental health and prosecuting actual criminals rather than penalizing private businesses for failing to police their own customers and their own additional businesses. Most of the reasonable controls listed in this bill are not reasonable exceptions to put on private business. How is a firearm industry expected to unfairly identify straw purchasers and people who intend to hurt themselves or others? This bill asks for profiling. I was told yesterday it doesn't ask, but all you have to do is read the bill. Reasonable control means reasonable procedures, safeguards, and business practices that are designed to implement to do all of the following. One of those following things is a person in the firearms industry member has a reasonable cause to believe it's a substantial risk of using a firearm industry product to harm themselves or unlawfully harm another, or of otherwise unlawfully possessing or using a firearm industry product. So if you're a business owner in this industry, and the paper every morning says, banks are robbed by people wearing bandanas more than any other person, and you have somebody walk in your retail store wearing a bandana, this says you are liable for that. You better make that decision when you see that person in the bandana that you will not sell to them. And I think you can see where that's going and how we control firearms in that way. People working within the firearms industry are hardly therapists or friends of their customers. How are they expected to flawlessly know when a purchaser of a firearm has a bad intention? Well, you have to profile. It is senseless to allow individuals to sue manufacturers, sellers of a product because the manufacturer or seller misjudged the intentions of their buyers. In this previous bill that we just voted on, we talked about how often we misjudge people's intentions. We miss the signs. And now we're taking the same idea that we applied in red flag and saying now the seller has to do that. So, going back to the previous bill tied to this bill, we want teachers, therapists, police, all these people to judge whether or not a person is capable, but now we want the retail dealer to do it also. And we want the industry to realize it when they use a business associated with them. This bill is not intended to protect consumers or regular citizens. It's intended to devastate the firearm industry of Colorado by making the industry's businesses intolerably risky. You know, we hear about frivolous lawsuits all the time. I spilt my coffee, I'm gonna sue, and some lawyer comes running going, I'll help you. I'm walking, staring at my cell phone, and I trip over the step. Well, it's the step's fault. Let's get somebody in here to sue. The wording of this bill not only would attack firearms distributors and the manufacturers of guns and bullets, it would also place legal responsibility on manufacturers or distributors who dare to make the parts for firearms. I don't know if you guys know what a firing pin looks like, but it looks like a nail. So somebody, I'm glad you do. So somebody making basically nails could be sued for something they had, hey, I was just asked to make this product. My brother-in-law is a machinist. He gets all the time orders to make pieces of steel look a certain way for something an industry needs that he may not know what that industry needs. He usually knows, but it's not, they might be manufacturing cement nailers. Those have some of the same parts. So he manufactures the stuff, and you're going to tell me he's liable when in the other 6 degrees of Kevin Bacon, that he's liable for that. This is a direct attack against the firearms industry. It's a clear abuse of government power and does a serious disservice to Coloradans. I ask you to please send this back. Let's get some of those guardrails on this so that not every business has to be subject to what the firearms industry or a customer might do along the way. Thank you.
Representative Bradley.
Thank you, Mr. Speaker Pro Tem. I agree with this motion to send this bill back to seconds. To me, there are several critical flaws in this bill that have already been eloquently stated by my representatives that have been up here before me. I was pretty upset last night and this morning. I felt like we were debating a very important issue to all of my constituents in Douglas County, and I would think quite a few of yours. Let's not forget that we represent a huge variety of people in our different counties. We weren't wasting time. I think most of us are sick of the word filibuster because it enacts that we're wasting time. For me, we were speaking truth. We were coming up here speaking truth. We were sharing statistics and evidence as to what this bill would do to our communities, the businesses in our communities, the people in our communities. We were cut short of being able to represent our counties. I would love to flip the script. What if we had a supermajority and you guys were in the minority? What if we were trying to get something extremely important to you, get rid of it? Let's take RHEA, for example, Reproductive Health Equity Act.
Representative Bradley, I appreciate the point you're trying to make, but we really do need to constrain it to the subject of this bill.
Okay. What if we strip the right for the republic for which we stand to debate what we find is important? And that's why I think this motion to take it back to seconds, so that we can stand for our community. Because if you want to stand for yours, we should be able to stand for ours. How would your constituents react? I will tell you that if I'm ever in the majority, I will never, ever limit your ability to speak for the people you represent. That's not a republic. That's not what we were elected to do in this House. That's group mentality. It's unbalanced. And I'll use some of your words. It's not fair and it's not equitable. I vote to send this back to seconds. Thank you.
Representative Taggart.
Thank you. That's a good clue. Thank you, Mr. Speaker Pro Tem. It's right here, so you can't miss it now. I knew this bill was problematic when I read the legislative declaration. And I'd like to read to you what it says in letter B. Unlawful and irresponsible conduct by the firearm industry pose significant risks to life, health, safety, and the well-being of Colorado residents. I was a member of this industry for a long time. I think I've told you we were one of the largest manufacturers of hunting knives and pocket tools for this industry. If I was still CEO of that company and somebody sent this to me, I would be enraged. How dare you tell me that my industry, which is the shot industry, which stands for shooting, hunting, and outdoor industry, how dare you tell me that I operate my company in an unlawful and irresponsible manner? Anybody that ever worked for me and ever worked in our industry knew my company was one of the most ethical companies in the consumer product industry. And you just told me I'm unlawful and unethical. Let me go on to letter C. Our state and our nation have a long-standing historical tradition of prescribing standards of responsible conduct and accountability for industries whose business practices may cause harm to the public. Again, how dare you say that to me? This bill needs to go back for more discussion. This bill is wrong in the declarations right up front. It's accusatory. It's demeaning to many of us. There are 52,000 people that attended the SHOT Show this year that are either manufacturers, make the accessories that we tried to get an amendment on, and the retailers. We're saying to all 52,000 of those people, which traditionally for trade shows, maybe 20% of the industry can go to those from a sales standpoint and a retail standpoint, and we just accuse them all of being unlawful and irresponsible right in the declaration. That is not remotely fair. I again rise in support of this amendment going back to second reading. These phrases alone need to be changed.
Representative Luck.
Thank you, Mr. Speaker Pro Tem. So I wanted to point out one other thing that is, I think, a difference between the minority and the majority that encourages me to rise in support of this amendment, which is that we often only get notice of these bills once they're introduced and the public gets notice. It's my understanding that drafts were circulated for this particular bill well in advance of when it was introduced. And so some in this chamber have been able to grapple with these questions for a lot longer period than we have been able to engage around these things for a lot longer period. And so I think it's important that we too have that opportunity to speak into this and to speak into it in a way that the whole public can hear. And so I rise in support of this amendment, or this re-referring motion.
Seeing no further discussion, the question before us is whether to refer Senate Bill 168 back to second reading. Mr. Schiebel, please open the machine, and members, please proceed to vote. Looks like I'm not switched up here. For members just returning to the chamber, the question that we are voting on is whether to refer the bill back to second reading. The machine is open, so please vote. We'll now go to the wall. Representative Ortiz, how do you vote?
No.
Representative Ortiz votes no. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Gonzalez-Gutierrez, how do you vote?
No.
Representative Gonzalez-Gutierrez votes no. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Representatives Doherty, Duran, Harrod, McLaughlin, Titone, and the Speaker are all excused. And as soon as that is done, please close the machine. With 19 aye, 38 no, 7 excused, and I'm sorry, did I not say Representative Duran was excused? Okay, thank you. With 19 aye, 38 no, 8 excused, the motion fails. We are back to the bill. Representative Winter.
Thank you, Mr. Speaker Pro Tem. So after speaking with my constituents over the last couple days about this bill, they're afraid of possibilities. We've talked about it in here before, first step bills. So the way they look at this is something happened and then a lawsuit can be filed. And then once that lawsuit's filed, it leads to basically breaking arms manufacturers. And at that point, it leads to stopping the production of firearms, which can possibly and probably will lead to a forced registration of all guns, which then could possibly lead to voluntary buybacks. And then if that don't meet the goal, would possibly lead to forced buybacks. And then if that don't meet the goal, will lead to confiscation. And what scares my constituents more than anything is that leading to confiscation will lead to conflict. And with that, I urge a no vote on this bill. Thank you.
Representative Bockenfeld, I believe you've already been recognized twice on this particular motion. Let me just confirm with our chief clerk.
The re-refer was the cleanup of the first motion.
Representative Bockenfeld, when you made the re-refer, that was when we were already under the debate of the second motion. When you made the motion to refer back to second reading, then you were the mover of the question, and under that motion you were allowed unlimited times, but you had already spoken twice on the underlying bill. That is my understanding. If we need to clarify, we can take a moment.
Thank you, Mr. Speaker Pro Tem.
You are welcome. Representative Bottoms.
Thank you, Mr. Speaker Pro Tem. So again, I stand in opposition to this bill. There's a lot of danger that comes along to us economically. There's a lot of danger that comes along to us personally. But what we're going to be doing, again, this bill is going to open up the floodgates for litigation. The lawyers are waiting. The lawyers are waiting to gut every single company they possibly can. That's what those types of lawyers do. Some lawyers don't do that, but those types of lawyers, they go after anything they can. And we are now taking this and making the entire industry a low-hanging fruit. And we're going to make it extremely accessible. And they're going to go after, obviously, the deep pockets first, but they're going to attack every form of this industry. Put a bunch of amendments up here that we're trying to say, okay, well, let's try to exclude this group. Let's try to exclude this group. Let's try to keep this group safe. Let's not just open this up for everybody. And every one of these amendments are getting knocked down to enable this to be wide open for all this litigation. Every time we try to close a door that says, well, this group will be a very innocent group of people that are just creating. I think one of the things that was discussed was coats, clothing that has holsters built into the clothing. Well, now that group's gonna be attacked. This bill includes all of them in there, and we did everything we could to try to take that out of the bill, or at least provide some kind of responsible action to protect some of these different groups. And I think that there is such an attack on the whole picture here that it makes it very difficult for us. It makes it very difficult for us as a legislative body to see this and not see that it's going to be attacking everybody. And so the more that we open this gate, the more that we are the ones that are responsible for this. Now we're the ones who are, again, and as I said earlier, we're putting lawyers into place. We're allowing lawyers to be moved into the position of tearing down the constitutional rights of our people. Before, it's directly from the state, and we have that written in the Constitution, so we said we can't do that. So now we're saying, lawyers, you go after them, and you can take people's rights away. You can take manufacturers, gun dealers, all this kind of stuff off the table. And so again, I just stand in strong opposition. I think this is a very dangerous bill, not only a Second Amendment level, but it's a very dangerous bill on an economic level for the state of Colorado. This is going to greatly harm the economy of the state of Colorado. So I ask for a no vote on this bill.
Representative DeGraff. Oh, I'm sorry. I apologize. There was a representative before you in the wall. Representative Brown.
Thank you, Mr. Speaker Pro Tem. I'm a strong consumer advocate, and I think I've demonstrated that through the short time that I've already been in this chamber. I believe that all companies should be held accountable for misconduct that results in death, violence, and other harms. The laws that we have in place in Colorado have shielded bad actor gun manufacturers and dealers from most lawsuits, creating a culture of impunity within the industry. It's clear that our current law blocks legal responsibility for gun manufacturers that have failed to prevent unintentional shootings by innovating, making guns safer, and for irresponsible, reckless, and negligent sales practices that contribute to the flood of illegal firearms into our communities. My community is fed up. We're fed up with catering to an industry that has protections that no one else does. I would never stand for toy manufacturers knowingly manufacturing and marketing toys that were dangerous for children, putting lead in our toys knowingly, and yet we allow these types of things in the gun industry. And what is the result? It's an industry that's incredibly profitable, that sells millions of guns. More than 103 million guns were manufactured between 2006 and 2019. And 2 publicly traded companies account for $1 billion in profits. These special protections create the situation, and they create a culture where an industry views the children in my community as collateral damage. And I'm tired of it. So we can stop that. We can create a culture where there are incentives to make guns safer, to market guns in a way that is protective of safety and health in our communities. But our existing law doesn't do that. It doesn't protect consumers. It doesn't protect our kids. And it's time we change that. I ask that you vote yes on this amendment, or on this bill.
Thank you. One moment, Representative Holtorf. I just want to clarify, with regards to the number of trips to the well, I just spoke with our chief clerk and our reviser of statutes. The motions previously made by Representative Bockenfeld do not count as a trip to the well for the purpose of debating the motion that is at hand, so he will be allowed 2 more trips to the well if he so chooses. Representative Holtorf.
Thank you, Mr. Speaker Pro Tem. Ladies and gentlemen, in this very difficult debate, in some of the comments we just heard. There is something very important that is forgotten. Before I get to that point, I want to mention something in this discussion. First of all, if I were to be carrying a firearm, that firearm would hurt nobody. That firearm would hurt nobody. I could set the firearm on this dais and it would hurt nobody. I could have it in my desk and it would hurt nobody. I could have it in my pickup. I could have it in my apartment. I could have it anywhere and it would hurt no one. And what liability would exist for that particular piece of equipment? Here is what everybody is forgetting to mention that is overlooked in this discussion every time we turn to Senate Bill 23-168. That someone has to have negligence or intent. Someone or something. You say, Representative Holtorf, how can it be something? Well, let me tell you, my good friend was killed in a hunting accident when his hunting dog jumped on the tailgate of the pickup and stepped on his shotgun. It's a tragedy, and I asked no one to stand up. It's a tragedy. He was an expert hunter, and he was doing what he loved. Okay. But there has to be something or somebody that pulls a trigger. Who holds the greatest level of responsibility to do harm with a firearm? Ladies and gentlemen, it is not the manufacturer. It is not the manufacturer. In most cases, it is a person or several people who have been negligent in securing the firearm, storing the firearm, handling the firearm, and that is a human element that you cannot overlook. To the bill sponsors, think about that. You fail to mention it every time. There is a human element here that cannot be refuted. Yet we continue to target manufacturers as if they are out there killing our people, killing our children, killing our youth, committing violence in the streets. That is not the case. The premise of this is that if we go after the manufacturers, I'm going to open the veil, Colorado. This is larger than the state of Colorado. This is larger than crime rates in Colorado. This is a national movement that has come to Colorado that are attacking companies across this country. It infringes greatly on the people that I represent in House District 63 to an extent that I have an uproar I'm dealing with in rural northeast Colorado. The email box has gone into orbit. Why? Because people see through and see what is really happening. This is an attack on an entire industry. And you can sit there and play and run the numbers and talk about, oh, they're making so much money. That isn't even relevant to the question. What people make is not relevant. It shouldn't be in the conversation if we're talking about gun safety, gun violence, and how do we protect our citizens. If you want to talk about that, then listen to what I said on the previous bill. It is a societal problem. And if you think you think this bill's going to stop that, I'm telling you it's not. Yes, there's a lot of guns in this country. There's guns in this country because we are one of the only countries in the world, based on the premise of the Declaration of Independence and those Bills of Rights, that allows for guns to be everywhere in our country as a constitutional right. And there is no country, there is no foreign country that would want to come to this country and invade us. Because not only would they have to fight our military, which is mighty and strong, but they would have to fight every red-blooded American patriot in my district who is well-armed and wants to remain well-armed to protect against enemies, both foreign and domestic. But then this also extends to the individual right to protect yourself and your home and your loved ones. Now, this is where we have a significant rural-urban divide. I heard somebody earlier talking about how they live in the city and they are victims or have been close to in the victimization of gun violence. In many of those cases, it is criminal activity. They are gang members that are shooting at other gang members. They are criminals trying to do something that's a criminal in nature. And that still needs to be addressed and is not addressed in this bill. If you want to go to the root of the problem, you better find out where the problem is. Now, I will tell you, it is no secret, America, that lawyers outside of Colorado are waiting for this bill to be signed by the governor. Because they are going to be the ones, if you want to talk about profitability, let's be honest to the lawyers in the room, it's all about billable hours. And what is my rate in a national gun case against a national manufacturer? It's not 200, it's not 300. Keep going. This is money. It's about making lawyers rich in one hand and going after an industry that the larger gun control activists have targeted. And the battle is being waged right here in the state of Colorado today. I don't want guns to commit violence in the inner city. As a matter of fact, if it was me, I would say, you know what? If you're going to commit an act of gun violence in the city, I'm going to give you maximum minimum. That's right. It's called tough love. 10 years. 10 years. Right now. And everybody out there wanting to play a pistolero would have second thoughts, because that's 10 years. That's 10 years in the can. No grace. Now, for juveniles, I would be different. They need a chance. Sometimes the young people don't know what they do, but sometimes they do. The gang initiation business that goes on and plagues the metro Denver area over here east of the Capitol, it's a hard subject to talk about, but it's real. Some kid goes boom, pops a cap, somebody dies. Those gang rituals are real. We have to break apart this gang culture. That's a real problem. How do we do that? I want to save lives too.
Representative Holtorf, you are out of time.
Thank you. I strongly encourage everybody to vote no on this bill.
Let me just clarify one thing that I've seen from both sides of the aisle. After the time limit runs out, I've seen a number of members add an additional comment. That is not permitted. When we say you're out of time, you're out of time. Representative Bockenfeld.
Thank you, Mr. Speaker Pro Tem. Is it possible for you to give me at least a minute or 30 seconds so I can wrap up my comments?
Yes, you have actually 7.5 minutes.
Thank you very much. Members, one of my former careers was in the banking industry as a special asset lender. And what happened, or just for your information, what a special asset lender does is that when a business starts to struggle and their finances start going south, the bank regulators have to come in and they classify those assets as non-performing assets. So as a bank who makes money on investing money, has to take that loan and set it aside uninvested to protect the equity in the bank. I wish every member in this House had the opportunity to experience what I had to experience. We sometimes had business owners who came in and they were losing their business. They successfully ran that business for years. For years. They raised their family, they sent them to college, and now they're at the prime of their life. And I know some of the members in here have relatives who run small businesses. They grew up in small businesses because they've gotten up here in the well and talked about it. Now, there are several ways that these businesses start failing. They could have been underinsured, had a lawsuit. Now they've lost their retirement. They lost their financial viability to continue to run. They could have had adequate insurance. And they got a lawsuit. And they had to focus on that lawsuit and couldn't continue to market their business. And so the business started sliding. They could have done absolutely nothing wrong. But when you have a legislature that comes along and they all of a sudden change the rules of the game after all these years, guess what happens? You created more risk for that business. And when you create more legal risk, their insurance goes up comparable to the amount of risk the insurance company takes on. So they may be a legitimate business. They may not be one of those no good, rotten gun dealer, people that, we heard about here in the well. They could have been a very legitimate business. But all of a sudden, their cost of business and their expenses have gone up because the risk profile of that business has gone up. And that's what you're doing with Senate Bill 168. You're creating a higher risk profile. So what would happen? Mom and pop who ran the business for years many times would come in, tears in their eyes, and they would want us to try to restructure their financial portfolio so they could continue to run the business. And many times we did that. That was a success. We were able to restructure their debt so they could continue on and be viable. And other times we could not, and we would have to call the loan. But sometimes we had discussions with them. And with those discussions, in order to restructure their business so that they could be financially viable again because of their increased insurance risk in this case, which is what we're creating on these businesses, They had to make adjustments to their business. And where's the first place that they look? Full-time employees. They have to reduce their staff in order to pay the higher insurance premium. The same people, many times, that the folks in this chamber claim that they're here to help, they're hurting. And I don't know how many times I've had to step in this well and tell folks, sometimes we make laws here, we think we're helping someone, but we're actually hurting them. We need to sometimes step back and take a breath and really analyze the long-term effect of what we do in this legislature. But we would get them to cut staff so they could afford to pay their loans and the higher insurance premiums. Sometimes we were able even to get them to make investments in automation, to get rid of those FTEs. FTEs are the largest expense on every business, including this state. 85% of what it takes to operate this state here is salaries and benefits. And it's the same thing with the small guy down the street. So when you hit that yes button and you put this extra burden on the back of small businesses or any business, realize what you are doing. You're kicking the ones that you love the most out on the street, and they're trying to find a new job. And I know in the current environment, you believe there's all kinds of jobs out there. Well, folks, you don't have to listen very far to the business people on the radio and TV to find out that we potentially could be headed towards a recession. You know what happens when you head towards a recession?
Representative Bockenfeld, you have 1 minute remaining.
Thank you very much.
Surprise.
Oh, Madam Speaker. I thought something happened to the Speaker pro tem. Thank you, Madam Speaker. Now I lost my train of thought. But they're through automation, again, they have to cut that major expense, which is salaries and that type of thing, to try to put things back in balance. And when that couldn't happen, unfortunately, many times they ended up in bankruptcy. And that was devastating because many of these small business people, they have their whole lives and their future retirement and everything wrapped up into that business. They don't always have a bunch of 401ks. They surely don't have the little para benefits that we get.
Representative Bockenfeld, your time has expired.
Thank you very much. I ask for a no vote.
Representative Garcia.
Thank you, Madam Speaker, and it is an honor and a privilege to serve with you.
An honor and privilege to serve with you.
Members, I want to just give a little bit of numbers here and share not only why is it essential that this bill pass, but also, unfortunately, why gun manufacturing companies can absolutely afford it if this gun bill passes. We know, we've already heard multiple times that in 2020, more than 45,000 Americans died from fatal firearm injuries, the highest reported in 2 decades. As of late July of 2022, more than 25,000 people in the United States have been killed by gun violence by July of 2022. We also know that at the same time, we're seeing gun manufacturing profits increase. In recent years, they have recorded record profits. In 2021, the largest publicly traded gun maker in the United States, Sturm, Ruger and Company, topped $280 million in profits, setting a new company record. Similarly, profits from Smith & Wesson brands, the second largest gun maker, reached nearly $450 million and reached a new company high. Together, this is a total of $730 million. In other words, $16,222 per life lost. We also know, we have evidence that shows that as gun purchases increase, so does gun violence. In 2019, there were 13.9 million gun purchases, which led to 15,492 homicides and unintentional deaths, 30,198 total number of injuries, 417 mass shootings. In 2020, 22.8 million gun purchases, leading to 19,518 homicides and unintentional deaths, 39,533 total number of injuries, and 610 mass shootings. In 2021, 19.9 million in gun purchases, 20,948 homicides and unintentional deaths, 40,590 total injuries, and 692 mass shootings. According to the Securities and Exchange Commission's filings, publicly traded firearms and ammunition company earnings since the beginning of the pandemic have outpaced previous year's earnings by more than $3 billion. To put this figure into context, these recent years represent the most profitable ever for several gun companies, while for others, they are amongst the highest in the last decade. Gun sales rise and gun makers' profits routinely increase in the aftermath of a highly publicized mass shooting. For example, after the Sandy Hook Elementary School shooting in 2012 and the San Bernardino terrorist attack in 2015, gun sales jumped by 3 million and 1.6 million, respectively. Based on normal buying patterns, these numbers exceeded expectation by more than 1 million sales. In months leading up to these events, the deviation from predicted buying patterns were consistently less than 200,000 extra sales. Members, data, facts, numbers speak volumes. This bill is essential to saving lives, and this bill will not run the gun industry out of business. They make way too much money for that. We saw in New York five lawsuits brought after they enacted their law allowing folks legal remedies. We've heard so many stories. I've shared the numbers. I know we're going to continue to hear reasons for and against, and I appreciate the respectful dialogue that we've had so far today. And I'm going to leave you with a respectful and a desperate request to please support this measure so that we can see accountability in the gun industry. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. Wanted to do that. My community is fed up with criminals on a catch and release basis, where crime is encouraged based on an ideology of redistribution and that views my rights and the rights of my community as collateral damage. What I hear in this bill is we have industrial accountability, but you know what's not in here is individual accountability. And you know what my community is sick of? It is sick of addressing issues by papering over the rights of good American citizens that follow the laws. Law-abiding citizens don't break the laws. That address the issues that are created in this body. Gun-free zones. We hear about these shootings. Where are the shootings? They're in gun-free zones. Why was the shooting the other day, this tragedy? It was enforcing a DEI policy. But we don't do that. We don't look at that. We don't evaluate and go, wow, where could we make a difference in how we do business? We say, no, we're just going to make a new law. And we're going to put it over top, and then we're going to shake our heads that that's not the case. That is the case. What is a unique American problem? A unique American problem to the people that hate it is the liberty that we have. And we have a specific set of rights. We have the right to life, liberty, and the pursuit of happiness. We have a right to life. You don't deprive life, liberty, or property. We have a set of boundaries around those rights because inside those boundaries we preserve individual liberty and individual sovereignty, and we step outside of those and we go into tyranny. These type of laws are truly out-of-the-box thinking. They're out-of-the-box thinking and they go to tyranny. Let's see. Here's something that's ironic. Damage or death caused by the discharge of a firearm or ammunition is not based on the inherent potential of a firearm to cause injury, damage, death when discharged. It is not an inherent risk, according to this bill. So that's ironic. Why do we need to legislate that? Oh, we need to legislate something around here, that's in here, so that we can turn around and impose liability, so that we can have a chilling effect on the legal system, erode public confidence in the nature's law, threaten diminution of a basic constitutional right and civil liberty, and invite the dissembly and destabilization of other industries and economic sectors lawfully competing in the free enterprise. So what's the true crime here? I would say I think it was listed as 280 billion and 150 billion. And it was listed that numbers of crimes and the numbers of guns. But let's look at the numbers of guns. I think I caught 103 million weapons manufactured last year alone. Okay, I'll give you that, 103. Less than 50,000 deaths. Every single one of them a tragedy because every individual is created in the image of God, and that is a tragedy in itself. But that is less than one in 2,000 in every single year that these are manufactured. 2,000 this year, 2,000 last year, 2,000 the year before, 2, 4, 6, 8, 10, 12, 14, 16, 18, 20. Less than 1 in 20,000 and just going back 10 years. The guns are not the problem. Because the discharge of a firearm or ammunition is not based on the inherent potential of a firearm to cause injury, damage, or death, then you take that responsibility, that individual responsibility. You cannot have individual liberty without individual responsibility, and this takes away individual responsibility and therefore twists and takes out individual liberty, and that is the intent. Correlation is not causation. I worked with enough statisticians to know that correlation is not causation, and let's look at those numbers. Let's look at those numbers because data and facts and numbers, they speak volumes. What happens? Sales increased by 3 million and 1.6 million. When? When did that happen? Those numbers went up after those mass shootings. The increase in sales didn't result in mass shootings. The mass shootings resulted in the increase in sales. Bodies like this create the increase in sales in guns because you create an environment that is permissible to crime. We've created an environment permissible to crime. Why are so many illegal guns out there? Because anybody can go outside of a gun-free zone and not only pick up a car, but likely pick up a gun in the process. Because somebody had to put their gun in that car, and then they had to leave. So now a criminal can go pick up a car, go for a joyride, and then they have a weapon so that they can commit the crime. Because 90% of the weapons that are used in crime, over 90%, are illegally acquired. So this will not help that. They're illegally acquired. So what are we going to do? We're going to put tremendous restrictions on the legal aspect. We're going to put restrictions on the 1,999 guns that were not used. And what was the one gun? Most likely illegally acquired. This bill does nothing. It is a trial lawyer's dream. There's a reason that we have terms like ambulance chaser. Frivolous lawsuits. That's how they make their money. Deep pockets. What do we say? 140 million, 3 million, 1.6 million, 280 million, 50 million. That's the true crime here. The true crime here is an individual business. What does that business do? Did those businesses go out and take money from somebody? No, they exchanged value for value. And what was that value for value? That value for value was a protection of their individual life. Why? Because after those shootings, law-abiding citizens decided that they needed to go out and find some means of protecting themselves. Where are all the mass shootings? The mass shootings are in gun-free zones. If you want to solve the problem, this is not it. Get rid of your gun-free zones. Or you know what? You could deal with the heart of the issue. You could deal with, like my colleague said, you could deal with the issues on the First Amendment. Oh, we don't want to take away the First Amendment, and I agree. But there is a level of responsibility there. And we avoid that. And we go, oh, you know what? I got it. We'll go after the guns. 103 million guns produced last year, less than 50,000 deaths. And again, every single one of them is a tragedy. This is not a matter of whether we want to deal with mental health or not. I mean, this bill is crazy, so we should deal with mental health. I get it. But third-order effects. You have third-order effects that a manufacturer is supposed to be able to, not only is supposed to be able to, but is required to. And then you say, well, that would never reach that point where they would actually be involved in a lawsuit. By being named in a lawsuit, they're involved in a lawsuit. We already discussed that. By being named in a lawsuit, that was frivolous. That company was involved in the lawsuit, and it cost hundreds of thousands of dollars just to get out of a lawsuit that they shouldn't be in. Why? Because the lawyers will put them on there and just see what they can do. It's called throwing it up against the wall and see if it will stick. Yes, this bill is a pipe dream for the trial lawyers. That's the only way to see it. You're asking somebody to reach down into the future, predict thought crime. I get it. You want to deal with the problem, but you don't want to deal with the problem. You want to make the problem go away without dealing with the problem. We have a constitution that specifically deals with these issues. And it's not like murder goes away in these other countries. They just do have not, oh yeah, they're going to ban knives in Europe. No kitchen knives. You're just going to have to cook with a butter knife or something. I don't know. Because these things are not, because these are heart issues. Any life that can be saved is so important. If you want to solve the problem of crime, solve the problem of crime. Stop the rotation. If you want to stop people from buying guns, stop creating the need for them to buy guns.
Representative DeGraff, you have 30 seconds left.
Thank you, ma'am. I'm going to stop there just in case I want to spend 30 seconds on something else.
Assistant Minority Leader Puglisi.
Thank you, Madam Speaker. I've never done this before, but okay. So I have some issues, obviously, with the bill in general, but one that I did speak to the sponsors about that I still want to express some concerns with is under a reasonable control section 4, Roman numeral 3. And this says, a person the firearm industry member has reasonable cause to believe is at substantial risk of using a firearm industry product to harm themselves or unlawfully harm another, or of otherwise unlawfully possessing or using a firearm industry product. And the bill sponsors were kind enough to explain to me kind of their rationale behind this. And while I respect that rationale, I still respectfully disagree. What I had asked was if we could raise the standard from reasonable cause to knowingly, because reasonable cause, I thought, while yes, defined in statute, just left too many open-ended questions. So, for example, this is a situation I always think about. So let's say a survivor of domestic violence gets out of the home, goes to safety. She now has to wait 3 days to purchase a firearm. In those 3 days, her nefarious husband decides that he's going to use this provision and call every gun store, because he has plenty of free time, within a 90-mile radius, and tell them that he's afraid that his survivor domestic violence wife, who they don't know, might harm herself or unlawfully harm him. And so what happens next? One of the things as a county commissioner that we always thought about, that I struggle with as a legislator, is what happens next? The bill becomes law, and then it leaves this chamber, but then what happens next? What does implementation look like? So in this scenario, my friends here who are also lawyers will appreciate the hypos that we used from law school. So in this situation, she couldn't buy a gun. Her nefarious ex-husband calls every gun store. They have her name. If they decide to sell her a firearm and disregard this information, and then he attacks her 3 days later, after, again, she's gone through a background check and been cleared, but he attacks her, she shoots him, and kills him, then his family would now have the right to sue the gun manufacturer, firearm manufacturer, because they warned these gun stores, but they didn't take it seriously. Or alternatively, and what I'm really concerned about, is what happens if they take that information and choose not to sell her a firearm, and then her abuser comes and attacks her and kills her. I think that there's just still so much that's gray, and as a lawyer, I don't generally enjoy gray personally, but there is a lot of gray in the law. But I do think this section could be clearer, could be cleaned up, could be tighter. And again, I don't support this bill for lots of other reasons, but that's the provision that really, out of the whole bill, stuck out to me. Because now we're putting the firearm industry in the position of being police officers, cops. I mean, do they have the responsibility now to investigate a domestic violence allegation before selling, even though this person has passed a background check? And I mean, I know from personal experience the amount of time an abuser will spend on trying to hurt survivors. And so I am very nervous about frivolous lawsuits. My colleague from Weld County, when he had gone through this bill, whatever night that was, went paragraph by paragraph and said, this opens the door to litigation, this opens the door to litigation, this opens the door to litigation. I do believe that this provision does open the door to unnecessary litigation, and does potentially bring forward lawsuits that will harm people. And so I think that we could do some more work on this. I appreciate the sponsors for hearing me out and taking my perspective into account, even though they couldn't get there. But I will say that I still have some serious reservations about what implementation looks like when this bill goes into effect. And I don't normally take all my time, Madam Speaker, but I just want to say one other thing before I leave, and that is when I was driving home last night, I was thinking a lot about my good friend from Mesa County, and I really struggled on my hour and 10-minute ride home last night. It was quicker than most of my rides at 11:30 last night. But when I had a really hard time kind of questioning myself. He had brought a great amendment that I thought really did exclude a narrow portion of people and businesses that would be affected by this legislation. It was a good amendment. It really was. And I had spoken to it, and it was late, and I felt like I was fumbling over my words. And literally, my whole drive home, all I kept thinking was, I didn't do a good enough job of articulating it. I didn't do a good enough job of supporting my good friend who brought a really good amendment. And what could I have said to change the minds of people in this room? And I don't know that I could have articulated it better. He actually did a great job of articulating it, and I wanted to support him. But he really did have a good amendment that was very reasonable, and I'm deeply sorry that amendment couldn't move forward for lots of reasons. But I was kind of beating myself up on the way home, thinking that I wish I could have articulated it better to help support you more. But with that, I will stop. Madam Speaker, thank you. I urge a no vote on this bill. Thank you.
Representative Hartsook.
Thank you, Madam Speaker. Pleasure to serve with you.
Pleasure to serve with you.
It's been stated that we have an obsession with guns in this country. See it in the news, you see it in this chamber, you hear it all the time. However, I would say that we have a desire and a passion for freedom. Why do people come to America? They come here for the freedom and the opportunity to pursue whatever it is they want to pursue. And what happens in the world when there's problems? They usually call the United States of America for help. Sometimes it's State Department, but when they need serious help, it's the United States military. I fought on many places alongside with coalition partners. You can look through the history, and whether people agree or disagree with why wars were fought, the fact remains that the United States steps into the breach and helps fight for freedom for people around the world.
Rep. Hartsook.
Yes, ma'am.
Appreciate this. I want to give you some latitude. Just bring it back to the bill.
Yes, ma'am.
Thank you.
Yes, ma'am. In that vein, we teach kids how to drive. At 16, 15 and a half. When my son was ready to hunt, at least big game in Colorado, it's 12. And so I needed to take him through a hunter safety course. I sat with him, we went through the hunter safety course. He had to pass a test, and then he had to go through a shooting exercise. And then it was my responsibility to take him out to the range and practice over and over with the rifles. So when we went hunting, not only did he know how to use his rifle proficiently, because when there's very specific rules when you're hunting big game. If you only wound the animal, you must track it down. And that's a long, arduous process at times. So where's the responsibility in a lot of these things? On the bill, on page 2, it states the General Assembly finds and declares that, paragraph A, the state of Colorado has a compelling interest in protecting the life, health, safety, and well-being of Colorado residents. On B, it says the unlawful and irresponsible conduct by the firearm industry pose significant risks to the life, health, safety, and well-being of Colorado residents. My responsibility was to teach my son how to hunt after he got his license. My responsibility was to teach him how to safely handle that weapon after he finished the hunter safety course. It was my responsibility by the statute and the law that states I have to be present when he's handling the weapon when we're out there hunting. That's my responsibility, not anyone else's. Not the firearm industry. Now my eyesight's not so good anymore as it used to be many years ago when I could hit a target with iron sights at 400 yards, so now I have a really nice scope on my hunting rifle. But we still practice at 400 yards. But that's my responsibility, to teach him. So I ask you, why do we not spend more time and more resources teaching our children about safety of firearms? We teach them about driving. We teach them about drinking. We teach them about drugs. We teach them about math. We teach them about everything in this world except safety when it comes to weapons. And yet we're arguing here about the dangers of weapons and what happens to kids. We teach them the safety when they drive, of speeding, reckless driving. Take a 4,000-pound vehicle hurling down the highway at 60, 70 miles an hour. Mass times velocity squared, that's a lot of force upon impact. We teach them to drive safely. You take a hunting rifle, that's a lot of force when you pull that trigger. We must teach them safety. That's my responsibility. That's an individual responsibility. We should not pawn that off on an organization. That's our individual right and responsibility, not under the Second Amendment, but simply as human beings. It's our job to look out for our fellow person. And part of that is being responsible when it comes to safety. And it doesn't matter if it's a vehicle, drinking, drugs, hunting, guns, and it doesn't matter what I shoot with, what I hunt with, shotguns, rifles, or whether I'm out at the range and having fun and relaxing. As you've heard many times, those of us that are veterans, I personally enjoy sitting on the range and shooting for a day. It's relaxing. Some of you probably wouldn't like that. That's perfectly fine. But it's, for me, fun and relaxing. But I do it safely. I have my hearing protection. I have my eyeglasses. I know who is around that range and where everyone is at. Just like when we teach driving, we teach awareness going down the freeway. What is on your left, on your right, behind you, in front of you? We must do the same thing when it comes to weapons. We teach it on knives. When my son went through Boy Scouts, he had to learn how to whittle with the knife. He had to learn how to sharpen it. He had to learn how to handle it, how to hand it to someone. When he's in the kitchen cooking, you teach him how to cut up meat or the vegetables. There's a right way and there's a wrong way to cut with sharp knives in a kitchen, so you don't cut your finger or cut someone else that's working in the kitchen with you. The same thing applies to guns. Safety is rule number one in the NRA and the manuals. You must handle it safely. Always, always handle it safely. And yet there's people that will do things illegally. There's people that will drink and drive. There will be people that use vehicles to rob banks. There will be people that use guns to do things illegally, hold people up, do shootings. That's not the responsibility of the manufacturer. It's not the responsibility of the people that manufacture the vehicles, the tires, or the guns. It's the individual that is responsible for right and wrong. It is the individual that makes the choice to do right or wrong. Every single day, it's an individual choice. We should never acquiesce that individual choice and lay the blame on someone or something else. That's our responsibility. That's our job. As a parent, that's my job. It is my job to teach that safety, driving, hunting, and everything else that my children will do as young men in this life. I give them the tools. I give them the guidance. I give them the moral compass. If a company does something illegal, that's a
Representative
different story.
Hartsook, you have
Yes, ma'am.
1 minute remaining.
Thank you, Madam Speaker. I shall close with this. Do not pass on that responsibility to someone else or hold something else responsible for what is our job as individuals. I urge you to vote no on this bill. Thank you very much.
Representative Armagost.
Thank you, Madam Speaker. So I get up here as well in opposition of this bill for many of the similar reasons that have already been spoken about, but there's a lot of people that come up and talk about things within the firearm industry that don't necessarily know the firearm industry. I don't get up here and speak on things that I'm not comfortable speaking on, but being that I'm in the firearm industry, I do feel comfortable and passionate in speaking on this. I do consider myself very knowledgeable in the firearms industry, especially since I am certified to teach in it. That'd, I think, be a good expectation to have of anyone. With that, and being certified to train, one of the first certifications I had to get in teaching was through the National Rifle Association. And their certification for teaching and training citizens is much different than that same course that is provided for law enforcement trainers. And that goes also to say for all of my experience being a trainer in the military with firearms, and that the classification of what you call your firearm when you're teaching is, in military and law enforcement, considered a weapon. But in citizen training through the NRA, you will actually get bumped from the course if you can't correct your language in calling it a firearm or gun, but refraining from calling it a weapon. Because when we are training people in these classes for citizens and firearms safety, you're not teaching people that are buying firearms as weapons. You're teaching people that are buying firearms for many different reasons, whether it be for sport, for hunting, for collection, simple sentimental value, even showpieces, even though they are working, not replicas, but working firearms. Some people just use them and keep them for display. That being said, you can't expect, when you are a firearms dealer, a firearms manufacturer, to understand that the person that you're selling a firearm to is going to use it for any reason in particular. And when we're talking about the firearms industry, the community, people that either sell or manufacture or train safety with firearms, you're talking about a very, very tight-knit culture, a very passionate culture surrounding firearms. Where I teach is at my friend's business in Berthoud, Colorado, and that is a small firearms manufacturer. It is not a big, one of the top 5 firearms manufacturers. It is an independent, small-owned business. He creates firearms and firearms accessories for people to use in all different aspects of hunting, of competitive shooting, and otherwise sport and range time, even displays. They are very high-end firearms, but this is a small business. This is a business that if they were to be sued for selling a firearm to somebody who made the choice to go do something nefarious with it, it would ruin him and his entire family. He lives a modest life just like any of us do, and is not anything that you would consider one of the Ruger or otherwise Smith & Wesson, any of the big firearms industries that have stockpiles of millions upon millions of dollars ready for any kind of a lawsuit. This would put him in a very precarious situation by giving people liability to sue him based on not just his firearms, but as is quoted in the bill here, the accessories that he makes as well, because they can increase the destructive capabilities or otherwise rate of fire on a firearm. So in thinking about these communities, these businesses, small businesses, and otherwise anyone in the firearms industry, even myself being included in something that can be harmed by a frivolous lawsuit, which is very capable and probable with this bill to be passed. We're talking about ruining lives. We're not talking about large businesses that have a legal team on standby that can defend and deflect any kind of lawsuit that might come their way, which is going to happen. We're talking about small businesses that can't afford an attorney to go to trial to even deflect or at least lessen a frivolous lawsuit. We're talking about people that would have to go toe-to-toe, take time off of work, let their business run into the ground, and then potentially lose everything they've ever worked for their entire life. So this is one of those bills where I think we should have had more of these conversations in committee. We should have had more of these conversations with the firearms community, not with attorneys or anyone else that might have had a different interest in this, but with the actual firearms community, with the actual firearms industry, those leaders in the firearms industry. Because this could be something where I think it could be an effective concept, and one of my friends in the firearms industry that manufactures and sells firearms, in looking at this bill, called the bill the Sue Everyone But the Criminal Bill. And I don't see that being far off from the truth. I think this is something that we need to be very careful about and moving forward with any more bills like this, but especially this one, and taking care of those businesses. Not only chasing them out of Colorado, but putting small business owners like my good friend Berthad out of business and ruining their lives completely. So I would, for that reason and many more, encourage a no vote on this bill. Thank you.
Representative Frizzell. Thank you, Madam Speaker.
You know, you have heard so much good and pertinent information from my colleagues. And I share their concerns. I share their concerns about frivolous lawsuits. I share their concerns about damaging local businesses and our community members. I share their concerns about broad definitions that include pieces and parts of firearms that may or may not be actually relevant, like tripod manufacturers or sight manufacturers or pin manufacturers. I also share their concern about something that we've talked some on, and that's legislating to the exception. Because, you see, from my perspective, and again, I don't have a broad-based experience, but this is my experience and my opinion, is that when you legislate to the exception, sometimes there are unintended consequences to those who aren't the exception. We'll call them the majority. Sometimes you're penalizing those other people. And again, it's not an intended consequence, it's just an offshoot. And I think that's something that we need to be careful about in this chamber. These topics are emotional. They're important. They're important to a lot of different people. But if we are legislating to a situation that may happen very rarely, as this bill, as it's been described according to this bill, that this isn't something that's going to happen very often. Then is it necessary? And you've heard me talk about, do we always really address the problem? Sometimes we are creating statute that it may or may not be necessary. And I looked through this, and the definition of reasonable controls. And according to this bill, reasonable controls means reasonable procedures, safeguards, and business practices that are designed and implemented to do all of the following. And it talks about preventing the sale of a firearm industry product to a whole bunch of different folks. And it was brought to my attention, And I've actually completed one of these forms myself, and I should have remembered, honestly, but I'm old and my memory's going. But this form, it is an ATF Form 4473. And this is a federal form, therefore the ATF moniker on the form number. But this form has to be, it's a required form. It has to be filled out by anybody who's purchasing a firearm. Anybody. And there are a lot of questions on this form that if you are the purchaser, you have to fill out. There's the usual, your name, address, that information. There's a bunch of information that I don't personally feel would be relevant, like ethnicity. I can't say that, I can't speak anymore. Race, country of citizenship, I don't think those would be necessary, but I didn't make up the form. But the other things that are important and germane to this conversation are, have you ever been convicted in a court? Are you under indictment? Do you intend to sell or otherwise dispose of any firearm listed on the form? In other words, are you a straw, what was it called, a straw purchaser? It also asks, are you an unlawful user or addicted to marijuana, any depressant, stimulant, narcotic drug, or any other controlled substance? Have you ever been adjudicated as a mental defective? That's a bad term, I think. Or have you ever been committed to a mental institution? Have you ever been discharged from the armed forces? I'm not going to bore you because it's late in the day. But again, this is a required form by people who are legally purchasing a firearm, which is really what that particular portion of the statute is geared toward. I'm guessing it's not geared towards people who are obtaining firearms illegally, because they wouldn't be filling out a form. But again, let's look at the intent. Let's look at the intent of what we're trying to do in statute, and I'm sure the bill sponsors will be able to get up here and inform me after I'm done. But I would love to see us not create useless statute in this chamber. And please don't infer that I am calling this statute useless. That's not what I'm saying. I'm saying that I would love for us to be mindful about what we do and the rules that we're creating, because we don't need to be duplicative. Thank you very much. I will be voting no on this legislation and ask for your no vote as well.
Representative Weinberg.
Thank you, Madam Speaker. I rise in opposition of this bill strictly for the local business owners and firearm manufacturing accessories in Loveland specifically. Constituents have reached out for Loveland specifically, and they feel like they were not brought to the table as stakeholders or brought to have that conversation, and they feel, quite frankly, ignored in this conversation. I would ask that we rethink, just very simply, to bring in all the businesses, find out who we're going to hurt in this one, make sure that the language is cleaned up and tight enough that we won't have an issue moving forward. I fear truly for businesses that have been conducting in a positive manner with no issues, shape, or form through many years now, and since Loveland has not seen representation on this specific bill, we are a firm no and ask you vote no. Thank you kindly.
Representative Wilson.
Thank you, Madam Speaker. This has got to be one of the most entertaining bills we've heard. Time after time, we've heard how the bill doesn't do this, and it's followed by an explanation of how it does. We've heard entertaining stories on lead toys, and yesterday it was selling cars to intoxicated people, and even auto recalls. But the funny thing is, these comparisons are not apples to apples. These are more like apples to bricks. Because you see, you can already sue the firearm industry for issues that result in the harm from the firearm malfunctioning. You can sue them. But you cannot sue the brick manufacturer for somebody throwing a brick at you. Just as Craftsman Tools will not be sued for the attack on Paul Pelosi. We hear dramatic numbers about harm caused from firearms, and yet this bill would have no effect on those numbers. Because the actions in this bill do not happen until after the injury or harm has occurred, except by one method, which may be the reason behind this bill. The only method in this bill that would protect those that are harmed by firearms is if this bill put the industry out of business. And I think that's clearly the intent, because it doesn't stop anything. We have talked about unintended consequences of this bill, and we've offered good amendments. We've talked about the profiling in the bill, and we've heard about how no one would sue and, frivolous lawsuits for a harmless accessory like a flashlight. But it even says in the bill, a device marketed or sold to the public that is designed or adapted to be inserted, asphyxiated onto, or used in conjunction with a firearm if the device is, and I'll use the last end of I, to be used to increase the destructive capacity. I don't know about the bill sponsors, but I've actually trained with shooting firearms at night. And I tell you, a flashlight's very helpful. And it does increase the destructiveness. But that won't happen. There's none of these frivolous lawsuits. A sling. We talked about taking a sling off this bill. I don't know if any of you have ever tried it, but I've done what's called a loop sling. And that's when you use the sling to steady your ability to fire, to increase your consistency and accuracy by using the sling. Now, I would think that when a lawyer sees this in this bill, a lawyer that has somewhat of an idea, and I would guess there has not been much in the way of firearms expertise working on this bill. But I would guess that an attorney that knows firearms and knows how to use accessories appropriately could connect almost any accessory to the harm or injury of a person. I just gave you 2 examples. We could give examples all day of an accessory. Does a bipod increase the destructiveness? Well, it steadies the firearm. It holds the firearm. So I would say yes. Any of those items can be used in that method. This bill is either designed to get lawyers rich or designed to end the industry. It would be great if we had an avenue to continue working on this bill, but I don't think that'll happen. So I would just ask that you vote no on this bill. Do not open Pandora's box to lawyers, lawsuits for lawyers. Thank you.
Representative Winter.
Thank you, Madam Speaker. So not too long ago, I took a phone call in my district, actually in my home county, around my hometown. We have Trinidad State College, and it's the #1 gunsmithing school in the nation. And one thing that they're worried about, I talked to one of the gunsmiths, and he said, now Ty, if I build a platform or build a firearm for somebody, which would be legally bought or purchased, and say I legally sold it to him, and then that firearm was transferred somewhere down the road and somebody used it in a heinous crime, would I be responsible for that firearm since I essentially manufactured it? And I mean, maybe if you guys could clarify that for me a little bit. I mean, it's a concern from somebody, and I just wanted to get an answer, because what he's afraid of is you know, if he creates an AR platform, which would be milled and manufactured by him, is that then considered manufacturing? And then if it was used, what he wants to know is, I mean, would it break me? Would it put me in jail forever? Would it break my family? So I just wanted to raise that concern. That's another one of those, I think, valid issues that we need to talk about, because if that's something that would happen, I think it would drive people from wanting to become gunsmiths and then eventually kill the gunsmithing program, which is the main driver of the college that's not only in my district but in my hometown. So that's a concern of some of my constituents, and I, you know, still urge a no vote on this bill, but it's something that at some point, if it could be answered, I'd greatly appreciate it. Urge a no vote. Thank you.
Representative Soper.
Thank you, Madam Speaker. Members, I also rise in opposition of Senate Bill 168. We had a very robust debate on second reading, but I wanted to come down and just hit on a few other points as to why I'm against this particular bill. One is it opens the floodgates for lawsuits. And I appreciated the amendment that was brought in committee for knowingly, and I appreciate the amendment that was accepted on the floor to be able to add back in the common law principle of novus actus interveniens, meaning you'd cut off liability extending to unforeseeable third parties. But the fact that the language in the bill says marketing or so marketing the device or intended to be used to increase the firearm's rate of fire. It's the marketing or intended. When I read PLACA, the federal legislation that's similar to this, it actually says marketed and intended, which is very important that we look at whether or and is appropriate here. And in this case, it really ought to be and to be consistent with federal law. Because if something is marketing and intended to be used in a certain way, I think most of us would be fine to open up the courthouse doors to those particular lawsuits. The bill also is interesting. We heard a lot of debate about the 2000 law that was passed by the General Assembly that certainly blocked access to the courthouse for suing firearm stores and firearm manufacturers. Yet, there's actually nowhere in the bill where Title 13 is even touched. This is all in Title 6. So we actually are setting up an interesting conflict of laws element going forward. Certainly a court is going to have to grapple with that, and perhaps that was the intent, is to allow the courts to be able to decide which title prevails. The reasonable controls on page 5 of the bill, we heard that it would be up to industry practice to interpret how they're going to meet each of these standards. Because what we're incorporating here in statute is that we're creating the duty of the gun store manufacturer that if they market or they fall below their duty and they go ahead and sell a firearm to a straw purchaser or a trafficker, to a person who is prohibited by state or federal law from owning a firearm, or 3, to a person who has a reasonable belief will cause injury to themselves or others, then that store or manufacturer should not be selling to that individual. 2 is really easy to be able to satisfy from a reasonable person standard. That would be engaging in having a background check. But 1 and 3 are much more difficult. How do you know if someone's a straw purchaser or a firearm trafficker? Well, in committee, what we heard is, oddly enough, the manufacturers are probably much more aware of who might be an arms dealer if a particular store is always ordering 20 or 100 or 50 types of rifles or pistols for a particular customer. I mean, perhaps that does indicate, but then we don't know who necessarily is a straw purchaser. And I think we put a lot of pressure on that store and that owner to try to determine, are you purchasing for another person? Are you purchasing for another person? And if they pass the background check and there's no other indication such as a red flag or anything else sitting out there that they could reasonably grasp a hold of to determine whether they're a straw purchaser, they wouldn't know. And then with 3, a reasonable belief of harming themselves or others, we talked about in second reading, clear-cut kind of law school example, phone call rings at the gun store don't sell to this person. They've indicated that they are going to commit suicide. Well, that's a very clear indication. But we all know the real world is not like a law school exam example. The real world is going to be much more murky. And how is that particular store or even the manufacturer going to know whether or not they're selling to someone who's a risk to themselves or others? That's a really, really high bar to overcome, and one that a reasonable, prudent person would say, I'm able to identify that person based on a background check. But what if there's nothing on that background check? You've done everything that would be expected. Now, we heard in committee from the bill sponsors that if you did everything that the industry expected as far as safeguarding whether you're selling to someone that could commit injury to themselves or others, then of course you wouldn't be found liable. Here's where the problem comes. You're still pulled in front of the court to have to defend yourself. Now the burden of proof is on the plaintiff at this point still. But as the defendant, the gun store or the manufacturer, you're still having to get ready for a defense. You're still having to go back and interview clerks and managers, and you're still having to think, okay, what happened? You're still having to pay attorneys, trying to get that motion to dismiss. And all that costs money, and all that will cause your insurance to increase. It certainly will cause you to think, well, what can I possibly do to not be pulled in front of a court from every potential sale? And so they're going to be looking for more mechanisms to raise the bar. And raising the bar is a chilling effect on our Second Amendment rights. Because under the Bill of Rights and under the equivalent in our state constitution, Article 2, Section 13, it only says that the government is prevented from having a chilling effect on our rights to bear arms. It doesn't talk about what happens if it's the private sector that does it. And that's what this bill is leading to. It's putting a lot of pressure from the fear of lawsuits on the private sector, the manufacturers, the retail stores, to go ahead and put that chilling effect that the government cannot put on the Second Amendment. And that's why I'm against this particular bill and will be a no vote. I have appreciated the spirited debate and the conversation that we've had. Thank you.
Representative Catlin.
Thank you, Madam Speaker. It's still an honor to serve with you.
It is still an honor to serve with you.
Thank you. Members, I've sat and listened to a lot of the discussion, and there've been plenty. But I still have some questions in my own mind. So this bill is going to create a right of action for a person that suffered harm as a result of an industry member violation of the firearms industry standards. Have we talked about the standards yet? I guess I missed that. You know, I've heard it compared to the tobacco industry. You know, we had to get the Marlboro Man out of the newspaper. But I'm not sure what we're really talking about as far as industry standards. I think there's some questions that are going to be raised there and probably will end up having to be figured out in court. And the idea that the bill's definition of a firearm industry member is extremely broad and includes any person, firm, corporation, or any other entity engaged in the manufacture, distribution, importation, marketing, or wholesale or retail of a firearm industry product. So in other words, that means to put a lariat around everybody and let them sort themselves out at their own cost. You know, you might have a target in your lawsuit, but we'll put a rope around everybody and let them figure it out at their own expense. It's worrisome to me that this broad definition opens up thousands of entities to potential lawsuits in the event that an individual is harmed or killed as the result of misuse of a firearm by a third party. Are we only going to go to the first third party? It doesn't say. So if, for example, I sold a gun that I bought legally, sold it legally to another person, and they went, and maybe they sold to another one. Let's make it a little deeper. What happens if that third party commits a crime with that weapon and someone's injured or killed? Because there's a chain of ownership, I'm certain. Does it come cascading back to me from the third party that committed the crime? The second guy I sold to, and then to me, through to me, to the place I bought it, on and on and on. I'm not lawyer. I didn't stay at La Quinta last night either. But it makes me wonder, where are we with this? These are citizens shutting down things that we've never thought about having shut down before. I never worried about that. You know, I don't buy and sell guns. I have a few. They're not, they're not a great big deal in my life. But they are a big deal in some people's lives. So the next question would be at a gun show. What happens there? Gun is sold at the gun show. By the way, they're really concerned about that 3-day wait at the gun show. I guess I'm not, I don't understand. I've sat here and I've listened. I've been real attentive. So, you know, those kind of questions linger in my mind. And when I have questions in my mind, it makes me feel like the best thing that I can do is to vote no, because I'm not sure of the intended or unintended consequences that come from this piece of legislation. You know, I have some questions about what percentage of shootings have occurred as a result of an industry member's violation. Do we have any numbers on that? I don't think so. Because if we did, there would have already been something done. I'm afraid that Colorado is going to become a soft target. Sorry for the use of words. But for some of these lawsuits, I'm afraid we are going to be a soft target. You know, and small businesses in my district are struggling. It doesn't matter what business it is, whether it's selling a milkshake or selling a pistol. They're all hurting. You know, and this kind of idea Probably insurance is going to go up, some of the expenses. What does that do to the consumers too? Guns keep going up. Less and less people will be able to buy one, possibly. Is that an unintended consequence or intended? You know, I believe that it is reasonable for families of victims of violence to pursue justice, and we Republicans want criminals to commit heinous crimes to be put in prison. But by allowing a wide range of actors, everything from advertising agencies to the manufacturer, to get the rope put around them and then figure out whether or not they were involved, seems like it's just going to take this massive scatter approach, and everybody involved should be worried, and I think they will be. You know, I don't think it's going to bring peace to these victims, nor is it going to curb the rising violent crime in our state. There are a lot of questions on this bill, and I think that the thought is we have to do something. That worries me about let's do something. You know, the old boy that I work for told me, Mark, I want you to think this clear through. What's it going to look like when it's done? What will you be doing when this is done? And that's the thing I've taken with me since I worked for him, is try to envision what it's going to look like when we're done. I cannot envision this. I think it's going to be a melee. We're told that people won't pick up the lawsuit trail, but I'm not sure of that. We're printing an awful lot of attorneys, and we're getting more and more litigious all the time. So these are the kind of things that concern me about my small district. It's not small. It's great big. But the small businessmen that are there, families that own things, families that are trying. The other question is, what will the value of a gun store be when this is done? If you and your wife had owned a gun store for 30 years, as part of your retirement package was to sell it and move on, what will the value of that be? I think you're going to get a big hit in what somebody might be willing to pay in this marketplace. I encourage you to please consider what I've asked. If you have a question, please vote no.
Representative Evans.
Thank you, Madam Speaker. As with last time, I ask, does this bill work? Does this bill keep us safer? Does it accomplish the absolutely critical goal of ensuring that violence in Colorado goes down? And as we talked at length in this bill, again, I'm afraid the answer is no, for a couple of reasons. We talked about the overly broad definitions found in this bill and how it defines firearm industry member to include not just the manufacturers of firearms, but any other device that could be inserted into, affixed onto, or used in conjunction with a firearm. And again, we talked about a very important word that is found in this bill that I have yet to hear the sponsors mention, and that word is adapted. A firearm industry product is something that can be designed or adapted, its original function changed to be inserted into, affixed onto, or used in conjunction with a firearm. And that casts a very, very broad net. That casts a net that affects a vast swath of industry and lawful business and lawful commerce. And unfortunately, it brings those industry products into a category that currently has very robust protections, but those robust protections come at an economic and administrative cost. You see, currently in the state of Colorado, a firearm, for it to be sold, for it to be transacted, has to go through a robust process that does involve a background check, that does involve filling out a 7-page federally prescribed form that is designed to assess risk factors. And when we roll items like holsters and belts and flashlights into that category, a tremendous amount of liability is being incurred by the industries and the law-abiding citizens and businesses that also manufacture those products by requiring those products to be held to a similar standard as the actual transaction of a firearm. And if that standard is not met, if a background check and a 7-page form isn't filled out when somebody buys a belt, then those industries are also opened up to liability. Because of this word, adapted. Any product can be adapted to be used in conjunction with a firearm. And so my concern is for our industry. We know that there is a rising cost of living. We know that families are struggling to make ends meet. And so is this the appropriate thing to be doing, to be imposing that liability onto our industries? We know there's been robust discussion about this. Does that actually happen? Will these lawsuits actually occur? And as I've said before, if I have a question about it, somebody else probably does. And if they have questions, these are things that will be solved in court with great expense and great liability. And so, what's the natural reaction for someone that manufactures firearms or manufactures products that can be used or adapted to be used in conjunction with a firearm? Well, they're probably not going to be in Colorado very much. And that's the second unintended consequence that I'm concerned about. Because you see, firearms are a valid method of protecting one's life, one's family, one's loved ones, especially during this time of rapidly rising crime that we find ourselves in. I can personally think of situations that I responded to in which citizens lawfully carrying a legally purchased, lawful firearm used that firearm to avoid becoming a victim. I saw them on a regular basis as a police officer. They did not make the news. They did not generate headlines, because a headline that says nothing happened to an innocent citizen isn't very exciting. But firearms are used to protect innocent citizens every day. That's why the purchase of firearms typically goes up whenever bills like this are discussed, because citizens know that at times of rising crime, they can't count on the government to protect them, and they're going to have to do it themselves. I think of situations like the West Freeway Church of Christ on December 29th, 2019. You see, what happened there was a deranged killer walked into that church with the intent on committing a mass shooting. The killer shot 2 people, and then the killer himself was shot by an armed citizen lawfully carrying a firearm. The whole event was captured on video. It's the most clear-cut, justifiable shooting in probably the history of the world. And in that case, a firearm saved lives, to the point where the governor of the state in which this occurred actually gave the concealed carry citizen the Governor's Medal of Honor for stopping a mass shooting. But you see, what happened after that is the part that I'm most concerned about in the context of this bill. Because even though this was a justifiable situation of self-defense in which untold lives were saved by the actions of this citizen who was lawfully carrying a concealed firearm, even though this citizen was acquitted and recognized by the governor of his state, it still cost hundreds of thousands of dollars to defend that citizen in court from the court proceedings that were brought against that citizen. And so when I hear phrases like, oh, frivolous lawsuits aren't brought, I guess I have a hard time believing that. And when we're looking at frivolous lawsuits around a constitutionally protected product that can be legally manufactured, legally transacted, and legally owned, I become very, very concerned about the chilling effect that that has on a lawful industry and on citizens' lawful ability to lawfully acquire a constitutionally protected product. And so with that as the backdrop, I have to ask myself, as I always do, does this policy work? Does anything in this policy take guns away from bad guys? Does anything in this policy do anything to functionally lower crime, stop those people in our society who want to harm their fellow humans? Does it do anything to stop them from having access? And if the answer is to just get rid of firearms completely, well, then maybe it does. But see, that's not really an option that I'm okay with. That's not really an option that I think the Constitution is okay with. And that's not an option that keeps our communities safer. And so for these reasons, I would urge a no vote on this bill, because I believe it jeopardizes the ability of Coloradans to lawfully acquire and lawfully use a constitutionally protected item. So as you think about this bill, as you think about this policy, the question that I ask you to ask yourself is, does it work? In this case, I think the answer is no.
Representative Evans, you have 1 minute remaining.
Thank you, Madam Speaker. And so I urge a no vote on this bill. Thank you.
Representative Luck.
Thank you, Madam Speaker. Imagine for a moment that you are a car dealer and a customer comes into your dealership obviously intoxicated, obviously. Regardless, you want to make a sale, and so you make the sale and give the keys, and that individual drives off and causes harm. If we were to apply the same standards in this bill to that situation, we would open up Goodyear Tire to liability. That seems unreasonable to me. Similarly, imagine you live in Wyoming and you're a legislator there. And you say there is a huge problem with recreational marijuana coming across our border, and so we're going to put in a law that says that if you sell recreational marijuana believing that it will cross into Wyoming, you can reasonably foresee that it will cross into Wyoming, you will be liable for any and all harm caused from Wyoming. That's a term in this bill too. Stated another way, imagine that you sell hunting rifles in Indiana, and someone comes in and purchases a hunting rifle, letting you know that they are planning to go to Colorado to hunt, and they subsequently cause harm in Colorado. You would be responsible under this bill. Or you're a licensed dealer out of Fort Bragg, North Carolina, and an Army man comes in and buys a pistol from you and says in the process that he's being transferred to Fort Carson, Colorado. He moves to Fort Carson, causes harm. You again may be held liable under this bill. That seems staggering, that we would expect an FFL in any state in the union to know our laws. The bill is filled with unclear standards, couched in reasonableness language. Reasonableness as determined by the jury that sits. A jury in my counties would nullify this law. A jury in some of your counties would likely throw the book at whatever industry was sitting in front of them. Unclear standards such as, does this bill require discrimination? Does it require profiling? It says you have to have reasonable standards to protect against straw man purchases, firearms traffickers. How does one do that without knowing the categories of people that tend to be in those categories? And then deciding to put into place the reasonable policies and procedures and business practices to prevent purchases by that class or classes of people. The ambiguity in this law opens up huge amounts of vulnerability. So regardless if a claim is ever filed, the risk created by this bill increases astronomically. And maybe for a Ruger or a Smith & Wesson, it's worth taking the risk. But I already have at least one FFL in my district that's been there for a really long time that is similar to what a representative from the Western Slope shared. They're now looking to sell their business. They're now looking to move out of Colorado. They're an older couple, sweet, and they're leaving. And more than likely, they're not going to be the last. I suspect many will leave Colorado. We may find that purchasing any firearm-related product in Colorado will become impossible. And that might be a utopia for some folks who see the increase in gun violence and say, wouldn't the world be better if we never had guns? But it belies the fact that when we didn't have guns, there was still war, there was still murder, there was still death. In fact, the first recorded murder was with a rock. We see in other countries where they have outlawed guns, where they have removed them entirely, their murder rates are similar, just using different tools. But I don't think that many of our people would actually see that as a utopia, as proven by the increased sales, because many of those increased sales are for first-time gun buyers. And I don't know about you, but I don't know many people who go out and spend $400, $800 on an item that really they don't care to have in most instances of the ones that are first-time home buyers that I've, or not home, first-time gun buyers that I have talked to who have purchased it not because they've always had their eye on a particular piece, but because they are scared. They're scared for where our communities are headed. Recently, I think it was last year, the city of Memphis released a list of all of the individuals in their community who have a concealed carry permit. And they released the addresses of those individuals. What is interesting about that is that shortly thereafter, they saw a shift in their crime trends. You see, everywhere where there was a concentration of concealed carry permits, there was a decrease in crime. And everywhere that there was a lack or limited amount of concealed carry permits, there was an increase in crime. So if we're going to talk about guns, we can't just talk about one side of the equation. We can't just talk about the side that is the infliction of harm as a result of criminal activity. We also have to talk about the other side of the equation, which is the protective nature of even having the item at all, as the Memphis study demonstrates. There was no showing of the weapon, there was no use of the weapon in order to reduce that crime rate. There was simply an awareness within the criminal community of where it would be more dangerous than not to engage in crime. And so they did what most normal people do, and they did a risk assessment and decided, we'll go to the areas that have less risk. Similar to Switzerland, where I lived for some time, where most everybody had a weapon. And in the community I lived in, if I recall correctly, the last murder at the time that I lived there was 20 or 30 years prior with a gun. With murder at all, breaking in and murdering. So as we have this conversation about what the responsibility should be, it's important that we understand the impacts of this, because it will impact the industry.
Representative Leck, you have 1 minute remaining.
Thank you, Madam Speaker. I think it's important to note there was a conversation about, if we had toys that had lead in them, we would want responsibility. That's already in our statute. We already have product liability like that. If there is a weapon that is produced and there's a defect in it or there's a harm in its essence, then the companies will be held responsible. This has to do with a third party doing harm, and that harm being attributable back to the people who created those products. Let's put the responsibility where it belongs, and dare I say, we'll see less violence in our streets. Thank you.
Representative Bradley.
Thank you, Madam Chair. The rep from Louisville said that we need to make guns safer. So perplexing to me. How do we make inanimate objects safer? Guns don't kill people. I'm sure we've all heard this. People kill people. You make guns safer by making those buying guns with ill intent or intent to do harm better. So instead of passing bills to pass the buck, we make mental health treatment more accessible. We're pushing a bill that does nothing to address the root of the problem. Where's the accountability of the gun buyer? When my husband bought me my first gun, I was extremely nervous. I knew that my parents owned guns, but I never saw them or was around them. But I remember being young, feeling extremely protected and safe in our home. My parents were divorced, and while we were staying with my mom, my dad's house got robbed. The thieves literally pulled up a moving truck to our home and stole every piece of furniture, every TV, even the jewelry box that when I was 8 years old that I owned. I remember feeling like a victim. I remember feeling very unsafe. What if these people came back? They had already robbed us once. What if they broke into our house again? And my dad went out and bought a gun. And I remember my dad bringing the three of us into the room and showing us the gun, showing us what it looked like, showing us that it wasn't a toy, showing us that it wasn't something to be played with, showing us that this was something that could take someone's life and the realness of that. And he showed us where he put it. It was loaded, and he showed us and told us to never touch it and to never play with it, that this was something that was serious, that was meant to preserve our life in case something was to happen, someone was to break into our home. We respected him to not touch it, to not go near it, to not play with it. My mom owned a gun. She kept it loaded in her top drawer, and we knew where it was, but we knew also to stay away from that. That was something that was going to be used to defend our right to life. Fast forward to my first gun. My husband showed it to me. I was very nervous, like I said, but he educated me about it. And before we put it away, you know what he did? We went to a shooting range. I got comfortable with it. I knew to understand the consequences of using it. He worked a lot of nights, and for him, it was an assurance that I could defend my life if need be. From that moment on, and I know this sounds really weird to a lot of you, and I try to understand your perception of being fearful of guns, and I really take that to heart because at once I was fearful of the gun that I owned. But for me, it comforted the fact that I could protect my right to life and my home. And guess what? That became so much more important to me when we decided to have children. For me as a woman, with an imbalance of force was ever brought against me, that I would be able to protect my children's right to life and I would be able to protect my home. As my children got older, they begged and pleaded for phones and social media and to be able to play shooting games on their Xbox. Even as gun owners, we had very strict rules barring them from a lot of these things until we felt they could be aware of the consequences of playing games that would subject them to the impartial reality of killing people on a video game versus real life. We have plenty of friends. I have plenty of very left-leaning friends that don't own guns, but they let their children play 7 hours at a time on games that kill people. It's very different in reality than a video game. We made a deal with our children. We told them after they took hunter safety and learned how to use a gun and be responsible gun owners and use them, and went hunting and killed an animal and knew what it felt like to take a life, to understand that death is permanent, we would not entertain it. Last year, my 14 and 16-year-old each shot and killed an elk. They had accountability and were taught safe gun ownership. They had accountability for their actions. They didn't like the way it felt. It was sad for them to take a life, but they knew that they were providing food for our family, and they knew that they were taking the accountability of taking something permanently away from something and how that felt to them. We are taking the accountability away from the person buying the gun with intent to do harm and blaming it on the firearm dealer and manufacturer. Where is the accountability with parents who let their kids play video games, killing people for hours at a time? These children often end up with no perception of reality on gun ownership, but we don't blame the video game manufacturer. If a kid who plays these games gets a gun illegally and kills someone, no, now it's the firearm dealer's fault, and that's not right. This bill teaches people to pass the buck. It defers away from the person actually responsible for pulling the trigger and placing the blame on someone else. It is no different than suing liquor stores and car salesmen for drunk driving, or the phone companies and phones for someone texting while driving. A phone is an inanimate object, and some may say it can kill, but really it would be the person making the decision to hold the phone and text to cause a wreck and kill someone. I agree with the representative from Monument. This bill targets one industry, and I believe that that was the intent of this bill. Taking away the real accountability of the person wanting to pull the trigger with ill intent. Punish criminals who commit crimes with guns and set an example. Show them that choices have consequences and to have accountability. That's what I teach my 4 children. Every action has accountability. When did we stop doing that in this country? Stop assigning blame to everyone except the actual perpetrator of violence. Manufacturers and dealers don't load guns and pull triggers. People do. Thank you.
Representative DeGraff, you have 24 seconds remaining.
Thank you, Madam Speaker. I oppose this bill on behalf of the individual and industrial victims that it will create. No firearms expertise as evidenced in this bill by terms used like assault rifle. Republicans consider criminals to be the criminals as opposed to victims that need to be coddled. You won't put criminals in jail, so you'll put the society in a police state to be oppressed. The communities that need to be protected from themselves are run by Democrats.
Representative, your
That's your
time has
solution.
expired.
I tried.
Minority Leader Lynch.
Thank you, Madam Speaker. It's an honor to serve with you.
And an honor to serve with you.
Here we are again, finishing up another one. And remember what I said earlier, you can be guaranteed to hear from my entire caucus if something's got some constitutionality issues, whether it deals with the sanctity of life, or if it's a really bad idea. This one falls under the really bad idea category. You know, we all come to this chamber and we bring our expertise, we bring what we know to try to make better laws. This was brought by 2 lawyers. They know how to create litigation. People like me and Mr. Taggart know how to run businesses. It was my hope that through this discussion, maybe we could combine those two to make this a little better. We had that opportunity, but because people were in a hurry, it didn't ever happen. We're passionate about these issues. We had some opportunities to make this blow not so bad. We didn't take it. Sad. The other sad part of this is that this bill does nothing to prevent harm. However, it does a whole lot once harm has been done. This bill doesn't do anything until something bad has occurred. Then you've got an opportunity to do something. So I'm not so sure that this sort of litigation is a good thing. Because you can't use this law, which it will become, until there's a victim. And for us to try to promote tragedies, to argue for this, because tragedies are the only thing that leads to a good result, is bad legislation. In the words of one of my colleagues, bad bill, vote no.
Representative Parenti.
Thank you, Madam Speaker. Colleagues, we've spoken a lot about this bill, and I want to just, first of all, thank you all for your patience and your professionalism as we've discussed this bill at length. The corporate gun industry has a responsibility, like any other, to take reasonable precautions to protect human life and prevent unnecessary harm and suffering. And when industry members fail to take those reasonable precautions, they should be held fairly and justly accountable in court, like every other industry, to those who were wrongfully harmed by their actions. Victims of gun violence should have the opportunity to seek fair justice in court when industry actions have contributed to the harm that was bestowed upon them. Without this legislation, we will continue to have difficulty getting the firearms industry to see us as partners in the very difficult task that we have of working towards gun violence prevention in our state. I want to acknowledge many of the concerns that have been brought forth by the Minority Caucus and even agree with some of the concerns. This is not traditionally what we would think of as a gun violence prevention bill. Yes, this bill is not going to keep people from using guns to harm others. That is not the intent of this bill. That is the intent of other bills that we are bringing forth this session, but that is not the intent of this bill. Yes, it's not going to keep someone from harming another person. That is not the intent of this bill. The intent of this bill is to encourage the gun industry to be partners with us in preventing gun violence in this state. It's to encourage the gun industry to take steps to prevent gun violence in this state, to take steps to ensure that their products do not fall into the hands of people who intend to do gun violence in this state. We need them to be partners in this fight. And that means that they have to have a stake in the fight. That's what this bill is about. I also want to address the concerns that we have not had the opportunity to fully debate this bill. This bill was debated for multiple hours in the Senate committee, multiple hours on the Senate floor, 4 hours in the House committee, over 9 hours over the past 2 days, and now, as we've seen, about 4 hours today as well. We have had multiple conversations in good faith about this bill. As the minority leader just acknowledged, every member of his caucus has had the chance to come up today and speak at length for their allotted time on this bill. We have had the robust discussion on Senate Bill 23-168, and it's time to pass it and move it forward. We encourage your aye vote, and thank you.
Representative Mabry, you have 2 minutes and 56 seconds remaining.
Thank you, Madam Speaker. Members, I'll be brief. I just wanted to address something that I said earlier today that I should not have. It has been a long 3 days. I think all of us are tired. I should not have said that lawyers don't bring frivolous lawsuits. Of course they do. But Colorado has laws already to disincentivize frivolous lawsuits. We already have laws to disincentivize frivolous lawsuits, and we have joint and several liability and civil liability caps. What this is about ensuring that this industry is not uniquely exempted from facing any civil liability. Members, we believe quite simply that the firearm industry has a responsibility like any other to take reasonable precautions to protect human life and prevent unnecessary harm and suffering. We just heard a question asked by another member, well, why aren't tire companies subject to civil liability? They are. One of the foundational cases you learn in your first year in law school is about a tire civil liability case. So this is about leveling the playing field and making sure that the firearm industry is not uniquely exempted from civil liability, and we're proud to urge an aye vote. Thank you.
Madam Majority Leader. Please restate our motion.
Thank you, Madam Speaker. I move for passage of Senate Bill 168 as amended.
The motion before us is the passage of Senate Bill 168 as amended. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ortiz, how do you vote?
Yes.
Representative Ortiz votes yes. Representative Doherty, how do you vote?
Yes.
Representative Doherty votes yes. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Representative Gonzalez Gutierrez, how do you vote?
Yes.
Representative Gonzalez Gutierrez votes yes. Representative Herod, how do you vote?
Yes.
Representative Herod votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Snyder is excused. Please close the machine. With 40 aye, 22 no, 3 excused, Senate Bill 168 is adopted. Co-sponsors. Representatives Ortiz, Doherty, Gonzalez Gutierrez, Herod, Wilford, co-sponsor. Please close the machine. Madam Majority Leader.
Madam Speaker, pursuant to House Rule 14, I move that the time for debate on Senate Bill 169 be limited to 4 hours during special orders on March 26th.
Members, the motion before us is pursuant to House Rule 14, debate on Senate Bill 169 be limited to 4 hours during special orders on March 26th. This is a non-debatable motion pursuant to House Rule 15E and requires a simple majority vote. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ortiz, how do you vote?
Yes.
Representative Ortiz votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Representative Doherty, how do you vote?
Yes.
Representative Doherty votes yes. Representative Gonzalez Gutierrez, how do you vote?
Yes.
Representative Gonzalez Gutierrez votes yes. Representative Herod, how do you vote?
Yes.
Representative Herod votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Please close the machine. With 40 aye, 22 no, and 3 excused, the motion is adopted. First on the calendar is special orders. Representative Weissman. Members, you've heard the motion. Seeing no objection, the House will now resolve itself into the Committee of the Whole for consideration of special orders. Representative Weissman will take the chair.
The committee will come to order. With your unanimous consent, bills will be read by title unless there's a request for the reading of a bill at length. Committee amendments will not be read as they're printed and in your bill folders. Floor amendments will be shown on the screen up here and on your iPads. Bills will be laid over upon motion of the majority leader or assistant majority leader, and the code rule is already relaxed. Mr. Shebel, kindly read the title of Senate Bill 169.
Senate Bill 169 by Senators Mullica and Danielson, also Representatives Duran and Hamrick, concerning increasing the legal age for certain conduct related to a firearm and in connection therewith, increasing the legal age to purchase, possess, sell, or transfer a firearm.
Majority Leader Duran.
Thank you, Mr. Chair. I'd like to move Senate Bill 169.
Properly moved. Please go ahead. Madam Majority Leader.
Mr. Chair, I'd like to move Amendment L054 and have it displayed.
All right, 1 second while we get it up on the screen.
No committee reports.
Okay, the amendment is displayed. Please proceed to L54.
Thank you, Mr. Chair. I did move the amendment, L054, correct? It's been a long day. It has always been our intent with this bill to prohibit 18 to 20-year-olds from purchasing a firearm. We have some exceptions in this bill, but that's the purpose overall, period. This amendment focuses the bill on this critical policy to prevent our youth from purchasing firearms and potentially causing harm to themselves or others. As this bill has moved forward, we have continued to refine the policy around possession. Who under 21 should be allowed to possess a firearm, under what circumstances, and with whose supervision. Through this process, and with the continued input of stakeholders and the gun violence prevention community, we have tweaked the policy around possession. At the end of the day, however, our primary goal is always, and I repeat always, to make sure the policy is right, that the policy is strong, and that it accomplishes our goals. Current law on possession, particularly on handguns, is fairly strong. It's not perfect, and we know that. However, we want to make sure that any changes we make to possession do not have unintended consequences. The goal of this bill is to prevent firearm ownership for people under the age of 21. This is the core piece of the bill, and it is the most effective part of the bill. Access to firearms for those in high school is far too easy. Right now, any 18-year-old can purchase a long gun. With this in mind, we are offering an amendment that will remove possession from the bill. This decision was not made quickly or lightly, nor without input from stakeholders, our Senate sponsors, and our colleagues across the legislature. And we all agree that this is the right policy at the right time. We will continue to work on common sense solutions in the future. And colleagues, I ask for your yes vote on this amendment. Thank you.
Thank you. Further discussion on L54, Rep. Basenecker.
Thank you, Mr. Chair. And members, I'll keep this brief. I rise in support of this amendment. As the bill is currently written, I have concerns, quite frankly, with how the exemptions in the bill interact with current law. I've previously shared this with the bill sponsors, and I thank them for their work on this policy. I think we need more time to work on this important part of law to ensure that the best policy outcome can come forward. I've also spoken with the bill sponsors, and I know that there will be good faith efforts in tandem with the gun violence prevention community and other stakeholders to take a hard look at how this area of law, at the areas of law that concern the possession of firearms. I look forward to seeing these conversations take place, and I can tell you that I will do whatever it takes to support that process. In the meantime, I have to say I am extremely comfortable that our current laws on the possession of firearms, in combination with the increasing of the age to purchase a firearm, are sound policy which will keep Colorado and our communities safer. Narrowing the focus of this bill to solely focus on the purchase of firearms is meaningful policy that I believe will indeed save lives. The data is clear. Increasing the purchase age of all firearms to 21 years or older keeps our children, our communities safer. Suicides will be prevented. Acts of violence will be prevented. This is good policy as amended, and I'm proud to be a yes vote on it. For those reasons, I ask for an aye vote on this amendment.
Representative Froelich, 2L54.
Thank you, Mr. Chair. Members, I too rise in support of this amendment. As a longtime gun violence prevention supporter, I know how critical it is to raise the age for the purchase of a firearm. This amendment focuses the policy on the most crucial element and leaves room for discussion at a later time to address our laws on possession for young people. That discussion, whenever it happens, this year or next, needs to ensure that we don't have any unintended consequences. That's why I'm supporting this amendment. This bill saves lives. It will reduce suicides, reduce violence, and make our communities safer. I ask you for an aye vote on this amendment.
Is there further discussion on L54? Representative Amadale.
Thank you, Mr. Chair. I also support this amendment. I guess I come at it from, we want to try to stop people who are too young to have ill-formed brains from purchasing firearms, especially going out in the heat of the moment, buying a gun, and then doing something that they may regret forever. And, but I also have some hesitation about creating a gray area where we create potential criminal penalties for somebody who is in possession of a firearm that they legally purchased. And so to the extent that the cow already left and now we're trying to close the barn door, I think this is a good amendment. Thank you.
Is there further discussion on L54? Representative Brown.
Thank you, Mr. Chair. I rise today in support of this amendment. Being able to purchase a firearm is a significant risk factor for suicide. Our suicide rates among 18 to 20-year-olds in particular have skyrocketed in recent years. This amendment focuses the policy on the most important part of this discussion, which is access to firearms for people in a particularly sensitive and challenging time in their life that are particularly prone to mental health crises and potentially higher rates of disproportionately higher rates of violence. So I support this amendment because it focuses on the purchase of the firearm, and I look forward to the discussion about possession at another time. Thank you.
Is there further discussion on Amendment L54? Representative Epps.
So I absolutely oppose this amendment. I presume I would. I confess I'm not able to read quite as quickly as my colleagues, and I'm really impressed at how well prepared we had the talking points down. Sometimes I feel like there might be meetings I've been missing. This is a really important issue, the one of possession. It is something that for a bill that has been stakeholdered and worked on for as many months as this is, should not be rushed through in a weekend, should not be done without the opportunity to have meaningful conversations with the folks best positioned to make these decisions. We have colleagues in the Senate who could have considered this. I had the opportunity to serve on State Affairs, where when looking at this amendment and what I can initially see of it, it would have been a really good opportunity in the hours of our hearing to have a chance to discuss it. When we say that it's better, I think the phrase that I heard repeated several times was that addressing the elements of possession are better served for another day. There's an element of that I very much agree with, which leads me to oppose this amendment. If it's important enough to get right at a later time, it's important enough to not thrust upon us in a moment like this. It cannot be the case in good faith that it became an issue just this weekend. It can't be the case that for a bill that was worked on for this long, that now after, is it 54? After weeks in which we've had hundreds, maybe thousands of students and moms and children in our hallways asking us for the bills that we were allowed to run, to carve out something like this without doing the service of an appropriate hearing, not just the service to each other as colleagues, but to community. I'm not going to say the baby boy's name, but his spirit is all in this amendment, who is now dead and who would have been someone who should not have possessed the alleged weapon, the East High School student. Passing this amendment is doubling down on misappropriating the lived experiences of folks who are disproportionately harmed by gun violence, raising their names when it's convenient for us in terms of rhetorical devices, but not turning to them in moments of making critical decisions like this. This is a fundamental change to one of the only 4 or 5 bills we were allowed to run on this topic. It is not an appropriate thing to rush through at the last minute. It is as uncomfortable as anything we do here, to say no to your friends, to say no to people we like, to say no to people who are working for the world we want. But this amendment that we say is asked for by advocates, it's worth examining which advocates are asking for this, when issues of equity become important to them and when they aren't, when issues of enforcement become important and when they aren't. When something doesn't make sense, it's not true. And it doesn't make sense that this weekend is the moment that we would rush this through without giving it the attention it deserves. I'll vote no by myself.
Is there further discussion on L54? Seeing none, the question is the adoption of Amendment L54. All those in favor, please say aye. Aye. All those opposed say no. The ayes have it. L54 is passed. We're back to the bill. Representative Hamrick.
Thank you, Mr. Speaker. I would like to move Amendment L053 and have it displayed.
Okay, 1 second while we get it up on the screen.
Do I hand these out? Like I used to? Okay, you keep a copy. Okay. I can give to these guys. No, you give them to Robin. Oh, okay.
All right, 1 second. The amendment is displayed. Please go ahead.
Thank you, Mr. Speaker. Sorry, Mr. Chair. This amends the title to narrow it and clarify the underlying purpose of the bill in light of the amendments we just ran. I ask for an aye vote.
Thank you. Is there further discussion on L53? Seeing none, the question is the adoption of Amendment L53. All those in favor, please say aye.
Aye.
Any opposed, say no. The ayes have it. 53 is adopted. Back to the bill, Representative Hamrick.
Thank you, Mr. Chair. I move L057 and have it displayed.
All right, properly moved. 1 second. All right, L57 is now displayed. Please go ahead.
This clarifies that purchasing a firearm when under the age of 21 is a Class 2 misdemeanor. That was our intent all along, and it is critical for the integrity of the policy. I ask for an aye vote.
Thank you. Is there further discussion on L57? Representative Soper.
Oh, sure.
Thank you, Mr. Chair. I just had a technical question, just because this was moving quite quickly. So the Class 2 misdemeanor would be a penalty assessed against the person making the transfer, the sale, correct?
Representative Hamrick?
Yeah, it's the seller and transferee. Is who the penalty would be assessed against. It would be the seller or the transferee who the penalty is assessed against.
Actually, let me check on that one. Is it the seller or the
Can I get back? Is that fine?
Majority Leader Duran.
You have the next one?
Yep.
No, we're ready.
Rep Hamrick.
I move L038 and have it displayed.
All right, so the question pending is L57. Was there further discussion on L57? All right, seeing none, the question is the adoption of L57. All those in favor, please say aye. Aye.
Aye.
Any opposed, say no. The ayes have it. 57 is adopted. All right, now Rep. Hamrick.
Thanks, Mr. Speaker. I move L038 and have it displayed.
Okay, 1 second while it's being displayed.
Where's L038? Oh. Did we give it to him already? Oh, sorry.
Okay, now it's displayed. Please go ahead to L38. Rep. Hamrick.
Thank you, Mr. Chair. This is a technical amendment that clarifies the exemptions for purchases that apply to both the purchaser and the seller. Without this, we would have an unintended consequence where someone who is exempted from the age limit would be unable to purchase the firearm. I ask for an aye vote.
Thank you. Is there further discussion to L38? Seeing none, the question is the adoption of Amendment L38. All those in favor, please say aye.
Aye.
Any opposed, say no. The ayes have it. 38 is adopted. Back to the bill. Madam Majority Leader.
Thank you, Mr. Chair. Many of you have heard my personal story, but for those of you who haven't, I'm going to share it with you right now. So my journey to hell and back began when I was 19 years old. Not long after I married my high school sweetheart, he began drinking, became verbally and emotionally abusive, and over time became physically abusive. This once young, vibrant woman who was full of life began to live in fear, shame, and isolation. This went on for several years. It was a cold, rainy night when the sound of his yelling voice just made me shake uncontrollably. I knew what was coming next. Out of the corner of my eye, I could see him pulling out a gun like he often did to scare and intimidate me. All I could think of was my little boy who was crying in the next room, as this man threatened to end both our lives. How was I going to keep him safe? How could I protect him against a gun? At that moment, my life flashed in front of me. All the beatings that caused blackouts, all the verbal, emotional abuse that left me empty, finally gave me the strength to break my silence. I told my family, my friends, anyone that would listen, and my son and I made our escape. I was lucky, my son was lucky, but there are many people in Colorado who aren't as lucky to escape a terrible situation alive. My story, though harrowing, is not unique. I will always be a survivor of domestic violence and everything that comes with it. Gun intimidation, I know how critical it is to do everything we can to ensure that nobody else gets caught in the same life-threatening situation that I was in. No parent should receive a phone call from their child in the middle of the night, scared for their life. No parent should have to bear crippling grief when they receive a call that their child took their own life using a gun. Me and my abuser were just 19 years old when the violence began. This bill is a big step toward addressing the startling numbers of gun violence among children and 18 to 20-year-olds. Though it's not easy to tell my story, it's important to share. I made it here to help protect and stand up for survivors like me. 18 to 20-year-olds commit gun homicide at triple the rate of adults 21 and older. As a responsible gun owner myself, I know how critical increasing the legal age is to own a long gun to 21. This bill is about saving lives of young people and children, just like me, who are searching for their way out of hell, just like me. This legislation works to save those lives, as many lives as we can. I ask for your yes vote on Senate Bill 169. Thank you.
Thank you. Representative Hamrick.
Thank you, Mr. Chair. I'm the wife of an Air Force veteran, a mother, an aunt, and a grandmother. I'm also a high school history and government teacher who has served Colorado students and families for over 32 years. Teaching is a calling, and I've been focused on ensuring that my beloved students are supported, challenged, and loved. I have taught thousands of students over the decades, and they occupy a myriad of professions, including small business owners, police officers, artists, writers, architects, nurses, doctors, professors, teachers, active military personnel, carpenters, pipe fitters, salespersons, servers, farmers, engineers, ranchers, builders, restaurant owners, actors, lawyers, firefighters, bankers, judges. You get the picture. And even a Colorado State representative. I refer to the thousands of students that came through my classroom and into my life as my kids, because I'm always there for them. I was teaching when the Columbine shooting happened. My students were terrified that they could be next. Scores of parents swooped in to collect their students. Those students who remained clustered around me, and I tried to put on a brave face and support them. That was the beginning. Since that time, Colorado schools have engaged in lockdown drills in preparation for an active shooter, and each time the trauma on the students, teachers, family, and staff builds up. Since the Columbine tragedy, the median age of a school shooter is 16. In my school, the lockdown drill involves locking your classroom door, covering your windows, getting your 32 students to huddle as far from the door and windows as they can and remain silent, sometimes for hours. My school would have lockdown events, not just drills. So when a lockdown happens, it comes over the intercom, we're on lockdown, and you cover the windows on your classroom door. I had huge picture windows in my classroom, so we have to pull the blinds. And I would tell the kids to move, like I said, in an area in the classroom. And then I would start, and I'd lock the door. And then I would start looking for ways to protect my students. Books, moving a chest of drawers over. We teachers will instinctively stand in front of a shooter for our students. And you know that. But then you do the horrific calculus. You're a mother, you're a grandmother, you're a sister, you're a wife. Trauma upon trauma. This is no way to live. Speaking with elementary students who came to speak with us last week about the rise of gun violence and the impact on them, one group of elementary students spoke about their school's lockdown drill protocol of being moved into a closet and not ever knowing if it's an actual shooter drill or an active shooter event. And this happens every month. The generation of students in school now are called lockdown generation because they have been doing lockdown since they were in preschool, with elementary students often choosing shoes that don't light up or make a noise because a shooter could find them. Elementary students being afraid to walk outside in their neighborhoods. High school students fearing going to the mall or movies or parks or sporting events or a friend's house. The students, teachers, and parents who filled these halls for multiple days last week came here begging for action. Schools should be a place of safety, support, learning, and growth. Our students deserve to feel and be safe. 2022 was the deadliest year for school shootings in our country, with tens of thousands of children directly impacted, along with their families and communities, their sense of safety torn apart, trauma building upon trauma. Colorado has no law and statute that limits the age of purchase for a firearm. We rely on federal law. To purchase a firearm in Colorado, you need to pass a federal background check. You must be 21 or over for a handgun and 18 and over for a long gun. This chart shows age of purchase laws in other states, and Colorado is blank. California, Delaware, Florida, Hawaii, Illinois, New York, Rhode Island, Vermont, Virginia, all have age of purchase laws for all firearms for 21. This amended bill offers a clean, tight, enforceable law that will prohibit those under 21 from purchasing a firearm. Following the murder of 14 students and 3 teachers at Marjorie Stoneman Douglas High School in Parkland by a teenager who had legally purchased the weapons used, Florida passed a law that prohibited those under 21 from purchasing a firearm, a law which was recently upheld by the U.S. Court of Appeals, 11th Circuit, unanimously. The median age of a shooter in America is 16. Columbine, Parkland, Uvalde are school shootings where the perpetrators were teenagers who legally purchased the weapons used in the shooting. Columbine, we lost 14 students, including the perpetrators, aged 15 to 18, and 1 teacher aged 47. Marjorie Stoneman Douglas High School in Parkland, we lost 14 students aged 14 to 17 and 3 teachers aged 35 to 49. Robb Elementary School in Uvalde, 19 students and 2 teachers. Again, all 3 shootings involved teenagers who legally purchased the weapons used. Indeed, in April 2018, an 18-year-old female from Florida traveled to Colorado, legally purchased a firearm, and threatened to shoot up Colorado schools. Over 1,000 schools in our state closed that day, including the schools in my district. This amended bill will create a clean, tight, enforceable law that will prohibit those under 21 from purchasing a firearm. Following the murders in Uvalde, Jefferson County students organized a vigil outside of this building following the Robb Elementary School shooting. They held pictures of those dear souls and lovingly spoke about each student and teacher. They spoke of Nevaeh, whose name is Heaven spelled backward, age 10. They spoke of Jacqueline, age 9, McKenna, age 10, Jose, age 10, Alina, age 9, Irma Garcia, a teacher, aged 48, Mary, age 10, Javier, age 10, JC, age 10, Tess, age 10, Miranda, aged 11, Eva, age 44, one of the teachers, Alethea, age 10, Annabelle, age 10, Mate, age 10, Lexi, age 10, Layla, aged 11, Jayla, age 10, Elena, age 10, Rogelio, age 10. Once finished, the students quietly slipped the pictures of the 19 students and 2 teachers who were murdered under the door right below us on the west steps of this building. They lit 21 candles and had a moment of silence. Afterwards, they expressed frustration that society seemed to have become numb to these tragic events. The recent tragic shootings in and around East High School drew multitudes to the People's House, students, teachers, parents wanting action. Tragically, as mentioned, firearms are the leading cause of death among our children and teens in Colorado. Firearm suicide of our youth beginning at the age of 10 has increased 121%. Let me repeat that. Firearm suicide of our youth beginning at the age of 10 has increased 121% in Colorado between 2011 and 2020. And 18 to 20-year-olds commit gun homicides at triple the rate of adults 21 years and older. I know firsthand how essential this policy is to address our gun violence issue and keep Coloradans safe. Developing brains are not fully ready to evaluate risks, regulate emotion, or implement self-control, leading to young people being disproportionately engaged in violent acts involving firearms. By increasing the purchasing age, we can keep more people alive and reduce younger Coloradans' access to deadly weapons. Echoing the Jefferson County students, the 1,000-strong East High students who marched to the Capitol on March 3rd, the metro area students who rallied at the Capitol on Thursday, and the teachers, students, and parents who filled this building on Friday demanding action. We must end the silence. We must act now and stop gun violence. Please support Senate Bill 23-169.
Thank you. Is there further discussion? Representative Soper.
Thank you, Mr. Chair. I move Amendment L064 and ask that it be properly displayed.
Okay, 1 second while we get it on the screen. All right, the amendment is in focus. Please go ahead.
Thank you, Mr. Chair. So with the passage of Amendment L054, there is no need for a severability clause, as all that is left is the sale and transfer to a 21-year-old and under of the prohibition, I can't read my own handwriting, the prohibition on the sale or transfer to someone under the age of 21-year-old. The state Supreme Court has already held up this for pistols, and the Supreme Court is likely to also hold it up for long rifles, so there's no need to have a severability clause here.
Is there further discussion? Madam Majority Leader.
Thank you, Mr. Chair. And was mentioned by my colleague, there is no longer any need for that, so I would ask you to support the amendment. Thank you.
All right, is there further discussion to the amendment, L64? Seeing none, the question is the adoption of L64 to Senate Bill 169. All those in favor, please say aye. Aye. Any opposed, say no. The ayes have it, and 64 is adopted. All right, we're back to the bill. Representative Bockenfeld.
Thank you, Mr. Chair. It's an honor to serve with you.
An honor to serve here with you, sir. Please go ahead.
Thank you, Mr. Chair. I ask that the bill be read at length and also the fiscal note to be read at length.
All right, hold on, Rep. Bockenfeld. Just because we're being tight about motions, I think we'd like you to move that the bill be read at length, and then we'll do that. The rules do not provide for the reading of fiscal notes, but we will read the bill. Please make the motion.
Thank you very much, Mr. Chair. I move that the bill be read at length.
Members, what's going to be read is the full re-engrossed. That's the question right now, so that's what the software is going to read. Okay, Rep. Bockenfeld, we've heard the motion. That's a proper motion. We'll ask nonpartisan staff to please have the bill read.
Mr. Chairman, can I also ask that the fiscal note be read at length?
Rep. Bockenfeld, there is no provision for the reading of fiscal notes. However, once the bill is read, we can call on you to discuss the fiscal aspects of the bill.
Thank you, Mr. Chair.
All right, let's please commence with the reading of the bill.
First Regular Session 74th General Assembly State of Colorado re-engrossed. This version includes all amendments adopted in the House of Introduction LLSNO 23 to 811.0 to Jane Ritter X 4342 Senate Bill 23 to 169. Senate Committees House Committees State, Veterans, and Military Affairs. A bill for an act. 101 concerning increasing the legal age for certain conduct. 102 related to a firearm and in connection therewith. 103 increasing the legal age to purchase, possess, sell, or 10 for transfer a firearm. Bill summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. Current law allows a person who is 18 years of age or older to knowingly possess or purchase a firearm. The bill increases that age requirement to a person who is 21 years of age or older and adds: Senate third reading unamended March 13, 2023. Senate amended second reading March 10, 2023. Senate sponsorship Mullica and Danielson, Bridges, Coleman, Cutter, Exum, Fenberg, Fields, Gonzalez, Hansen, Jaquez Lewis, Coker, Moreno, Rodriguez, Sullivan. House sponsorship Duran and Hamrick, Kip. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing law. Dashes through the words or numbers indicate deletions from existing law. Intentionally to the mens rea required for a person under 21 years of age to commit the offense of possessing or purchasing a firearm. The bill lists exceptions to the offense. Under current law, it is a class for felony to intentionally, knowingly, or recklessly provide, or allow to possess, a firearm, with or without remuneration, to any person under the age of 18, juvenile. The bill makes it a Class 2 misdemeanor to intentionally, or knowingly sell or transfer a firearm to a juvenile. The bill makes conforming amendments. 1. Be it enacted by the General Assembly of the State of Colorado, 2 Section 1. In Colorado Revised Statutes, 18-12-101, add 3(1) B.7, and 1 C.5 as follows, for 18-12-101. Peace Officer Affirmative Defense definitions. 5(1) as used in this Article 12, unless the context otherwise requires. 6 B.7 firearm means any weapon, including a starter gun. 7 that can, is designed TO, or may readily be converted TO expel A8 projectile by the action of an explosive, the frame or receiver of 9A firearm, or a firearm silencer. Firearm does not include an 10 antique firearm, AS defined IN 18 U.S.C. SEC 921A16. In the case 11 of a license collector, firearm means only curios and relics. 12 firearm includes a weapons parts kit that is designed to or may 13th readily be completed, assembled, restored, or otherwise 14 converted to expel a projectile by the action of an explosive. 15 firearm does not include a weapon, including a weapons parts. 16 kit, in which the frame or receiver of the firearm, as defined in 17 subsection 1 C.5 of this section, or the weapon, is destroyed. 18 C.5, frame or receiver of a firearm, means a part of A19 firearm that, when the complete firearm is assembled, is visible 20 from the exterior and provides housing or a structure designed. -2, 169. 1 to hold or integrate one or more fire control components, even 2 if pins or other attachments are required to connect the Fire 3 control components. Any part of a firearm imprinted with A4 serial number is presumed to be a frame or receiver of a firearm. 5 unless the Federal Bureau of Alcohol, Tobacco, Firearms, and 6 explosives makes an official determination otherwise, or there 7 is other reliable evidence to the contrary. 8 Section 2. In Colorado Revised Statutes, amend 18-12-108.59 as follows. 10-18-12-108.5. Possession of firearms by persons less than 21 years of age, prohibited, exceptions, penalty. 12(1)(a), except as provided in this section, it is unlawful for any person 13, who has not attained the age of 18 years is less than 14 years of age to knowingly to have any handgun firearm in such 15 persons' possession. 16(b), any person possessing any handgun firearm in violation of 17 paragraph A of this subsection 1 subsection 1A of this section. 18 commits the offense of illegal possession of a handgun firearm by a 19 juvenile person less than 21 years of age. 20(c) illegal possession of a handgun by a juvenile firearm by 21 a person less than 21 years of age is a Class 222 misdemeanor. 23(2) for any second or subsequent offense, illegal possession of a .24 handgun by a juvenile firearm by a person less than 25 years of age is a Class 5 felony. 26(d) a person under the age of less than 18 years of age 27 who is taken into custody by a law enforcement officer for an offense. -3, 169. 1 pursuant to this section must be taken into temporary custody in the 2 manner described in section 19-2.5-305. 3(2) this section does not apply to 4(a) any a person under the age of 18 who is less than 21 years of age who is temporarily possessing a firearm. 6 for the purpose of 7(i) in attendance at attending a hunter safety education 8 course or a firearm safety course, or 9(2) engaging in practice in the use of a firearm or target shooting 10 at an established range authorized by the governing body of the 11 jurisdiction in which such range is located or any other area where the 12 discharge of a firearm is not prohibited, or 13(3) engaging in an organized competition involving the use of 14 a firearm, or participating in or practicing for a performance by an 15 organized group under 501(c)(3), as determined by the Federal Internal 16 Revenue Service, which that uses firearms as a part of such the 17 performance, or 18(4) hunting or trapping pursuant to a valid license issued to such. 19 the person pursuant to Article 4 of Title 33, CRS, or 20(4.1), hunting, trapping, taking, or killing wildlife 21 pursuant TO 33-6-1079, or 22(4.3), participating in a bona fide shooting class, training, 23 or sanctioned event, under the supervision of a certified Peace 24 officer, or a person who is 25 years of age or older and 25 who is a certified hunter education instructor or firearms 26 training instructor, or 27(4.5), hunting with a valid hunting license and -4, 169. 1 accompanied by a mentor, as defined by the Parks and Wildlife 2 Commission, who has a verified hunter education card, as3 required by Article 4 of Title 33, or rules promulgated by the for Parks and Wildlife Commission, or 5(4.6), participating in an accredited gunsmithing course 6 in a state-authorized institution of higher education, or in 7 institution regulated by the Private Occupational School 8 Division, or 9(v), traveling with any handgun firearm in such the person's 10. Possession being unloaded to or from any activity described in 11 subparagraph I2, 3, or 4 of this paragraph, A, subsection 12, 2, A, I2, A2, 2, A3, 2, A4, 2, A4.1, 2, A4.3, 13, 2, A4.5, or 2, A4.6 of this section, or 14(b). Any a person under the age of 18, who is less than 21 years of age, who is on real property under the control of 16, such the person's parent, legal guardian, or grandparent, and who has the 17 permission of such the person's parent or legal guardian to possess a 18 handgun the firearm, or 19(c) any person under the age of 18 years who is at such 20 persons' residence and who, with the permission of such the person's 21 parent or legal guardian, a person who possesses a handgun firearm 22 for the purpose of exercising the rights contained in section 18-1-704 or 23 section 18-1-704.5 or for the defense of livestock, or 24(d) a person who is less than 21 years of age who 25 has been issued a hunter education card by the Parks and 26 Wildlife Commission as required by Title 33 or rules promulgated 27 by the Parks and Wildlife Commission, or -5, 169. 1E, a person who is an active member of the United States 2 Armed Forces while on duty and serving in conformance with the 3 policies of the United States Armed Forces, or 4F, a person who is a peace officer as described in Section 516-2.5-101, while on duty and serving in conformance with the 6 policies of the employing agency, as set forth in Section 716-2.5-101 and Section 16-2.5-135, or 8G, an individual certified by the POST Board pursuant 9 to Section 16-2.5-102, or 10H, a person who was at least 18 years of age when 11 Senate Bill 23-169 was enacted in 2023. 12.3. For the purposes of subsection 2 of this section, a handgun 13 firearm is loaded if 14a. There is a cartridge in the chamber of the handgun firearm, 15 or 16b. There is a cartridge in the cylinder of the handgun firearm, 17 if the handgun firearm is a revolver, or 18c. The handgun firearm and the ammunition for such handgun. 19. The firearm is carried on the person of a person under the age of 2018 less than 21 years of age, or is in such close 21 proximity to such person that such person could readily gain access to the 22 handgun firearm and the ammunition and load the handgun firearm. 23.4. Repealed. 24. Section 3. In Colorado Revised Statutes, amend 18-12-108.725 as follows. 26. 18-12-108.7. Unlawfully providing or permitting a juvenile to 27 possess a firearm penalty. 1a. Any a person who intentionally. 6. 169. 1. Knowingly or recklessly provides a handgun firearm, with or without 2 remuneration, to any person under the age of less than 18 years 3 of age in violation of Section 18-12-108.5, or any person who knows of for such juvenile's conduct which that violates Section 18-12-108.5 and fails 5 to make reasonable efforts to prevent such violation, commits the crime 6 of unlawfully providing a handgun to a juvenile, or permitting a juvenile 7 to possess a handgun firearm. 8b. Unlawfully providing a handgun a firearm to a juvenile, or 9. Permitting a juvenile to possess a handgun firearm in violation of this 10 subsection 1 is a class for felony. 11.2. Any a person who intentionally, knowingly, or recklessly 12 provides a handgun to a juvenile a firearm to a juvenile, or permits a 13 juvenile to possess a handgun firearm, even though such the person is 14 aware of a substantial risk that such the juvenile will use a handgun. The 15. Firearm to commit a felony offense, or who, being aware of such 16. Substantial risk, fails to make reasonable efforts to prevent the 17. Commission of the offense, commits the crime of unlawfully providing, or 18. Permitting a juvenile to possess a handgun firearm. A person shall be 19 deemed to have violated this paragraph, a. If such violates this 20 subsection 2, a. If the person provides a handgun to or permits the 21 possession of a handgun firearm by any a juvenile who has been 22 convicted of a crime of violence, as defined in Section 18-1.3-406, or any 23 a juvenile who has been adjudicated a juvenile delinquent for an offense 24 which that would constitute a crime of violence, as defined in Section 2518-1.3-406, if such the juvenile were an adult. 26b. Unlawfully providing a handgun to a juvenile a firearm, 227 a juvenile, or permitting a juvenile to possess a handgun firearm in 7. 169. 1 violation of this subsection 2 is a class for felony. 2.3. With regard to firearms other than handguns, no person shall 3 sell, rent, or transfer ownership or allow unsupervised possession of a firearm with or without remuneration to any juvenile without the consent 5 of the juvenile's parent or legal guardian. Unlawfully providing a firearm 6 other than a handgun to a juvenile in violation of this subsection 3 is a 7 Class 1 misdemeanor. 8.4. It shall not be an offense under pursuant to this section if 9. A person believes that a juvenile will physically harm the person if the 10 person attempts to disarm the juvenile or prevent the juvenile from 11 committing a violation of Section 18-12-108.5. 12. Section 4. In Colorado Revised Statutes 18-12-112, add 13, 2, E, 2F, and 2G as follows. 14. 18-12-112. Private firearms transfers, sale, and purchase. 15. Background check required. Penalty definitions. 2E. A person. 16. Who is not a licensed gun dealer shall not make or facilitate the 17. Sale of a firearm to a person who is less than 21 years 18 of age. 19. F. It is unlawful for a person who is less than 20 years of age to purchase a firearm. 21. G. Subsections 2E and 2F of this section do not apply. 22. If 23. The person is an active member of the United States 24 Armed Forces while on duty and serving in conformance with the 25 policies of the United States Armed Forces, or 26. 2. The person is a peace officer, as described in Section 2716-2.5-101, while on duty and serving in conformance with the 8. 169. 1 Policies of the employing agency, as set forth in Section 216-2.5-101 and Section 16-2.5-135, or 3, the person is certified by the POSD Board pursuant to Section 16-2.5-102. 5. Section 5. In Colorado Revised Statutes 18-12-112.5, amend 6.1 as follows: 7. 18-12-112.5. Firearms transfers by licensed dealers, sale, and 8. Purchase, background check required, penalty, definitions. 9. 1a. It is unlawful for a licensed gun dealer to transfer a firearm to a 10 transferee until the dealer has obtained approval for the firearms transfer. 11. From the Bureau, after the Bureau has completed any background check. 12. Required by state or federal law. 13. A.3. A person who is a licensed gun dealer shall not make 14 or facilitate the sale of a firearm to a person who is less than 21 years of age. 16. A.5. It is unlawful for a person who is less than 21 years of age to purchase a firearm. This subsection 18(1)(a.5) does not apply if 19. The person is an active member of the United States. 20. Armed forces while on duty and serving in conformance with the 21 policies of the United States Armed Forces, or 22. 2. The person is a peace officer, as described in Section 2316-2.5-101, while on duty and serving in conformance with the 24 policies of the employing agency, as set forth in Section 2516-2.5-101 and Section 16-2.5-135, or 26. 3. An individual certified by the POSD Board pursuant 27 to Section 16-2.5-102. 9. 169. 1b. Transferring or selling a firearm in violation of this 2 subsection 1 is a Class 1 misdemeanor. 3. Section 6. In Colorado Revised Statutes 18-12-108, amend 4.7 introductory portion and 7 WW as follows: 5. 18-12-108. Possession of weapons by previous offenders. 6. 7. In addition to a conviction for felony crime, as defined in Section 724-4.1-3021, a felony conviction or adjudication for one of the 8 following felonies prohibits a person from possessing, using, or carrying 9 upon his or her the person a firearm, as defined in Section 18-1-90110(3)(h), or any other weapon that is subject to this Article 12 pursuant to 11 subsection 1 or 3 of this section. 12 WW. Possession of a handgun by a juvenile firearm by persons 13 less than 21 years of age in violation of Section 14, 18-12-108.5, 15 Section 7. In Colorado Revised Statutes 19-1-304, amend 16, 5.5 as follows: 1719-1-304. Juvenile Delinquency Records, Division of Youth. 18 Services Critical Incident Information, definitions. 5.5 Whenever a 19 petition is filed in juvenile court alleging a Class 1, Class 2, Class 3, or 20 class for felony, a Level 1, Level 2, or Level 3 drug felony, and offense 21 involving unlawful sexual behavior as defined in Section 16-22-1029, 22 a crime of violence as described in Section 18-1.3-406, a burglary offense 23 as described in Part 2 of Article 4 of Title 18, felony menacing, in violation 24 of Section 18-3-206, harassment, in violation of Section 18-9-111, for 25-degree arson, in violation of Section 18-4-105, aggravated motor vehicle 26 theft, in violation of Section 18-4-409, hazing, in violation of Section 27-18-9-124, or possession of a handgun by a juvenile firearm by persons. 10, 169. 1 less than 21 years of age, in violation of Section 218-12-108.5, or when a petition is filed in juvenile court in which the 3 alleged victim of the crime is a student or staff person in the same school for as the juvenile, or in which it is alleged that the juvenile possessed a 5 deadly weapon during the commission of the alleged crime, the 6 prosecuting attorney, within 3 working days after the petition is filed, 7 shall make good faith reasonable efforts to notify the principal of the 8 school in which the juvenile is enrolled and shall provide such the 9 principal with the arrest and criminal records information, as defined in 10 Section 24-72-3021. In the event the prosecuting attorney, in good 11 faith, is not able to either identify the school that the juvenile attends or 12 contact the principal of the juvenile school, then the prosecuting 13 attorney shall contact the superintendent of the juvenile school district. 14 Section 8. In Colorado Revised Statutes 19-2.5-305, amend 15, 3, A.V., introductory portion, and 3, A.V.C., as follows: 1619-2.5-305. Detention and shelter, hearing, time limits, 17 findings, review, confinement with adult offenders, restrictions. 18(3)(a)(v), a court shall not order further detention for a juvenile who 19 is 10 years of age and older but less than 13 years of age unless the 20 juvenile has been arrested or adjudicated for a felony or weapons charge 21 pursuant to Section 18-12-102, 18-12-105, 18-12-106, or 18-12-108.5, or 22 18-12-108.7. The court shall receive any information having probative 23 value regardless of its admissibility under the rules of evidence. In 24 determining whether a juvenile requires detention, the court shall 25 consider the results of the detention screening instrument. There is a 26 rebuttable presumption that a juvenile poses a substantial risk of serious 27 harm to others if 11-169. 1e(c), the juvenile is alleged to have committed possessing a too dangerous or illegal weapon, as described in Section 18-12-102, 3 possession of a defaced firearm, as described in Section 18-12-103, 4 unlawfully carrying a concealed weapon, as described in Section 5 18-12-105, unlawfully carrying a concealed weapon on school, college, 6 or university grounds, as described in Section 18-12-105.5, prohibited use 7 of weapons, as described in Section 18-12-106, illegal discharge of a 8. Firearm, as described in Section 18-12-107.5, or illegal possession of a 9 handgun by a juvenile firearm by persons less than 21 10 years of age, as described in Section 18-12-108.5. 11 Section 9. In Colorado Revised Statutes, 19-2.5-502, amend 12-5, introductory portion as follows, 1319-2.5-502. Petition initiation, petition form, and content. 14(5)(a) pursuant to Section 19-1-126 in those delinquency proceedings. 15 to which the Federal Indian Child Welfare Act of 1978, 25 U.S.C. Section 1619-01 ETSEQ, as amended, applies, including, but not limited to Status 17 offenses such as the illegal possession or consumption of ethyl alcohol 18, or marijuana by an underage person, or illegal possession of marijuana 19 paraphernalia by an underage person, as described in Section 18-13-122, 20 in possession of handguns by juveniles, a firearm by persons less 21 than 21 years of age, as described in Section 18-12-108.5, 22 the petition must, 23 Section 10. In Colorado Revised Statutes, 19-2.5-1203, 24 amend 5, B 7, and 5, B 8 as follows, 25 19-2.5-1203. Juvenile parole, hearing panels, definition. 26, 5, B, subsection 5, A of this section allowing for extension of the 27 period of parole applies to juveniles committed to the Department of 12-169. 1 Human Services due to an adjudication for 1 or more of the following 2 offenses. 3, 7, felony illegal possession of a handgun by a juvenile for firearm by persons less than 21 years of age, as 5 described in Section 18-12-108.5, that would constitute a felony if 6 committed by an adult. 7, 8, misdemeanor illegal possession of a handgun by a juvenile. 8, firearm by persons less than 21 years of age, as 9 described in Section 18-12-108.5, that would constitute a misdemeanor. 10, if committed by an adult, if the juvenile person, who is less than 21 years of age, is contemporaneously committed to the 12 Department of Human Services for an offense that would constitute a 13 felony if committed by an adult, or 14 Section 11. In Colorado Revised Statutes, 24-33.5-424, 15 amend 3, B.3, 9, and 3, B.3, X, and repeal 3, B.3, 11 as follows, 1624-33.5-424. National Instant Criminal Background Check. 17 System, State Point of Contact, Fee, Grounds for Denial of Firearm. 18 Transfer, Appeal, Rulemaking, Unlawful Acts, Instant Criminal. 19 Background Check, Cash Fund, Creation. 3, B.3, in addition to the 20 grounds for denial specified in subsections 3A and 3B of this 21 section, the Bureau shall deny a transfer of a firearm if the prospective 22 transferee has been convicted of any of the following offenses committed 23 on or after June 19, 2021, if the offense is classified as a misdemeanor, 24 or if the prospective transferee has been convicted in another state or 25 jurisdiction, including a military or federal jurisdiction, of an offense that 26, if committed in Colorado, would constitute any of the following offenses. 27 classified as a misdemeanor offense within 5 years prior to the 13-169. 1 transfer, 2, 9, cruelty to animals, as described in Section 18-9-202-1A3 and 1.5, or 4X, possession of an illegal weapon, as described in Section 5 18-12-1024. Or 6, 11, unlawfully providing a firearm other than a handgun to a 7 juvenile, as described in Section 18-12-108.73. 8. Section 12. Severability. If any provision of this Act or the 9 application thereof to any person or circumstance is held invalid, such 10 invalidity does not affect other provisions or applications of the Act. That 11 can be given effect without the invalid provision or application, and to 12 this end the provisions of this Act are declared to be severable. 13. Section 13. Safety Clause. The General Assembly hereby finds, 14 determines, and declares that this Act is necessary for the immediate 15 preservation of the public peace, health, or safety. 14, 169.
All right, the reading of the bill has been completed. Is there further discussion on Senate Bill 169? Representative DeGraff. All right, as a reminder, members, we are to the bill. Representative DeGraff.
Back down when I'm done. Put it back down. While we're trying to regroup here, just like to thank you for the bill sponsors for making the bill actually what the bill is about. I am overall, I'm very pleased with the changes. I do have concerns. It's going to take a little bit to regroup just from the Second Amendment side. I do think the concerns that we're raising that have been raised are legitimate. But it is it seems to me legitimately to be what the bill title is, and so I'm very happy. I'm very happy with that. So I would like to still. My concern is that we're still dealing with an issue outside of the framework that we're allotted, and that is still a concern to me. So so I'm going to have to think about this a lot. But I very much appreciate the effort and the incredible amount of change that was made. So, because I would like, just in general, the voters to be able to have access, because we are talking about modifying a right, our Second Amendment right. I would like to move L065 to SB 169 and ask that it be displayed. And this is just a simple petition, substitution, and that's it. There's nothing else there. I would just like to make sure that in this case, just like in every other case, we give our voters, we give our constituents, we give the citizens of Colorado the opportunity to disagree with us. I do understand the nature of putting a safety clause in there, but we are talking about something long-standing, and we are talking about something that is in terms of our constitutional rights. So I would like to move to change this to a petition clause and ask for an aye vote. Thank you.
All right, thank you. The amendment's displayed. We kind of veered right in, but that's okay. Representative to the amendment, Representative Hamrick.
Thank you to our colleague from Colorado Springs for bringing the amendment, and we urge an aye vote.
Okay, the question is the adoption of L65. Is there further discussion on L65? Seeing none, the question is the adoption of L65. All those in favor, please say aye. Any opposed, say no. The ayes have it, and 65 is adopted. Is there further discussion? We're back to the bill, Senate Bill 169. Is there further discussion? Seeing none, the question is the adoption of Senate Bill 169. All those in favor, please say aye. Aye. Any opposed, say no. The ayes have it. Senate Bill 169 is passed. Senate Bill 169 as amended is passed. Madam Majority Leader.
Mr. Chair, I move that we rise and report. The committee rise and report.
You've heard the motion. Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report it as under consideration the following attached bill, being the second reading thereof and making the following recommendations thereon. Senate Bill 169 as amended passed on second reading in order to revise and place on the calendar for third reading and final passage.
Representative Weissman. Members, the motion before us is that the House adopt the report of the Committee of the Whole. There are no amendments at the desk. Mr. Shebel, please open the machine and members proceed to vote. Representative Ortiz, how do you vote?
Yes.
Representative Ortiz votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative Doherty, how do you vote?
Yes.
Representative Doherty votes yes. Please close the machine. With 43 aye, 20 no, and 2 excused, the report is adopted. Yeah, announcements or introductions? Madam Majority Leader.
Thank you, Madam Speaker. If I could remind you members to please remove any drinks or food that you have at your desks so that our nonpartisan staff doesn't have to stay late to clean it up. And then I also think we need to thank our sergeants, our nonpartisan staff for all their hard work this weekend.
Madam Majority Leader.
Thank you, Madam Speaker. One more thing. If you have files on your file cabinet, it'd be nice if you could put those away. Thank you.
Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over the balance of the calendar until tomorrow.
Seeing no objection, the balance of the calendar will be laid over until tomorrow. Madam Majority Leader, I have a little bit of business to take care of. Members, you are free to leave. We will be adjourning until Monday at 10 a.m. Gosh, that's tomorrow. Madam Majority Leader has one more announcement.
Thank you, Madam Speaker. If I can remind you to clean the refrigerator in the back if you've got food stored there, anything. We don't want to leave it over the weekend to get, nasty. Thank you.
Glad we're doing it. Mr. Shebel, reports of committees of reference.
Committee on Health and Insurance, after consideration on the merits, the committee recommends following. House Bill 1215 be amended as followed and as so amended be referred to the Committee on Appropriations with favorable recommendation.
Printing report.
The Chief Clerk
The
reports
printing report
following.
will be printed in the journal. Signing of bills, resolutions, memorials.
The Speaker has signed
Signing of
Senate
bills,
Bill.
resolutions, memorials will be printed in the journal. Introduction of bills.
House Bill 1256 by Representatives Michelson, Janae, and English, also Senator Cutter, concerning the ability of a healthcare professional authorized to practice in Colorado to render care through telehealth and to individuals located in another state.
House Bill 1256 will be assigned to the Committee on Public and Behavioral Health and Human Services.
House Bill 1257 by Representatives Velasco and Basenecker, also Senator Cutter, concerning water quality in mobile home parks.
House Bill 1257 will be assigned to the Committee on Transportation, Housing, and Local Government.
House Bill 1258 by Representatives Charbini and Garcia, concerning creating a task force to study the costs associated with drug crimes.
House Bill 1258 will be assigned to the Committee on Judiciary.
House Bill 1259 by Representatives Doherty and Evans, concerning provisions in the open meetings law for an executive session of a local public body and in connection therewith, creating a local public body's right to cure a violation of the open meetings law for an executive session, adding prerequisites for a person to challenge a violation by a local public body of the opening meetings law for an executive session and permitting a local public body to recover costs and attorney fees in an action for a violation by a local public body of the executive session provisions and the prerequisites are not met, if the prerequisites are not met, or if the local public body has cured the violation.
House Bill 1259 will be assigned to the Committee on State, Civic, Military, and Veterans Affairs.
House Bill 1260 by Representatives Soper and Valdez, concerning tax incentives to maximize investments in semiconductor and advanced manufacturing in Colorado and in connection therewith, authorizing the Economic Development Commission to approve refund certificates for certain income tax credits, recreating a semiconductor manufacturing zone program, modifying the Colorado Job Growth Incentive Tax Credit for semiconductor and advanced manufacturing, and creating an advanced industries task force.
House Bill 1260 will be assigned to the Committee on Finance.
House Bill 1261 by Representatives McLaughlin and Martinez, concerning removing the requirement for a student to register for the United States Selective Service System to enroll in a state-supported institution of higher education.
House Bill 1261 will be assigned to the Committee on Education.
House Bill 1262 by Representative Ricks, also Senator Priola, concerning allowing a student to receive an associate degree from the Colorado Reengaged Initiative after earning a certain number of credit hours from a different institution.
House Bill 1262 will be assigned to the Committee on Education.
House Bill 1263 by Representatives Garcia and Young, also Senators Zenzinger and Gonzalez, concerning translating individualized education programs from children who may be eligible for special education services.
House Bill 1263 will be assigned to the Committee on Education.
Senate Bill 39 by Senator Buckner, also Representative Amabile, concerning measures to reduce family separation caused by parents' detention and in connection therewith making an appropriation.
Senate Bill 39 will be assigned to the Committee on Public and Behavioral Health and Human Services.
Senate Bill 53 by Senators Kirkmeyer and Rodriguez, also Representatives Woodrow and Evans, concerning restrictions on non-disclosure agreements that affect government employees.
Senate Bill 53 will be assigned to the Committee on State, Civic, Military, and Veterans Affairs.
Senate Bill 67 by Senator Coleman, also Representative Bacon, concerning a recidivism reduction program for persons sentenced to the Department of Corrections, facilitated by program participants in partnership with the Department of Corrections staff and in connection therewith making an appropriation.
Senate Bill 67 will be assigned to the Committee on Judiciary.
Senate Bill 72 by Senator Rodriguez, also Representatives Epps and Soper, concerning the continuation of the Defense Council on First Appearance Grant Program and in connection therewith, implementing the recommendations in the 2022 Sunset Report by the Department of Regulatory Agencies and making an appropriation.
Senate Bill 72 will be assigned to the Committee on Judiciary.
Senate Bill 149 by Senators Coleman and Exum, also Representative Bacon, concerning the creation of a program to provide higher education financial assistance to students who perform youth mentorship and in connection therewith making an appropriation.
Senate Bill 149 will be assigned to the Committee on Education.
Senate Bill 151 by Senator Fields, also Representatives Judah and Ortiz, concerning the continuation of the Health Equity Commission and in connection therewith implementing the recommendation contained in the 2022 Sunset Report by the Department of Regulatory Agencies.
Senate Bill 151 will be assigned to the Committee on Public and Behavioral Health and Human Services. Madam Majority Leader.
Thank you, Madam Speaker. I move that the House adjourn until 10 a.m. on Monday, March 25th. Madam Speaker, I move that the House adjourn until 10 a.m. on Monday, March 27th.
Thank you, Madam Majority Leader. This is why we need the cheat sheet. Seeing no objection, the House will stand in adjournment until 10 a.m. on Monday, March 27th.